Section 36 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3 by John D. Lawson. Trial of John Hanlon for the murder of Mary Mohrman, Philadelphia, Pennsylvania, 1870, Part 3. The court, after an adjournment at 1 o'clock, opened at 2:30 when the trial was proceeded with. As in the morning, the room was densely crowded with people, a very large portion being women. Long before the doors were thrown open, the crowd besieged the place, so that it was impossible for any one having business in the court to force their way through, and the officers were kept busily engaged in preserving order. The only means by which the reporters could gain admission was by climbing through one of the windows. Bridget Hanlon. Know the little cellar window. We kept chickens down the cellar. The chickens made too much dirt in the cellar, and we nailed the cellar window up. Mr. Hanlon, my husband, nailed it up. It was nailed up at the time of the occurrence and remained that way after we left. After we moved, I visited the house again. John and his wife lived there then. In the yard there were alterations and changes. They made a garden. John made it. He pulled the bricks up. The bricks were put in the cellar. John generally wore upon his feet about the barber shop boots and slippers. They were leather slippers. He had no other slippers at that time. He had cloth slippers with heavy soles, half heels. I never knew him to have plush slippers. Am 46 or 45, I don't know which. Cross-examined. Slept that night in the front room in the third story. There were a good many slept with me. Mrs. Quinn's children. There were so many I don't remember. Mrs. Steinmeier slept in the bed with me. Don't recollect where the children slept. Went to bed between 12 and 1. Got up in the neighborhood of 5. Did not get up from the time I went to bed until I got up at 5 in the morning. After I came out of the water closet, I went into the kitchen. I stayed in the kitchen. I did not stay there until I went to bed. Remained there a long time and then went down the alley. I then went to the kitchen and stayed there. Went down the back alley. I stayed in the back alley. I then went in Mrs. Mohrman's, wakened my little boy, and took him into my house. Went into the kitchen and went up to the third-story front room. Did not go to bed then. Put him to bed. Came down and fastened the back door. Looked out of the front third-story window. It was in the papers I first heard that my son was suspected. He was in prison at that time. It was after he was sent to prison when it was put in the papers. Up to that time had heard nothing about his being suspected. Did not take particular notice of his clothing any more than at any other time. He had no pants but the one pair. I was making him a pair. He had 5 shirts. He did not change his shirt on Monday, and went out in his shirt sleeves on Sunday. Could not say how many days he wore his shirts. John Hanlon was in the shop when I handed the lamp to his wife. Can't tell what we had for breakfast the Monday morning. I can tell who took breakfast. John went downtown this Monday. He bought things on Monday for the shop. Monday was his shopping day. Lizzie Steinmeier. Am John Hanlon's sister. Am married woman. In September 1868, I resided in 5th Street below Diamond with mother. Remember the evening Mary Mohrman was lost. An early part of evening was in the front second-story room. Remained there for some time. Stayed there until my sister Mary, Mrs. Kelly, called me. Went in the back room, and she had ice cream, and I sat and helped to eat it. John and his wife, mother and Mary, and little Johnny were in the back room. My brother John was sitting up in bed. Can't say how long I remained there. Went upstairs to the third story when I left the room. The front third-story room. My little girl was crying. I went to bed a short time afterwards. The little cellar door in the yard projected about 4 or 5 inches. The cellar window on 5th Street was a plain wire window. It was about 18 inches wide. It had a lap on the window with a catch to it inside, and you could not unhook it without going in the cellar. Saw John on Monday going into town about 9 o'clock. Next saw him Monday evening when I came home from the city about 5 or 6 o'clock. He was standing with his foot on Mrs. Mohrman's step. Mr. Strawhauer was reading the evening paper. There was a piece in the paper about the child being lost. Saw him Tuesday morning about 6 or 6:30 o'clock. Report came around that the child was found. My sister started up with another girl. Him and I was last. He a little ahead of me. We were running to see the child. I did not see the child, it had gone. Sometimes John would wear slippers. I can't say for sure what kind of slippers he wore at that time. I made him a present of a pair. Don't know whether they were the pair he used. Cross-examined. When John went to town on Monday morning, he had a straw hat on, light pants, dark coat. Did not take notice if he had a vest on. On Tuesday, think he had the same pants on. He was in his shirt sleeves. He had no hat on. Remember the Monday morning that Mary Mohrman was missed. Don't remember whether I was out in the yard that morning. Was out in the water closet early, before daylight. My sister-in-law was with me, John's wife. Could see in the privy at that time. There was no blood or trace of blood there at that time. Don't remember being in the cellar on Monday. Might have been there on Tuesday, for I often went after the victuals, sometimes 2 or 3 times a day. Don't remember seeing any blood or traces of blood there, or any blood on the stairs leading to it, or in the kitchen, or in the yard, or on any part of the little window, the sill, or any part of the wood belonging to it. Did not examine any part of it to see if there was any blood upon it. If it had been there, I would have seen it. Did not examine the stairs to see if there were any blood or traces of blood there. Did not examine the kitchen for that purpose, or the yard, or the little window, or the sill belonging to it. Never thought of blood being there, but if there had been blood, I would have seen it. November 9. Owen Hanlon. Am brother of the prisoner. Am going on 15. Remember 1868. Reside with my father and mother. Remember the Sunday that Mary Mohrman was missed. Was playing on the cellar door at the corner of Orkney and Diamond Streets that Sunday afternoon and evening. Louis Mohrman and John Strawhauer were playing with me. It was after dinner, before dark. Did not see John that day after he, John, closed the shop. He closed the shop between 1 and 2 o'clock on Sunday afternoon. That was the last I saw of him that I remember. Was helping him working. Lathered a man and combed the hair. He had on a light striped shirt, light pants with dark stripes down the legs. Next saw him the next morning at the breakfast table. Monday. He had on the same shirt and pants that he had on Sunday when I was working with him. Next saw him after breakfast in the shop. Don't remember having seen him Tuesday. Was in the yard on Monday afternoon. Was not in the water closet. Was in the cellar on Monday in the afternoon. There was no blood there that I saw. Went there to get a stick to go out in the woods to see if we could see anything of the man with Mary Mohrman. Louis Mohrman, John Strawhauer, and John Crees went with me. We all had sticks. We came back about 4 o'clock in the afternoon. A small pile of kindling wood was in one corner of the cellar, and a water trough in the other. Remember the cellar window. I can describe it. The cellar window was nailed down, the back one. It stuck out, and when we went to open the gate, it stopped the gate. The cellar window was used for chickens to go in. It had pieces of board on the side, and when the flap was raised up with a stick under it, the gate would not open. Then there was a board on the bottom. Then it went against the board. The stick was put under the bottom to let the chickens in first. It remained nailed down until we had left. Cross-examined. Saw Mrs. Kelly that Sunday evening at the corner of 5th and Diamond. Was then looking for Mary Mohrman. Was just going to ask Mother if I could go and look for Mary Mohrman when she was standing at the corner. My mother, Mrs. Kelly, her little boy, and Mrs. Mohrman were standing there. Mrs. Mohrman had been looking for her daughter before that. I had not been with Mrs. Mohrman before that. I did not see Mr. Fisher that night. John used to wear boots. Remember him having one pair of slippers, but I don't know whether it was that time or not. They were dark black cloth, worked on the top with zephyr. Don't remember any other. Was not with him when he purchased slippers. Mary Quinn. Left the house about 10 o'clock. Went directly home from Hanlon's. My house was at 2nd and Diamond Streets. The reason why I did not stay at Hanlon's that night was because I always lived at 2nd and Diamond, and I had to be there. Did not live at home. My mother lived at 2nd and Jefferson, I think. She kept house. I did not see John Hanlon that I remember. Cross-examined. Went home that night at 2nd and Diamond. Mrs. Patrick Kelly lived there. She was a relative of mine. She was my cousin and a sister of the prisoner. I lived there from the time I was small. I did not live at home. Mrs. Ann Quinn. Am a married woman. My husband carries the hod. I have 5 children. Mary, the girl that was last on the stand, was living with Pat Kelly. She is now living with my sister. Don't know how old she is. Don't know any of their ages to be perfect. Remember the Sunday on which this little child was missed. Was at home after dinner, and my husband was in liquor, and I could not stay in the house, so I took my little boy in my arms to take him to my sister's, and the rest of the children said they would not stay behind me, so we all went together to my sister's. My sister was Mrs. Hanlon, the mother of John. Don't know what time I reached my sister's. Can't say how long it was after dinner. When I got there, dinner was over. No one was there but my sister's husband lying on the settee in the kitchen. Stayed there for a long time with my baby on my knee, and it went to sleep, and I took it upstairs and laid it on the bed with Mrs. Steinmeier's baby, in the front room, the garret one. Came downstairs and stayed there until the lights were lit. Mr. Hanlon was in the back kitchen. He was here all the time. Saw John's mother. Saw John himself. He came in and his mother came in. His mother came first and he came after. His wife was with him. His wife asked his mother for a light, and his mother lightened the light and gave it to his wife. His wife went first and he went after her upstairs. Heard Mrs. Kelly's voice after a while. Stayed in the kitchen. No one was there but Mr. Hanlon. Could not tell how long I stayed there. Went upstairs after a good long while to see about my little boy. Went into John Hanlon's room, and he was lying in bed with his wife. Went in and took the lamp which burned on the mantelpiece. Went up into the garret then, and Mrs. Steinmeier's baby was there. Took the lamp down with me and left it on John Hanlon's mantelpiece, and he was in bed. Went to the back door, opened the door, and heard voices of the people talking at the bottom of the alley on the back street. I went there to get clothes to change the baby. Mrs. Hanlon was at the alley talking to the neighbors. Went upstairs and changed the baby and took the light off of John Hanlon's mantelpiece. After I changed the baby, I came down and left the lamp on the mantelpiece. Then went all around the cellar to look for some big pieces of wood. Took the lamp and left it on John Hanlon's mantelpiece again, and he was lying in his bed. Stayed in the back kitchen pretty much through the night. Mr. Hanlon was lying on the settee, and there was a lamp burning in the kitchen all night. Saw John the next morning. Could not tell the time. It was a good while on in the morning. It was after breakfast. I came through the day. After I left Hanlon's, I went to where I lived, to Front Street. Such a thing as blood could not be in the cellar, for I looked all around for some large pieces of wood. Cross-examined. Was looking for wood. I did not think of such a thing as blood. The kindling wood stood at a distance from the bottom of the stairs. Went all around it to look for large pieces. Saw John Hanlon on Sunday when he came in to go to bed. That was the first I saw of him. Was at Hanlon's at tea time on that Sunday. Went up to put my baby to sleep. Went upstairs when they were setting the table. I saw the family at the table when I came down. Did not see John Hanlon there. Think it was about 6 o'clock or somewhere there when they had tea. The lights were lit when I took the baby upstairs. Do not know where John's wife was when they were clearing away the table. Did not see John go out of the house that evening. He could have gone out of the kitchen while I was there without my seeing him. He could not have gone out after the lights were lit. He did not go out after he went to bed. There was a lamp burning in the kitchen when she lit the lamp. Don't know how long the lamp was lit that was burning in the kitchen. At the time I first went upstairs, I put Mrs. Steinmeier's baby in the crib. It was lying asleep. The time I first went up, my baby went asleep on my knee. When I went up the second time, was uneasy about my baby, and when I came down, the lamps were lit. I can't tell the time I first got to Hanlon's house. There was no one there but Mr. Hanlon and me when I first went in, and my children who were with me. Could not tell how long it was when I first took my baby upstairs. Took the lamp and put it on John Hanlon's mantelpiece. He was laying there still. Came down again and opened the kitchen door and heard them talking up the alley. Took a lamp up the second time. I got the lamp off John Hanlon's mantelpiece. He was laying in bed with his wife. Was not in John Hanlon's room before Mrs. Kelly came. Think I went into John Hanlon's room for the lamp 4 times and put it back again. Every time I took it, I went back again. Made the feed for Mrs. Steinmeier's baby. My baby slept all night. It was a big, healthy baby. Did not see Mrs. Steinmeier when I fed the baby. Don't know whether Mrs. Steinmeier was in bed or not. I know nothing about it. Stayed there until my sister came up. After I fed the baby, it struck 12 before I fed the baby a good while. I could not sleep that night because I was uneasy about my children, and my husband was drunk. Did not lie down except when I rocked the child. When I went into John Hanlon's room, I saw him. I could not go in without seeing him. The bed was right fornest the door. He was lying in bed. Could not tell when I first heard that John was suspected of this crime. He was 3 weeks arrested before I heard of it. Don't mind who first told it to me. Did not talk to any members of the Hanlon family what I could testify to here. All that I said was that I could testify to what I knew, and that what I knew I could say at any place. Elizabeth Steinmeier recalled. Mr. O'Neill, do you wish to correct a mistake you made in your testimony? Yes, sir. I made a mistake yesterday where I spoke about the slippers where they were made at. I could not say positively where they were made at. I thought they were made at Dalzell's. It was my sister he got them made, and I paid for them. I was sick at the time. Mr. Becker, second above Diamond, made them. Mr. O'Neill, when you found out your mistake, did you go to see Mr. Becker? Yes, sir. I went right away. Mr. O'Neill, you said your sister got them made. Is she here? What is her name? My sister Annie. She is married. Her name is Ann Kelly. I lived in New York before this trial commenced. My husband is there. He is a barber. He has been there about 5 weeks. I have lived in New York about 3 weeks. Justice Becker. Live 2104 North 2nd Street. I keep a shoe store. Know Mr. Kelly's wife. She lives 3 doors below me, but I don't know his first name. Think his first name is Pat, but don't know. Remember about 3 or 4 years ago, Mrs. Kelly came into my store with a pair of slipper uppers. She wanted me to put the bottoms on them. I did it. Can't remember whether it was cloth or knit. I think it was $2.50 or $2.75 that I charged. I put on white sole leather, white bottom stuff. They were double soles. Can't tell whether they were high heels or not. John Hanlon, Sr. Am about 55. Am the father of the prisoner. There are 7 children living. Am a laborer, all kinds of laboring. Remember the Sunday the little child was lost. Was then living on 5th Street below Diamond. My family was living there with me. John was living with me. Remember the afternoon of that day. I was in the house, in the back part, in the back kitchen, was lying on the settee. Don't remember whether I was lying on it in the afternoon, but I laid down after I got my dinner. I laid there all night, had a sprained knee. Had it about a week at that time. Do not remember seeing John, my son, that afternoon. Do not remember seeing him pass through the kitchen that night. No man passed through the kitchen that night. I do not remember seeing him the next morning. Spent the entire night on the settee and the next night. Don't remember seeing John on Tuesday. Was out in the yard on this Monday. Was in the water closet. There was no blood there that I seen. Saw none in the yard. Remember the cellar window on the back part of the house. There was a cover to it. It was closed at that time. The cellar at that time had nothing in it but some light kindling wood, a spade and a pitchfork, and some kind of watering trough, which was put in out of the stable. It was used for keeping ice in before I got it. There were no bricks there then. Moved away from there, I think, in the April after that happened. Left Johnny and his wife there. This thing at the cellar window was used for closing the window up. When we had the chickens in the cellar, it was open. When they were taken away, I nailed it down. End of section 36. Section 37 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3 by John D. Lawson. Trial of John Hanlon for the murder of Mary Mohrman, Philadelphia, Pennsylvania, 1870, Part 4. November 10. Henry Hoffman. Live at number 817 Charlotte Street. Am a barber. I know Hanlon. I was there at his home in 1868. At the time I was there, he was making a garden. Saw him make it. He tore up the brick and dug it up a while, and after that he made a small fence. The bricks were laying on one side of the yard. Don't know where he put them. I saw the garden completed. It was not so very large. A very small garden. It was not sodded when I saw it. Can't fix the time. It was in summer, think after the 4th of July. Mrs. Ann Kelly. My husband's name is Patrick Kelly. I live at the northwest corner of 2nd and Diamond. Know Mr. Becker. He is a shoemaker. I ordered him to sole a pair of slippers about the 3rd or last week in June, 1868. Got them about the 4th of July the same year. They were black cloth slippers, worked with zephyr, double soles, they had heels. James M. Fletcher. Was Coroner Daniels' clerk in 1868. Remember Mary Mohrman's death. There was an inquest. It commenced the 8th and ended the 30th of September, 1868. Was present at each meeting as clerk for the coroner. I took notes. The original notes were torn up when Coroner Daniels went out of office. They were written in lead pencil. The copy is in the book, and you have a copy. Mr. Daniels has the book, I believe. Book handed to witness. This is the coroner's evidence. Cross-examined. Was the coroner's clerk 6 years, never had occasion to make alteration or interlineations in the original notes. Cannot tell whether I made any in the Mohrman case. When I came to copy them off, I copied them correctly. Did not take any notes down in the form of questions and answers. Did not take them down phonographically. All the murder cases that appear in this book were taken down in my time. I have appeared in other cases. To Mr. Haggart. Don't remember what time Caroline Dinglacker's statement was taken. She was not sworn. The examination took the form of a conversation between her and the coroner. She being excited, it was with great difficulty that anything could be gotten out of her. There were 20 or 30 persons in the room, children and grown persons. Think the witnesses were examined in the order I read them. Don't remember, no counsel was present. No one represented the Commonwealth. Louisa Adams. Was married the next year after this happened. Before that, my name was Louisa Rice. Am the Louisa Rice examined before the coroner. Remember the night of Mary Mohrman being missing. Was standing on the corner of 5th and Susquehanna Avenue between church time and the letting out of church. I was talking to a young gentleman, saw a man passing up the left-hand side, up toward Susquehanna Avenue. He had a child in his arms, and the child was crying. He says, "Don't cry, Mary. I will give you 5 cents. I am your uncle." The child was bareheaded, barefooted, and had a pink and white dress on. The man had on dark clothes and a black cap drawn over his eyes. He passed on up toward Dauphin Street to Dauphin. Told the coroner this. Was not there when Caroline Dinglacker was there. When I was there, a dress was shown me. I recognized it as the dress the little child had on when carried in the man's arms. Cross-examined. Was standing on the corner of 5th Street and Susquehanna Avenue. Mrs. Glick's corner. Had been there but half an hour. Was talking to a young gentleman. His name was David McVeigh. I was waiting until the lady got ready to come out. The one he went to see. She was in the house at that time. 2221 Reese Street, above Susquehanna Avenue. Was standing at the corner near the house. The man was right across the other side by the brickyard. He had reached the corner of Susquehanna Avenue when I saw him, the brickyard corner. When I last saw him, he was going up towards Dauphin Street. He had passed Susquehanna Avenue, did not turn to look after him, said nothing to Mr. McVeigh about it at the time, went home when I left the corner, did not see the clock at all that evening, did not hear the time strike, did not take any notice. When the people were going to church, I was standing on the corner. Had been standing on the corner about 5 minutes when I saw the people going to church. Did not know Mary Mohrman. He was carrying the child sitting up on his right arm. The child was crying, but not so very loud. Heard the next morning, Monday morning, that Mary Mohrman was lost. Stayed at the corner about a quarter of an hour after I saw the man with the child. I suppose he was about halfway up between Susquehanna Avenue and Dauphin. Did not hear it afterward. Did not take any notice whether it cried after it passed me or not. Did not take notice whether the child's dress was a high-neck dress or low-neck. Did not see the child's face. Saw the back of the child's head. It was bareheaded. Noticed nothing on its head. Could take notice of the dress because it was pink and white, a white dress with pink stripes. Did not see the man's face. He had his cap pulled over his face. Did not take any notice of his face at all. Could tell by his hands that he was a white man. Did not know where Mrs. Mohrman lived at that time. Lived at that time near a square above. Did not go and tell Mrs. Mohrman about it, for I had no time. Was before the coroner. The detectives came to see me about it. Emma Krieger. Remember the Sunday on which Mary Mohrman was missed. Heard that a child was missing, and then went up and told them what I had seen. Went to the 19th Ward Station House. Was examined by the coroner on the following Tuesday after. Was examined under the name of Emma Springer. I was walking up Dauphine Street, and as I got to 5th and Dauphine, I saw a man carrying a child. He had the child on his right arm. She was crying and hollering for my mommy. He says, "Don't cry, sissy, for I am your uncle." He says, "I will give you 5 cents. He put his left hand into his pocket. He gave her something. Whether it was 5 cents or not, I can't tell. He crossed across the crossing to the right-hand side of Dauphine. He was a tall, slim man, light pants and a light coat. He had 2 patches on his coat, one in the shape of a V and the other a square patch, and a black cap drawn over his eyes. He walked very light, as if he had on no shoes. I think he had a sandy goatee and a sandy mustache. When he spoke to the child, he spoke broken English. He walked up Dauphine to Reese, then put his hand up to his face and threw something into the weeds. Could not see what it was. He walked through Reese Street to York. That is the last I saw of him that time. About 10 o'clock I saw him coming back. He had not the child with him at the time. He walked lame, as if his right foot was shorter than the left one. Told Taggart, and think it was a lieutenant of the 19th Ward, about his throwing something into the weeds. Taggart and 2 other detectives think Louisa Rice and myself went up. He asked me to show him what place it was I saw him put his hand up to his face and throw it into the weeds. Taggart then searched the weeds, and I left. About a week after, saw the same man at Water and Callowhill. It was on a Saturday night, and it was raining. Went up and told them in the 19th Ward Station House right away that I had seen the man. Lieutenant Whitcraft and 2 other police came down with them at the time. Again they got down. He had disappeared. That is all I can remember. Cross-examined. Have been married since last March. My husband is a stonecutter. My name was Emma Springer before I was married. Told Alderman Hines all I told here, except seeing the man on Saturday night. Was examined a week after they held an inquest over the child. Louisa Rice and small children were examined that day. Told at the coroner's all that I told here, all but that about Mr. Taggart and the detectives. It was not until after that they examined the weeds. Taggart and I did not go up to examine the weeds until I gave in the evidence to the coroner. Was at 5th and Dauphine Streets when I first saw this man at the corner. I was just crossing the corner on the left side. I turned and looked at him. After he left the corner of 5th and Dauphine, he went toward Reese Street. Did not see the child's face, because he held the child's face to him when the child commenced crying. He turned the child's face away whenever he saw me coming towards the side he was walking on, to the right while he was crossing. He held it away so that I could not look at its face. Don't know what he pulled out of his pocket. He pulled it out with his left hand. He carried the child on his right arm. He moved his arm, the one which he was carrying it on. He lifted her up. He moved her head away. He did not use his left hand to her at all. He turned it away so that I could not notice her face. Mr. Haggart. Did you not say to the coroner, the man said, "Don't cry, sissy, I am your uncle," and that he put his hand in his pocket and pulled out 5 cents? I did not explain it that way. At Reese and Dauphine, he stopped and put his hands up to his face and threw something into the weeds. Don't know what it was. Told them at the coroner's that I thought he had a false mustache, but I could not say positively about it. I said he had a false mustache, that he pulled it off and threw it in the weeds, but I did not say I knew him by his face. Morton McMichael. Was mayor of the city in September 1868. I issued my proclamation on the 9th of September, offering a reward of $1,000. It appeared in all the newspapers on the 10th of September, 1868. Have not a copy of the paper in my possession. Emma Krieger, recalled. When I was before the coroner, I told him that the man walked light, as though he had no shoes. They had a man up at the 19th Ward Station House that I thought looked very much like him. Have not seen him since. It was in the early part of the evening that I saw him at Water and Callowhill. He was standing in front of a liquor store, was down at a dance. Billy Kelly kept the place. Albert E. Holloway. Am 13 years old, live with my grandfather, Joseph Oat. He is a carpenter. Remember the time Mary Mohrman was lost. Saw a man in Montgomery Avenue. He was about 5 feet in height. Sandy goatee and mustache. Saw him 2 days after I heard of the Mary Mohrman affair. I saw him first at 9th and Montgomery Avenue. He was walking around. It was 6:30 in the evening. He went up 60th Street in one of the cellars. He spoke to me. There was nobody else with me at that time. I went over home and told my grandfather. I went into the house and got him something to eat. I took it to him. He talked to me then. He stayed there and ate the bread. I did not do anything. Joseph Gallagher was with me then. He is a boy about 16 years of age. The man went down to the flagman's box. I followed him. He left a bundle. Not before it was into my grandfather's house did I see it. It was there one day. It was tied up. He gave the bundle to Frank Phillips. He went around to the cellars again. I got him 2 wheelbarrows, and he made a bed out of them. The watchman came and drove him away. Thomas Blackburn was the watchman, my grandfather's private watchman. He went into the cellars of the new houses on 60th Street. They were just unfinished. The walls were just getting built up. He went down 10th to Jefferson. Then he went into a lager beer saloon at Jefferson and Mervine, and stayed there about an hour and a half or 2 hours. He had a cap on his head when I first saw him. He stuck it in his pocket, and I gave him a straw hat. He raced Joseph Gallagher and me. Went down to 10th and Master and got a police. Followed him about because he looked suspicious, and I suspected him of the murder. Went for the police, and he arrested him. Only I did not know anything about appearing against him, and they let him go. My grandfather took it to the station house the next morning and left it. I saw it. I saw it open. There were 2 gray flannel shirts, a fine-tooth comb and a coarse comb, toothbrush, Castile soap, and an old pair of pants with the seat torn out. One of the shirts had blood upon it down around the waist. The pants were light blossom color. Blotches of blood were on the feet at the bottom of the legs. Was brought here today for the first. Joseph C. Oat. Reside at 914 Montgomery Avenue. Am a house carpenter and builder. The former witness is my grandson. On the day previous to the advertisement coming out with a reward for the murder of Mary Mohrman, my attention was called to a bundle at 9th Street and Montgomery Avenue. Asked to see it and untied the bundle. We took it into my house and examined it. Contained a pair of light-colored pantaloons with blood spots upon them, 2 grayish shirts, on the lower part of the body of one which was what I took to be blood, the inside lining of an overcoat, a toothbrush, a large comb, a fine comb, a hairbrush, and a piece of Castile soap. The back and seat of the pants were cut out. It looked to me like a fresh cut. The edges looked as though cut. I was brought here yesterday. I detained the bundle till that night by the advice of a policeman, and the next morning I sent it down to 10th and Thompson Streets to the station house. Cross-examined. 60th Street is a small street east of 10th, running south of Girard Avenue. Went to see Alderman Hines about it 15 or 18 months ago. Won't be positive as to the time. Clara Barnes. Reside at 914 Montgomery Avenue. I am a married lady. I reside with my father, Joseph C. Oat, the witness last upon the stand. Went out and saw the man and gave him something to eat. The next morning I saw the same man walking around. I saw the bundle and saw what was in it. Here the witness detailed the list of articles it contained. Ellen Quinn. Am 15 and the daughter of Mrs. Quinn, who was on the stand yesterday. Remember the Sunday on which Mary Mohrman was missed. Went with my mother to my aunt's. It was after dinner. I saw John Hanlon in the evening. After I had my supper, I went on the steps with my cousin Kate. John came out and passed me on the steps and went over to the lager beer saloon. He came back. He was in his shirt sleeves. He was that way when he went out. Did not see him after he came in. Patrick Conathy. Am roadmaster on the 2nd and 3rd Street Railroad. Am a married man. Have got 6 children living and 3 dead. My house is on the back part of the lot where Hanlon's house stands. It is about 7 feet from the back part of my house to the water closet. The water closet is used in common by 2 families. Remember the Sunday evening that Mary Mohrman was missed. Remember the body being found. Was in my own house on the Sunday afternoon. In the forepart of the evening was in the front room, and after supper was sitting on my back step. The front room faced on Orkney Street. My back kitchen steps faced westwards Hanlon's house. No person was with me. I sat there until after dark, until my folks lit the lamp in my house. Heard neither noise nor saw anybody while I was sitting there, of a crying child in the water closet. Should think a child could not have cried without me hearing it while I was sitting there. After I left, I went out to the back steps. My door was open the time I left there. Cross-examined. Martha Conathay is my daughter. Did not see her when she came home. Knew that the little boy was out. After the children got their supper, I went front. I made the remark to their mother that I thought that it was time that the little ones were home. Was sitting on a chair or the sofa when the mother sent Martha out for the little boy. That was after I had been on the front steps a while. Rebuttal. David McVeigh. Am a dealer, am a married man. Was not married in September 1868. Remember the night that Mary Mohrman was missed. Knew a young woman named Louisa Rice at that time. Was in her company that night at 5th Street and Susquehanna Avenue at the southeast corner. Don't recollect how long I was there. Can't say that while I was there I saw a man carrying a child. Had opportunities of seeing whether or not a man passed along 5th Street across Susquehanna Avenue carrying a crying child. No such man passed there. I did not hear any man use the words, "Don't cry, Mary. I will give you 5 cents. I am your uncle." I don't recollect whether I or Louisa left first. Cross-examined. Am in the iron and rag business at number 309 Master Street. Been there nearly all my life. Was subpoenaed by Detective Taggart last Monday week. He asked me what I knew of the case. November 12. Mr. Brewster stated on the previous evening he and his colleague had learned for the first time that there was a witness who would prove that prior to Dunn's acquaintance with Hanlon, the former had received a copy of the Police Gazette containing all the facts of Mary Mohrman's murder, and also learned that he was informed that if he would testify he would be pardoned. He felt it his duty to state to this court and offer the witness who would prove this. Mr. O'Neill. Yesterday morning, before the beginning of Mr. Hagbert's address, a person came to me and gave me this information. I found the witness who was to prove the fact in Dock Street, and then apprised the court of the matter. The name the man gave was Tate, Samuel Tate. P. E. Carroll. Am junior counsel for the prisoner. At the instance of Mr. O'Neill, I went to a barber shop in Dock Street below Spruce to find the man, and was directed to Water Street and then to Spruce Street Wharf. I found him and took him to Mr. O'Neill's office, where he said if he had time he would find other witnesses to the same effect. He brought one with him this morning. I think his name is Thomas Pierce. Mr. Brewster said he had no knowledge of this information before he received it from Mr. O'Neill. Judge Ludlow. Under the oaths taken by the prisoner's counsel, we cannot doubt the course we ought to adopt in this case, and therefore allow them to examine the witness. Samuel Tate. Am an oysterman and live at number 316 South Front Street. Knew Michael Dunn, who was examined in this case. Last seen him 12 or 14 months ago. Seen him in cell letter A, south side, 2nd floor, Moisenmeisen prison. Had a conversation with him there. Mr. Brewster. State if you know whether Dunn at that time had access to any newspapers, and if so, what were they? Yes, sir, he had. I gave them to him myself. They were the National Police Gazette, the Philadelphia Inquirer, and different other papers. Mr. Brewster. Now what had the Police Gazette in it? Mr. Haggart. I object. The best evidence of the contents of the paper is the paper itself. Mr. O'Neill. Then we call upon the Commonwealth to produce it. Mr. Haggart. It never was in our possession. Judge Ludlow. The paper must be produced or its loss accounted for before secondary evidence of contents is admitted. Objection sustained. Mr. Brewster. Did you know if those papers of which you have spoken contained an account of the murder of Mary Mohrman? Mr. Haggart. This is still more objectionable because leading. Judge Ludlow. Objection sustained. Mr. Brewster, did you, 12, 13, or 14 months ago, converse with Michael Dunn upon the subject of the reported murder of Mary Mohrman? Mr. Haggart, that is also objected to. This witness is to be treated as if he had been called with the other witnesses for the defense, and these questions should have been asked Dunn if he was to be contradicted. After further discussion, the objection was withdrawn. Samuel Tate, I did. Mr. Brewster, did he know of her death at that time, and the circumstance connected with it, as they were made public? After he had read the paper I gave him, he knew. This conversation was on the convict side of the prison. I was a cutter of leather at the prison. I was convicted of larceny and served out my time. I worked in the cell next to him and talked with him through the hole in the wall every day, and he asked me if I had any papers. Cross-examined. I got out of prison on that charge on the 7th of December last. Have been in since on the charge of carrying concealed deadly weapons. The first charge I was in for 3 years. Was not in for safe blowing. That was not my first conviction. In 1861-2, I was convicted of burglary. That was the beginning of it, and September last was the end of it as far as I have got. Those were my only convictions. Was not on the 23rd of October convicted of forgery in this court and sentenced to 1 year in the penitentiary. Was in Mohrman prison then. Francis Evans was convinced with me for burglary. Do not know what became of Evans. He cut his way out of prison and escaped. The house number 316 South Front Street is tenanted, and I rent the 3rd-story back room. I occupied it 2 months. I showed these papers to Dunn 12 or 14 months ago. John Dunn occupied the cell in which I gave the papers. John Dunn was the man to whom I showed these papers. That is the only name I knew him by, and he told me that was his name. I got these papers from a prisoner named Henry Smith, who was in the cell beneath me. We traded out of the window. He gave them to me, I judge, 16 months ago. I put a line from out of my window, and he tied them to it. I made the line out of shoe threads, kept the papers in my cell, generally in the pillow, and I had them a month or 2 before giving them to Dunn. Have not read 1/10 of the report of this trial. Michael Dowling. Have been following the oyster business down the bay for 2 months. Was in no business before that. Had a conversation in his own cell with Dunn in the presence of the instructor. Was half cutter there. Had been put in on the charge of larceny and burglary. Talked with him on several subjects about the murder of Mary Mohrman. He read it from a paper in our presence, from the National Police Gazette, a New York paper, and the Philadelphia Inquirer. It was about 12 or 15 months ago. Thomas Pierce was his cellmate. Charles Mutant was the instructor. Don't know what Mutant was put in for. He was instructor in shoemaking. I was in for larceny, burglary, and house robbing. Was acquitted of the charge of murdering Philin. Have not yet seen Michael Dunn for a year. Was not in court when Michael Dunn was examined here. I don't know what he testified, but I heard him say he would sacrifice his mother, wife, or anybody else to get his pardon. He hallowed this down the pipe. I got out June 6. When I was in prison, I was in cell italic A. He was in the Roman letter A. When he hallowed that down to others as well as me, he told it to others in the presence of Mutant, Pierce, and myself. He hallowed down to a man named Meade in cell letter H. Was not in the cell with him then. He made the remark in the presence of Mutant, Pierce, and myself in his cell. We were all in the cell together. The reason why he made these remarks was that he wanted to get out of the institution. I said he ought to be ashamed of himself to say what he did. I went to his cell twice a week. Was not in New York in October of this year, nor was I charged with false voting there. This was a mistake of the newspapers. Mr. Haggart, how much money are you to get for swearing here? I don't know who is to get money. Samuel Tate sent for me and told me to come or I would be sent for. Was here at the recess of the court. Went over to the corner. Was 2 hours with Sam Tate and 2 other oystermen. There were 4 of us talking of the case. Did not say there was $500 offered for the men who would swear to this. Did not say this to Kit Manley. Don't recollect who all were with me. Pierce was not. Did not see him in court this morning. Conversed with Dunn in his own cell. I forgot his letter. Can't say where he was. Know the letter of the other cell, and could find him, but can't say I could find them all. Remember the paper, because I put my name on it. Sent it to a man by the name of Carroll, and it was sent to Dunn. Told Tate to send it to Carroll. He sent it to Dunn, was in Tate's cell, Dunn's cell, and all I named are on the same floor. Don't know the date of the paper. Think it was cool weather when the paper was sent. I don't know if the fires had been built in the prison then. It was a New York paper, the National Police Gazette. There were pictures in it. Don't think it was the Ledger. I got my information of this case from that paper and hearing Dunn, and also from the Inquirer. Can't tell all the papers I saw in the cell. There was a bundle under his bed. Don't know if he received them daily. I only know the child was murdered, but don't remember when or where. There was nothing more in it to my recollection. I could tell them, but have forgotten now. Believe it stated that a reward had been offered. John Hanlon's name was not mentioned as I recollect or know of. Only heard the officers were on the track of the murderer. The statement in the Inquirer was something similar to that in the other papers. I don't know what became of the papers. I saw them last at Dunn's cell. Don't know where Mutant is now. Sam Tate told me I was wanted here, and that if I did not come, I'd be sent for. This was at Shippen and 3rd Streets. We met there by accident just after dark. I was in liquor, but I'm certain I met him. Can't say if it was between 8 and 9 o'clock. Can't say when I began to drink. It was in the morning. I went to bed at 11 o'clock that night. You want me to tell a lie? I want to tell the truth. It was after dark. Went to Nolan's house in 2nd Street between Lombard and South. I believe I went there from 3rd and Shippen. Went to sleep in a chair. Went from there to John Scott's in Shippen Street between 3rd and 4th. Don't know where I got my supper. Was too much intoxicated. I last saw Tate about 2 or 3 hours ago standing at the corner of 2nd and South Streets, talking about going down the bay. He told me I was wanted as a witness. I say on my oath I don't know who Mr. O'Neill is. I may have been in his office, but I don't remember it. Did not join him with Mr. Carroll last evening. Cannot say when I saw Tate. To Mr. Haggart. The Police Gazette was the only paper Dunn read. Saw the heading of the article in the Inquirer. It was, quote, "The Murder of Mary Mohrman," end quote. Got my information from its being in 2 papers. There was a long pause in the trial here, owing to the absence of witnesses for the defense. Judge Ludlow urged the counsel to proceed. Mr. Brewster said they were making every effort to produce the witnesses and could produce them by 6 o'clock. Judge Ludlow: Then we will sit until 12 o'clock tonight in order that you may finish your case. I neglected to ask whether subpoenas had been issued for these witnesses, so that the process of the court may be properly used to bring them in and justify this delay. Mr. Brewster: I am instructed to say that we will be able to bring the witnesses in between this and 6 o'clock. We will do the best we can. Fugitive notes were sent to us yesterday afternoon. We could not know from whom nor ascertain the truth of their statements at that time. We have made every effort to produce the witnesses referred to in these communications, and will say to the court that if we do not produce them by 6 o'clock, we will leave the matter to your honor's ruling. Judge Ludlow: These witnesses may come in by 6 o'clock? Mr. Brewster: Yes, sir. Judge Ludlow: Then the court will remain in session until that time. The judges retired to their consulting room. A few minutes before 6 o'clock, they resumed their seats. Mr. Brewster said he understood that the witness Pierce had been detained by the officer on the stairs, and he desired to have him brought in. Judge Ludlow: Send for him, Mr. Crier. Daniel Pierce: Known Michael Dunn, knew him in prison. He came there in August 1868. He stayed with me till February 1869. Had no conversation with him in relation to the Mary Mohrman case, although it was talked about. He knew of it, and I knew of it. He got an account of it from the paper, the Police Gazette, and other papers. I saw him reading the Police Gazette. It came from different localities and parties. I was there serving out 2 years for larceny, served out my term. Cross-examined: My name is Daniel Pierce. Did not say to anyone my name was Scanlon. I think I did sign my name to a bail bond before Alderman Allison by the name of Scanlon. I was intoxicated at the time. I was in cell B. Dunn got the Police Gazette from letter B, I think. A man named Carroll was there. I don't know where he got the papers. There were 1 or 2 police gazettes, I am sure, containing the account of this murder. Carroll sent it up to me. The runner said he sent it. Don't recollect any writing on it. Tate's name or any other don't recollect. The runner was a colored man. It was in October 1868, I think. Cannot tell what I did with the paper. Can't tell how long I had it. Think there was another paper containing an account of this matter. Can't say what. Did not read it loud. Can't say if Dunn read it aloud. Don't know that I had a conversation with Dunn about Mary Mohrman's case. I live at number 316 Bainbridge Street, formerly Shippen Street. Tate came to subpoena me. Was waiting for William Murphy, a young man. He was a bartender for Mr. Oliver. Don't know what business Oliver carried on. Did not wish to mention the man's name. Have not seen him since I came out of the county prison. He asked me to take a walk. Did not tell me what for. Said we ought to go out to the court. I have read part of Dunn's testimony here. Don't remember that part in which he said he had friends, money, and influence. Was waiting for Murphy this morning. I was subpoenaed when I got to 6th and Walnut Streets. I got out of Moyne-Mansing June 15th, 1870. Lived with my brother. That is the first time I was in. Was convicted on 2 larcenies. Was in letter B, South Side. Dunn and I were in letter U when the paper was received. Know Michael Dowling. Have not talked to him on this subject. Michael Dowling was notified to be here last night. Did not come voluntarily. It is no interest to me. Had no part in it until I came to court. Asked the last witness why he had not told the truth. He knows more if he would say it. Was at 7th and Shippen Streets. Met Tate and Farmer to look for Murtart. Saw no one else there. Don't know what time it was. It was after the court met. I think after the noon recess. I did not say to anybody there that there was $100 in the case. End of section 37. Section 38 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3 by John D. Lawson. Trial of John Hanlon for the murder of Mary Mohrman, Philadelphia, Pennsylvania, 1870, Part 5. The Arguments of the Counsel. November 15. Mr. Brewster began his argument discussing the principles of law applicable to the principal features in this case. The confession, for the purpose of showing that it should not be received by the jury. He referred to the fact that the English statutes as early as the 14th century forbid the use of these means, confessions drawn through the process developed in this case. He contended that, while not expressly forbidden in this state, the theory of the law forbids it. Authorities were referred to showing the danger of taking confessions, voluntary or otherwise, as evidence of guilt. Confessions are received by courts, but always with suspicion. Upon this branch of the argument, Mr. Brewster urged that the confession was, quote, hearsay, end quote, and the jury could only receive it as Dunn gave it, not knowing what he omitted or what he added, not knowing whether he reported correctly the words of Hanlon in making the alleged statement. Having disposed of the principles of the law with numerous quotations from the reports, Mr. Brewster took up the evidence. First, John Hanlon is accused of this offense by Michael Dunn, and Michael Dunn is sought to be corroborated. Would any juror convict John Hanlon of any charge, no matter how trivial, upon such testimony? When Hanlon was put with Dunn, it was natural for Hanlon to tell him the latest horror, the murder, and he might have told every words as alleged by Dunn without the all-important addition, quote, I am the man, end quote. Hanlon was only repeating what others knew. The mere proof of facts, known long before, is not corroboration of Dunn. Caroline Dinglacker's testimony, called to corroborate Dunn, is not corroborated by a living witness, and what she does now say is entirely different from what she said before the coroner when she failed to tell that she saw the man go up the alley. If that was true, why not tell it then? She tells the story like a well-prepared lesson, as it is, not because her mind is impure, but because it is weak naturally, for she is 9 years of age. In regard to the other corroboration, it was contended that, while a man was seen carrying a bundle, there is no evidence that it was John Hanlon, and yet some of the witnesses who saw the man knew John Hanlon, and they do not identify him here. District Attorney Shepard, to the jury. I am here to perform my duty without any reference to the seductions of flattery or the threats of others. I shall, however, discharge my whole duty in the case, as I feel the public demand it. In what I shall say, however, I shall confine myself to the facts and the facts alone, without reference to any attempt at oratory. Now let us begin at the beginning. Was there such a child as Mary Mohrman? For there have been attempts made to raise so many doubts that possibly they would have you to believe that no such child existed. It is certain that when she was last seen, she was in the neighborhood of John Hanlon's house, and it was there, alongside of that corner and in that alley, that Mary Mohrman was missed and carried away. There is evidence in this case to show that she was carried up that alley by John Hanlon. Now about Caroline Dinglacker, of whom so much has been said. After she had given her truthful story, she was subjected to a torturing cross-examination, occupying over 2 hours and a half. But in the case of a full-grown man, it was different with my friends. They feared to attempt to subject him to so terrible an ordeal. It seemed as though the transaction was to be completed by torturing a child after one had been murdered. In the examination before the coroner, it is difficult to say which of it is in the coroner's language and which is the testimony of Caroline Dinglacker, as the testimony as recorded was conversational. These rough notes of the coroner rather represent the judgment of the coroner instead of her testimony, for he did not even get her name correctly. Observe, gentlemen, it is not her own testimony alone, but that it has a bearing upon Michael Dunn's evidence, and herein is the reason why they should have you reject the little Dinglacker girl's testimony. She said that he wore light clothes and a striped shirt, and during the whole time I was troubled as to how she made that out. That was not accounted for by John Hanlon in his confession, and was not made up by detectives. But when the defense opened their case too, they said that he wore a striped shirt, and herein the little girl was fully corroborated. District Attorney Shepard continued his argument at some length, reviewing the evidence for the Commonwealth and defense, and closed with a powerful appeal for the jury to render a verdict of guilty. The judge's charge. Judge Ludlow. Gentlemen of the jury, after many days of patient labor, we approach the end of this trial. To the court is assigned the duty of explaining to you the law, and while we may comment upon the evidence, you and you alone can decide upon the guilt or innocence of the prisoner. In view of the vital importance of the issue presented now and here, we beg that you will, as conscientious men, act with perfect impartiality, and being guided by the law and the evidence, that your conclusion, whatever it may be, will commend itself not only to your own sense of justice and right, but also to the severer judgment of that being before whose bar we which each stand hereafter to be judged. Acting upon these principles, you can safely proceed to the discharge of your duty, regardless of consequences. The bill of indictment charged the prisoner with having committed the crime of murder. It contains 2 counts. The first charges a willful, deliberate, and premeditated murder, and the second a murder committed in the perpetration of a rape. Our statute declares that all murder which shall be perpetrated by means of poison, or by lying in wait, or by any other kind of willful, deliberate, and premeditated killing, or which shall be committed in the perpetration of or attempt to perpetrate any arson, rape, robbery, or burglary, shall be deemed murder of the first degree, and all other kinds of murder shall be deemed murder of the second degree. You will observe that, under our law, any willful, deliberate, or premeditated killing constitutes the offense of murder of the first degree, and also a killing committed in the attempt to perpetrate or the actual perpetration of the crime of rape. Hereafter, your attention will be called to a distinction which depends upon the language of the statute. Before we proceed further, it is proper to refer to the general law in relation to homicide, and then we will be able to understand the language of our Act of Assembly. All homicides are not felonious. An officer of justice who kills a man in the discharge of the duties of his office, as when the sheriff executes a criminal, perpetrates a homicide, but he commits no crime, for it is a justifiable act. The man who in self-defense and under circumstances clearly warranting it slays another is not a criminal, for the act is a necessary one and the homicide is excusable. Where a life is taken under circumstances clearly indicating malice, the offense at common law is a felony of the highest grade in murder. To this day, and in this Commonwealth, a malicious killing is murder. Our statute, however, modifies the rigor of the common law and establishes 2 grades of murder, to wit, murder of the first and murder of the second degree. To establish murder of the first degree, something more than malice must be present. It must in ordinary cases be coupled with an intent to take life, and the killing must have taken place in consequence of the willful, deliberate, and premeditated act of the prisoner. If the intent to take life does not exist and is not clearly established by the Commonwealth, and if the act was not willful, deliberate, and premeditated, the offense is not murder of the first degree. If the killing occurred from the malicious intent of the prisoner to do great bodily harm, the offense would be murder in the second degree. We have said that in ordinary cases the intent to take life must be proved, together with the fact that the killing was the willful, deliberate, and premeditated act of the prisoner, in order to constitute the offense of murder in the first degree. But in a case in which a murder is said to have been committed in the perpetration of rape, the specific intent to take life need not appear, but the death must, in the language of the present Chief Justice of the State, be clearly shown by the prosecution to have occurred in the performance of such acts as should establish the independent substantive crime. Kelly v. Commonwealth, 1 Grant 487. Upon this branch of the case, 2 questions therefore present themselves under this bill of indictment. First, was the killing willful, deliberate, and premeditated, and was it malicious and coupled with an intent to take life? If so, whoever committed it would be guilty of murder in the first degree. Second, did the killing take place in the perpetration of the crime of rape, manifested by acts clearly indicating the commission of that crime, and without regard to the intent to take life? If so, the crime would be murder of the first degree. Under the first count in this bill, it is in the power of the jury to convict of murder of the first degree without regard to the fact whether a rape was or was not committed, but to do so they must be clearly satisfied that the act of the guilty agent, resulting in the death of his victim, was a voluntary one, that it was well considered beforehand, and being thus a free act, thought of in advance, was coolly perpetrated with a malicious design to take life. Under the second count in this bill, the prosecution must establish by clear testimony the fact that the crime of rape was perpetrated, and that in the perpetration thereof the deceased lost her life, and that without regard to the intent of the prisoner. It is all important upon this second count for you, gentlemen, to understand what the crime of rape is under our law. Our penal code declares, if any person shall have unlawful carnal knowledge of a woman forcibly and against her will, or who, being of the age of 14 years and upwards, shall unlawfully and carnally know and abuse any woman, child, under the age of 10 years, with or without her consent, such a person shall be adjudged guilty of felonious rape. Another section of our code declares that it shall be necessary in the case of an alleged rape upon the person of a child under 10 years of age to establish carnal knowledge by proof of penetration only. It is necessary, therefore, in this case, for the jury to believe that the person of a child under 10 years of age was unlawfully and carnally penetrated by a man above the age of 14 years, and this without regard to whether she did or did not give her consent, in order to come to the conclusion that the particular crime called in the statute rape was committed. If in the perpetration of such a crime upon such a person the victim died, the crime is murder of the first degree. We said to you that our statute created a degree of homicide called murder in the second degree, which you will remember was the malicious killing of another, not perpetrated willfully, deliberately, and premeditatedly, and with intent to take life, or in the perpetration or attempt to perpetrate one of the felonies named in the statute. For, after designating these, our law says, all other kinds of murder shall be deemed murder of the second degree. We call your attention again to this degree of crime, as well as to the offense named voluntary manslaughter, which is the unlawful killing of another person without malice on a sudden quarrel or in the heat of passion, Not because we suppose the jury will, with the facts now in evidence, believe for a moment that it does not at all point to the commission by some one of a capital offense, to wit, murder in the first degree, but because our supreme tribunal has declared that a jury may by law find any degree of crime they please and are alone responsible for the view they take of any evidence in a cause. Having thus referred to the law, it is now our duty to direct your attention to a number of questions which arise in the cause, and to refer to the evidence together with the principles by which you ought to be governed in determining its application, weight, and reliability. To sustain a conviction, it ought to appear that the person named in the indictment as the victim of criminal violence is in fact dead, that she came to her death by violence inflicted either maliciously with a willful, deliberate, and premeditated design to take life, which is murder in the first degree, or in the perpetration of the crime technically called rape, which is also murder in the first degree, or maliciously and with intent to do great bodily harm, which is murder in the second degree, or without malice, in hot blood, on sufficient provocation, or in a quarrel, which is manslaughter. The following questions must therefore be answered in this case. First, in point of fact, is Mary Mohrman dead? Second, did she die a violent death? If so, what was its nature? Third, did the prisoner at the bar destroy her life in manner and form as he stands indicated? The first question can, if you regard the evidence, easily be answered, for it has not been disputed that this child lost her life in September of the year 1868. That, however, we may be guided alone by the proof and the cause we refer to the testimony of Dr. Sharpley, to the identification by Mr. Fluke, and the mother of the deceased, as also to the evidence of a number of other witnesses produced by the Commonwealth upon this point. Having thus established the fact of the death, the second question arises, did she die a violent death? And if so, what was its nature? Dr. Shapley's testimony discloses the fact that the person of this child was most shockingly mutilated. Upper part of chest and neck, and under each ear the body bore evidences of violence. Upon the top of her head were 2 wounds, and also one upon the back of the head, while her private parts had been torn and lacerated. The testimony of the mother is that she was but a little over 6 years of age. By other witnesses was declared to be at the utmost not more than 3½ feet in height. Can this be a case of death by accident or suicide? It is for the jury to determine, and if it would be impossible, in your opinion, to come to any such conclusion, then what was the nature of the violence which resulted in the death of a child of such tender years? Dr. Shapley declares that the immediate cause of death was strangulation, but we must look a little further and determine whether any circumstances of a peculiar nature accompanied the act. The evidence is that the child was seen alive at an early hour on Sunday evening, that she was not again discovered until she was found dead at the edge of a pool of water on the morning of September 8, 1868. When found, her body presented a melancholy spectacle, with marks of violence upon her throat, chest, ears, and the top of her head, and with blood upon her limbs and about her private parts. Looking now simply to the manner of her death, without regard to the guilt or innocence of the prisoner, it is for the jury to say whether this strangulation was incident to, and a part of, the act of some person engaged in the perpetration of a rape, because if it was, although the actor did not intend to take life, the law makes the offense murder in the first degree, if the jury believe that in point of fact a rape was perpetrated. If, however, you come to the conclusion that, although a rape did take place, the child afterwards died by an act of violence, independent of rape, the offense would only be murder in the first degree if the guilty agent acted maliciously with an intent to take life, and willfully, deliberately, and with premeditation. Taking into consideration the testimony in this cause, which relates exclusively to the condition of Mary Mohrman's body when found, and viewing especially the evidence of the coroner's physician of the condition of the private parts as developed by post-mortem examination, can the jury pause in determining the exact legal nature and cause of this death? Was it violent and the result of force used in perpetrating a rape? You have a right alone to determine its nature, and in doing so we know you will be governed by those well-known rules of common sense, sanctioned by law, which permit you to draw conclusions of fact from causes established by the uncontradicted evidence in the cause. If you determine that the deceased child lost her life by violence, the greatest question in the cause remains yet to be answered. It is this: did the prisoner take the life of Mary Mohrman? Before proceeding to speak of the evidence submitted upon this branch of the cause, we ought to refer to the peculiar nature of the most vital part of it, to wit, the alleged confession of the prisoner. Verbal confessions are at times to be received with great caution, for, says a learned writer, besides the danger of mistake from the misapprehension of witnesses, the misuse of words, the failure of the party to express his own meaning, and the infirmity of memory, it should be recollected that the mind of the prisoner himself is oppressed by the calamity of his situation, and that he is often influenced by motives of hope or fear to make untrue confession. Greenleaf, section 214. Confessions are also of two kinds, judicial and extrajudicial. Judicial confessions are those which are made before the magistrate or in court, in due course of legal proceedings. Extrajudicial confessions are those which are made elsewhere than before a magistrate or in court. Of this nature is the alleged confession in evidence in this cause. It is also to be observed that by our law, an extrajudicial confession, uncorroborated by any other proof of what is called the corpus delicti, that is, the actual offense committed, as that the person alleged to be murdered is in fact dead, is insufficient for the conviction of the prisoner. In this case, the death of Mary Mohrman seems, though you must determine the fact, to be admitted or established by competent testimony. As, however, the confession in this case was made, if made at all, by the prisoner to a person who was a fellow prisoner, and who admits that he had committed here and elsewhere numerous crimes, we think it our duty in this case to say that this confession ought to be corroborated by circumstances in the cause which are themselves to be proved by competent witnesses, are consistent with each other, and with the main fact sought to be established, to wit, the truth of the confession in evidence. The competency of the witness was decided by the court. His credibility is for you. Bearing in mind these principles, we will now proceed to examine the evidence insofar as it relates to the guilt or innocence of this prisoner. End of section 38. Section 39 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3 by John D. Lawson. Trial of John Hanlon for the murder of Mary Mohrman, Philadelphia, Pennsylvania, 1870, Part 6. In order to give you a correct view of the premises in which it is alleged by the Commonwealth this murder was committed, as well as to present to the eye a representation of the streets of the neighborhood, together with the lot and pond on which it is said the body was found, the district attorneys have produced in evidence plans of the residence of Hanlon, the adjoining alley, privies, gates, streets, lot, and pond. Your attention has already been directed to the house in which Hanlon lived. You remember the alley at the side of the house, its gate and the position of the house and privy. The house had 3 stories, with a back kitchen and cellar. The room downstairs, first story, was occupied by Hanlon as a barber shop. Had, of course, a front door, a rear door, and a partition, which had been erected at the end of the room. Passing out of the shop, you entered the space enclosed by the partition. You could go upstairs by a stairway or into the cellar by another stairs, or into the kitchen through a door. The house upstairs was divided into 4 rooms, 2 on each story. The cellar ran under the house. The question of the exact time at which the deceased lost her life becomes one of importance, and to the evidence submitted on that point we shall first direct your attention. Officer Fluke declares that he saw Mary alive for the last time between 3 and 4 o'clock on the afternoon of Sunday, the 6th day of September, A.D. 1868. She was missed, he says, at 8 o'clock p.m. Anna Mohrman, a sister of the deceased, says her sister was with her that evening on Diamond Street on the step. Mary and Mrs. Dinglacker's little girl went with the baby, Mrs. Bush's baby, around into 5th Street, with the coach on the same side of the street upon which Mr. Hanlon's house is situated. Emma Bush testifies that the last she saw of Mary, she was seated on Haggenswheeler's steps, spoke to Hanlon as she passed by a group. She fixes the time at 7:45, just before church let out. Carolyn Dinglacker met with deceased at the steps and went with her around into and down 5th Street with the coach. Martha Conathay saw Mary that evening standing at a fence, Deal's fence, talking to a man, but does not fix with precision the time, though she says it was after supper just about dark. Her brother went to bed at 8 and she about 9 o'clock. The mother of this child, Mrs. Sophia Mohrman, saw her daughter last at 7:15 on her way to church. Mary left me at the corner of Orkney and Diamond Streets. She returned, she thinks, at from 8:30 p.m. to 20 minutes to 9 o'clock. Her child was not at home, and her anxieties being aroused, she proceeded to make a search for her, which was continued to an early hour in the morning. This witness went around into 5th Street, and the neighbors informed her that Mary was there 10 or 20 minutes ago. From this evidence, it may be contended that the child was lost and had disappeared between the hours of 7:30 to 8 p.m. and 20 minutes to 9 on that evening. On the question of the time, we shall refer hereafter to the confession. When was the body discovered? All the testimony seems to concur in fixing Tuesday, the 8th day of September, 1868, at an early hour of the morning, as the day and time the discovery of the dead body was made. The place also seems to be settled, for all the witnesses say the body was found at the edge of a pool of water in the open lot. When was it placed there? Anna Emery testifies that she came from 505 Dauphin Street across the lot at 20 minutes after 5 on Tuesday morning and discovered the body. Samuel Bilger came down to Tyson Street and crossed to Susquehanna Avenue at 3:30 a.m. on Tuesday morning. He did not see the body, although he passed within 8 or 10 feet of the spot where it was found. George Quester crossed the lot at 4:15 a.m. within 2 yards of the pool, and the child was not there then. After the discovery of the body by Anna Emery, or about that time, a number of other witnesses testify to the time at which each saw the body. Isabella Martin got up at 5 a.m. and saw the body soon afterwards. Emma Brown, who knew the child as soon as she saw her, was called by Mrs. Martin. Anna Lepp went home from her father's house to prepare a meal for her husband at 5 a.m. and soon saw the body at the pond. Caroline Landman was there when Mrs. Emery came, while Caspar Bond, the officer, and George J. Link found the body at the pond at about 5:45 a.m. or soon after that. From this evidence, it would seem that up to 4:45 a.m., the deceased was not upon the lot, and at some time between 4:45 a.m. and 20 minutes after 5, it had been deposited, though this question, as well as all others of fact, is for the determination of the jury. At what exact period of time the child lost her life does not of course appear, but the Commonwealth have submitted testimony from which the jury are asked to believe 2 facts. First, that the child disappeared between the hours of from 7:30 to 8 p.m. to 20 minutes to 9 p.m. on Sunday evening, was discovered dead at about 20 minutes after 5 a.m. on the following Tuesday, and further that the body was not deposited upon the lot before 3:45 a.m. on the morning of the 8th of September. Having thus endeavored to fix your minds upon the question of time, you must be anxious to search for further evidence of the nature of the death, its cause, and the perpetrator of it. Just at this point, our attention must be directed to what may be called the great central fact in the Commonwealth's case, to wit, the alleged confession of the prisoner at the bar. It is unnecessary to recapitulate that confession. It is enough for the court to call upon you to review it as a whole and in detail, and we will content ourselves now by referring to its most significant parts, and then point you to the testimony by which it is contended it has been corroborated. After describing the method by which the child was taken into the alley, the alleged confession makes the prisoner state that he took the child into the privy of his house and then violated her person. I caught hold of her by the neck. The more I heard her, the more she tried to holler, so I had to hold her tighter. I did not mean to let her go until I did all I wanted. When I was done, she was dead. Everyone thought she had been cut with a knife. I did not cut her. I then carried her across the yard to a small window that led to my cellar. The window lifts up and down. It has no latch to it. He put the body, says the witness, through the window, put down the window again, took off the whiskers, and went upstairs. It was 8 o'clock when he got the child, and 8:30 when he got up the stairs. I covered her up, and I left her in the cellar. I was bound to get her away that Monday night. Tried 3 or 4 times before 2:30. Scene coast was not clear until between 3 and 4 o'clock. At a subsequent interview between Dunn, the witness, and the prisoner, the witness states that the prisoner gave a somewhat different account. The witness says that at this interview that he did not in the privy. He murdered her in the cellar. The way he held her by the neck in the privy, he hurt her and had to keep her from crying. He put her in through the cellar window and went to get some hair oil, and she began to cry. Same as he told me, says witness, before. I caught her by the neck and I held her till I was done. When I was done, she was dead. Is this confession of the nature of the acts which resulted in the death of Mary Mohrman true or false? If it be true, it requires no further comment from us as to the crime which was then and there perpetrated. Let us look further into the details of this alleged confession to see whether it is corroborated, reserving our comments upon the evidence for the defense to a subsequent part of this charge. By the confession, the prisoner is stated to have gone at 3 o'clock over to Fisher's, left at 7:30, went over and sat on his own step. In a few moments went so far as 5th and Diamond Streets, then asked Emma Bush to show him the way to 4th and Dolphin. Emma says, a man at the corner of 5th and Diamond asked me if I could not go with him. I did not know him. I went down 5th to our house. John Hanlon was sitting on his own step. He asked me if I knew where Dolphin Street was. I said yes. By the confession, Hanlon said, as stated by the witness, I got her in the alley at the time Emma Bush was with them, but the other girl was there and saw me lead Mary Mohrman by the hand into the alley. The next day, she said it was a big man with whiskers on took her from me, and that is why I stood my ground. Carolyn Dinglacker says, I was with Mary at Hagen's Wheelers, had a coach with Mrs. Bush's baby, stopped by Hanlon's pole, a man took her by the hand up the alley. I called her 2 or 3 times, and she did not answer, and she did not come back. She took the coach to Bush's. Just here we pause to say that the vital importance of this little girl's testimony may explain why she was subjected to a tedious and lengthy cross-examination. The court did not and would not interfere, and the result of that examination is before you, so that you may judge of the weight which is to be given to the child's testimony. The learned counsel for the prisoner measured the extent of the cross-examination by the momentous issue involved, and with her conscientious discharge of proper duty, no man has a legal right to interfere. Look at this child's evidence as a whole, weigh it with reference to its material points, as contrasted with minor details, and give to it that consideration which it legally deserves. We shall refer to it again hereafter. But to proceed, the witness also says that she went across the street, looked over at Hanlon's, and the barber shop door was standing open, and it was dark. When she got into her own home, she saw a man go up the alley. Did she see 2 men? The man I saw when I looked out of the window had a dark straw hat. The man that spoke had dark clothes, a striped shirt, and a cap on. He had whiskers, too. Martha Conathay saw Mary talking to a man at Deal's fence, standing at the corner, had a cap and dark clothes, but did not know him. Alderman Field stood at the corner of 5th and Diamond and went into his house at 8:15. He saw some person before he went in on Hanlon's steps. Came out in 15 or 20 minutes and saw nobody. He thought the person he saw was a man. It is said that the confession has received further corroboration. Let us examine again the testimony. In a minute or 2, said the prisoner to the witness, Dunn, I got her in the alley. A man came through the alley at this time. I had her standing up against a fence that separates the yard belonging to the cigar store from the alley. I did my best not to let the man see her. He hit up against me in passing. He told me, says Dunn, he did not know this man. He was damn sure he could not swear to him. The man went through the alley somewhere. John Shriver is called by the Commonwealth to corroborate this statement. He says that about 20 minutes to 9 p.m. he went into the alley about 15 or 18 feet and saw a man. I did not know what he was doing. He was standing still between 2 privies, one his own, the other Deal's. He was alone, did not speak to him. It was dark. I heard of the loss half an hour after. He was standing in this position, head down and feet apart. He was about 5 feet high. Clothing looked dark. On cross-examination, this witness said that he saw him, the man, when 1 or 2 steps from him. When I entered, from where I saw him, it is 15 feet to where you enter my yard. When 2 steps from him, I looked over my shoulder. He mentioned the circumstance some 14 days or more after, and that he spoke to his children about it some 4 or 5 weeks after the death of Mary. It is for the jury to say how far upon this point this witness corroborates Dunn's statement of Hanlon's confession. It is evident that he did not know the man, but does this witness corroborate the statement and thus add to its weight? That question you alone can determine. In speaking of his visit to the upper part of his house after the alleged murder, the confession stating that by 8:30 he had gone upstairs, the prisoner is made by Dunn to say, "I had hardly got upstairs until Mary Mohrman's mother came in front of my house looking for her. Mrs. Mohrman, in her evidence, says, I passed Hanlon's house in search of my daughter at 20 minutes or a quarter before 9 p.m. The confession describes the efforts made by the prisoner to dispose of the body and the Commonwealth endeavor to corroborate the truth of the statement by proof of the appearance of a man at certain periods of the early morning. Let us look at the evidence upon this point a little more in detail. By the confession, it appears that when the coast was clear by one statement, he got the body, went out the back way, turned to my left, crossed over Diamond, then around up Diamond Street as far as 6th, turned up 6th, turned again and went into Dolphin Street, then turned again and saw a man on opposite side. Got behind a barn, which was a wooden frame building. I don't think the man saw me. Threw body on a spare lot. Then he crossed over, says the witness, to either 5th or 6th Street and Susquehanna Avenue. A lager beer woman saw me, came down on her side of the street, saw a light in the window and someone standing. Got away home as soon as I could. It was now after 4 o'clock. Another statement made to witness was as follows. I got the body and put it lengthways in front of me and fastened the coat I had on around it and me. Went out the back way, turned to my left, crossed over to Diamond Street, then I turned up Diamond Street as far as 6th, then went into Dolphin Street, then turned again, saw a man on the opposite side of the street, got behind a barn on the opposite side of the street, which was a wooden frame building. All was clear until I was crossing Susquehanna Avenue, and there I met Charlie Mass. I had on a pair of the light plush slippers. The way I was dressed and fixed up thought Charlie did not know me. I knew he was going to the stable to feed his horse, so as to get to market to buy things for his mother, who keeps a grocery store. When I met Mass, I had the body in my arms. I went on to Dolphin Street and got to where I put down the body in a pond of water that was on the spare lot. I hardly had it out of my arms until I see a man coming. Then I run and got behind the barn. Stayed there a minute or two, then I went down to 5th and Susquehanna Avenue, and a lager beer woman seen me. She was opening her shutters from the inside. I held my head down and threw up my arms. To corroborate the essential part of this statement, the Commonwealth called Alfred Walton, who lived at Susquehanna Avenue and 5th Street, opposite the lot on which the body was found. He states that early on Monday succeeding the murder, about 1 o'clock, he saw a man standing under the awning, or 2 feet from it. Then appeared on southeast corner, Glick's. He did not stand, but looked excitedly around, then went down the south side of the avenue. He then stood under a shed at corner of the avenue, and looked about, and went down Orkney Street. Next he saw of him was in 5th, below Susquehanna Avenue, coming out of Orkney Street. The witness then went down into his store, struck a match, saw it was 2 o'clock. On his return he saw nothing further. The man was about 5 feet 7 inches high, slightly built, dark clothes, hat or cap pulled over his eyes, and collar turned up and made no noise. Another witness, George Custer, was the watchman at the 4th and 8th Street Passenger Railroad Depot. He was on duty at an early hour on the morning of the 8th of September. He stood at the corner of the office on the lower side of Diamond Street. It was early before the hostlers had arrived. It was 20 minutes before or after 3 o'clock, you cannot say which, when a man was seen by him to cross Diamond Street, coming not going across. Heard no footsteps. Going up Germantown Road to the bend of 6th Street, he lost sight of him at that point. This man had a sort of bundle thrown over his shoulders, like a bag of wheat or feed. His walk was slow, his size medium. An hour or so afterwards, the body was found. Charles Mass got up about 3 o'clock, was going to the stable on the opposite side of Germantown Road, near Diamond Street. He saw a man walking fast, carrying something in his arms, made no noise in walking. When this witness got to the square, he looked toward him, saw him carrying something in his arms, bent over as though carrying something weighty, had on light pants, looked dark about the body. He met this man coming up 6th Street toward Susquehanna Avenue, on the east side, 6 or 8 doors below Susquehanna Avenue. He watched him till he came to the curb of the avenue and then lost sight of him. This time the witness fixed as between 3:30 and 4 o'clock. He did not know the man. Another witness, John N. Giverson, was going to work early in the morning between 3 and 4 o'clock, nearer 4. He says he saw a man 25 feet ahead of him. He, witness, had crossed Diamond Street on the east side near Cornell's cigar store. He appeared to be carrying something across his left breast, walking sharply, apparently barefooted. He went straight up to Susquehanna Avenue on east side of 6th Street. The witness walked at an angle to the old foundry, saw Mass standing in front of his house, lost sight of the man about 20 paces above Susquehanna Avenue. He did not see his face, for his back was turned, though the witness thought the man was built slenderly and was about 5 feet 5 inches in height. To trace the route by which this man returned, the Commonwealth called William Quester, who states that he had been to a watermelon party, left the house at 20 minutes to 4, crossed the lot at 10 minutes to 4, crossed from 6th and Susquehanna Avenue to 5th Street, went along Susquehanna Avenue towards 5th, down Susquehanna Avenue to 5th, then went catacornered across 5th Street from northwest to southeast corner of Susquehanna Avenue. This witness saw a man as he stood at the edge of the path which crosses the lot. As he stepped on 6th Street, he saw a man pretty close to the old house, and he walked around and went to the north side. When Quester reached 5th and Susquehanna Avenue, he started on a run. The man at first was 50 yards ahead of him, and he saw no more of him. Emmelina Welscher, the German woman who lives at the southeast corner of 5th and Susquehanna Avenue and keeps a lager beer saloon, went to bed and left her window open. She got up and went to open her shutters or shut down her window, being cold. As she reached the window, she says she saw a man coming from Susquehanna Avenue. He walked fast and was going toward 5th Street. She saw him first on the Brickyard side, then on her own side and pavement. He went down 5th Street. He run down 5th on my side, says Mrs. Welscher, though on cross-examined she added he did not run, he walked fast. She did not see his face and did not take particular notice of him. This witness cannot fix the precise time, but thinks it towards morning. She went to bed again the second time, and when she got up it was 6 o'clock. In answer to prisoner's counsel, she said it was about 4 o'clock. She did not hear the man until she saw him. Other and minor details of evidence of corroboration have been offered by Commonwealth, such as that Hanlon sometimes wore slippers, that officers were detailed to examine into the case at the time the murder was committed, and that men were arrested generally who had whiskers and dark clothes, that a subscription was taken for Mrs. Mohrman, though it does not appear that Hanlon subscribed, and that he was present to view the body of the child on Wednesday, that the prisoner on being arrested gave the name of Charles H. Harris, but as we do not pretend to review every particular fact in the case, we will content ourselves by asking you to refresh your memories by reflection as to any point which may have escaped our notice. In looking at this confession with the evidence submitted in corroboration of it, the most material part of which we have alone referred to, you ought in the first place to determine what was the position of Dunn at the time he says it was made to him. How long had he been in prison? When did he first know of Hanlon, or hear or know of any fact touching his, the prisoner's, case? And were they, the facts of the murder, generally known? In weighing the credibility of Dunn's evidence, everything depends upon a satisfactory answer being made to these questions. If the witness never knew Hanlon, had never heard of the facts of this case until informed by him, and by him alone, the corroborative testimony will doubtless have more weight with you than it can possibly have if Dunn, by any possibility, in any way, did or could have informed himself as to the specific facts of the case. Dunn says he was convicted and sent to prison in August 1868, that he never knew Hanlon until December 29, 1869, and that because that time he knew nothing whatever about him or this case, and that the interviews which took place during the day continued from time to time between the 29th of December, 1869, and March 1st, 1870, when the prisoner was removed from his cell. Alderman Hines, Detective Taggart, Smith, and Tryon, and the Assistant Superintendent of the prison, each say that they communicated nothing to the witness Dunn. Mr. Perkins declares that no one but the detectives had access to Dunn, to his knowledge, that no newspapers except religious ones are permitted to be received by convicts, and those only when given by the prison society, while to his knowledge no communications, which are opened and examined either in going out or coming into prison, were ever made of the disappearance and death of Mary Mohrman. The Commonwealth goes further and offers testimony to the point that as to certain witnesses, among them William Quester and John M. Giverson, the officers knew nothing of their testimony until within a few days past, and that prior to the confession they did not know even of the existence of such a fact as this, to wit, the appearance and disappearance of a man behind the old barn. We shall hereafter notice, in its proper place, the evidence produced to prove that Dunn had knowledge of the murder, and now, looking at the alleged confession, with the evidence which has been produced to corroborate it, together with all the other testimony produced by the Commonwealth, remembering the very able arguments of the prisoner's counsel directly to the reliability of the evidence produced in corroboration of the confession, and the want, in their opinion, of such evidence, can you say that the prisoner is not fairly called upon to make defense? If so, your labor would end at this point. But if not, then you would naturally turn to the testimony by which he seeks either to destroy the case of the Commonwealth altogether, or to render it one of a doubtful nature, in which event he would be entitled to an acquittal. End of section 39. Section 40 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3 by John D. Lawson. Trial of John Hanlon for the murder of Mary Mohrman, Philadelphia, Pennsylvania, 1870, Part 7. Let us then examine the nature of the defense and the evidence by which it is supported. That defense is of a fivefold nature. First, the prisoner seeks to establish a defense in the nature of an alibi. Second, a second branch of this defense consists in an effort to prove the confession false by testimony intended to establish substantive facts inconsistent with the truth of the confession. Third, a third defense is based upon contradictions in the testimony of Caroline Dinglacker, established by the production of the notes of evidence taken before the coroner. Fourth, a fourth defense consists in the production of testimony calculated to lead to the belief that in this murder, if established, was committed by a person not the prisoner now on trial. Fifth, the fifth and last point of defense is based upon the evidence of witnesses, produced to prove that Dunn is not to be believed because he knew facts in relation to the murder before he saw Hanlon, and that he, Dunn, expected a pardon. The evidence upon all these points was carefully reviewed in detail by the learned judge, who in conclusion said, "We have thus commented upon the most material parts of the evidence in this cause. We cannot hope that we have specified every particular item, and we therefore request you to examine anxiously the whole testimony, weigh it candidly and impartially, conscientiously exercise your best judgment, and endeavor to come to a satisfactory conclusion. If a reasonable doubt exists, give the prisoner the benefit of it. This doubt must, however, be reasonable, such a one as would lead a man of common sense, if he were dealing with the ordinary business of life, to pause before coming to a conclusion. If upon candid and conscientious review of the whole testimony in this case, such a doubt arises, it operates to acquit. And now the fate of the prisoner is in your hands. If his guilt has been legally established, say so firmly and fix the grade or degree of the crime. If, however, the Commonwealth has failed to establish it beyond reasonable doubt, then, as her magistrates, we join in that prayer, which at the supreme moment of peril a humane government offers, as she directs her official solemnly to pause, and in reply to the plea of the prisoner to exclaim, "May God send you a safe deliverance." The jury at 8:30 retired. Not having agreed up to 10:30, the court was adjourned until 10 Wednesday morning, November 16th. November 17th. The jury not having agreed on Wednesday, the court was again adjourned until today. This morning, the 18th day since the trial, was marked by an immense crowd in the courtroom, every inch of available space being occupied and hundreds being turned from the doors after the room was filled. A few minutes after 10 o'clock, the jurors came into court. Mr. Galton, the clerk: "Gentlemen, have you agreed upon a verdict?" The foreman: "Yes." The jurors were directed to stand up. The same order was given to the prisoner. The clerk: "Prisoner, look upon the jury. Jurors, look upon the prisoner. Gentlemen, how say you? Do you find John Hanlon, alias Charles Hanlon, alias Charles E. Harris, the prisoner at the bar, guilty of the felony of murder whereof he stands indicted, and in the manner and form as he stands indicted, or not guilty?" The foreman: "Guilty." The clerk: "Of what degree?" The foreman, the first degree. Mr. Brewster asked that the jury be polled, and to the question put to each juror the answer came guilty of murder in the first degree. Judge Ludlow, gentlemen of the jury, I am about to discharge you from further attendance upon this court. Before doing so, I desire to return to you the thanks both of my brother Pierce and myself for the careful, attentive, and judicious consideration of this case. The sentence. December 10. Mr. Brewster having filed a motion for a new trial, it was today overruled by Judge Ludlow, whereupon District Attorney Shepard moved that sentence be pronounced. Judge Ludlow, John Hanlon, have you anything to say why sentence of death should not be pronounced? Hanlon, I have, and with the privilege of a book, I will introduce it. A Bible was passed to him by Mr. Brewster. Hanlon, by this book I will now introduce to your lordships what I have to say, and show you what has been done, and prove how my life has been sworn away by perjured witnesses. Oh, look at George Smith. How did he and Howard Perkins treat me? How was I beset by these men who tried to draw me into a trap? On the 6th of January, George Smith came into my cell, and what did he say? John, how are you? I'll tell you who I am. I might pass off for an inspector, but I won't. I am George Smith. Do you know me? Said I, No, I don't, nor do I want to know you. He looked at an Episcopal Bible that is in every man's cell, and said, What book is that, John? I said, One you'd better take with you and make good use of. He said, No, John, you'd better make use of it. He asked me about making shoes, and asked me what kind of a partner I had, and said, I know as much about him as you do. He said, Do you think I'd hold such a book as this in my hand, and say I didn't know a man I did know? Oh, George Smith, he was seeking my ruin. What were the oranges, the pipe, and tobacco for? Oh, the perjurer to swear away my life for $1,500, as Josh Taggart said, and Howard Perkins. And I shall die by murder, leaving behind me a heartbroken mother. I may say it has sent her to her grave. And my poor wife, what did she know about the slaying of Botany Bay? She could say nothing. And now I have one request to make, your lordship, and it's a dying man's request. If ever another such case should come to light, lay before the jury John Hanlon's last words, and let no more blood be spilt by perjury. When Hanlon closed, he kissed the Bible as if to give the sanctity of an oath to his words. Judge Ludlow, prisoner at the bar, if you ask by what authority we act, learn that we, as your judges, represent here today the sovereignty of this Commonwealth. Through us, she speaks to you. We do not desire to protract this sad scene further than to call upon you to measure the depth of your guilt. Thus, if possible, would we move you to seek for and obtain forgiveness. Upon a quiet Sunday evening, while, as an humble worshipper, the widowed mother of your victim sent up her prayers to God, her infant daughter, through your accursed lust, was put to death. Your fiendish passion heeded not the tears, the piteous moans, and the last beseeching glance, the awful terror of that defenseless child. She exchanged the agony of earth for the glory of heaven. The divine Master took her and folded her to his bosom. While we abhor your crime, we pity you. Your earthly hopes must now perish, for human forbearance has reached its limit. Our faith teaches us to believe that divine mercy is alone limitless, and covered all over as you are with the blood of a little child, to that mercy you must look for safety. As the rays of the morning sun penetrate your cell, remember that the business of your short life will be to repent. As the hours of each day swiftly glide along, and thus shorten your passage to the grave, earnestly study how to be forgiven. When the gloom of night settles around you, remember that the blackness of darkness will soon shroud you forever from mortal vision in the grave. We beseech, we implore you henceforth to live and breathe, and have your being as though each week and day and moment, with articulate voice, rang into your ear this solemn sentence, Prepare to meet thy God. And now nothing remains for us to do but to pronounce the judgment of the law, which judgment is that John Hanlon, alias Charles Hanlon, alias Charles E. Harris, the prisoner at the bar, be taken from hence to the jail of the county of Philadelphia, from whence he came, and from thence to the place of execution, and that he be there hanged by the neck until he is dead, and may God of his infinite goodness have mercy upon his soul. The execution. 2 or 3 weeks before his execution, Hanlon sent for George Smith, the detective, and when Mr. Smith entered the cell, Hanlon said his object in sending was to ask Smith to forgive him for what he had said in his speech in court when sentenced. Mr. Smith replied that he had long since forgiven him. Hanlon then requested Mr. Smith to see Detective Taggart and Michael Dunn, the witness, and to ask them also to forgive him. Hanlon added significantly, "You and I know how it was, and it's no use talking about the case now." The interview continued nearly a half hour, but no further reference was made to the case. For a time after his conviction, he had hopes of a commutation. When he sent for the detective, he gave up all idea of escaping the penalty and began a most rigorous penance. He deprived himself of the use of tobacco, strapped rough blankets around his body next to the skin to prick and goad the flesh. He walked barefoot on the stone floor, declined to sleep in bed, but lay on the cold floor without covering, and for a period of 17 days, up to the final day, took no food but bread and water. He was assiduous in his devotions, and was affable and pleasant to all who visited him. Fathers Barry and Mooney, both of the Roman Catholic Church, were his spiritual advisers, prepared him for death, and gave him absolution. He was hanged on February 1st, 1871, besides Sheriff Leeds, the officers of the prison, the sheriff's jury, deputies, physicians, the district attorney, the prisoner's counsel, the representatives of the press, were the only persons present. None of Hanlon's family attended. Hanlon ascended to the scaffold quickly and knelt between the kneeling priest, who still conducted the devotional services of the church, Father Barry reading and Hanlon with Father Mooney making the responses. When they rose to their feet, Father Barry said that he had been requested by the condemned man to state that he had no communication to make to the public further than that he desired to express his sincere thanks to the prison inspectors, keepers, and officers for their uniform kindness to him, and also to thank his counsel. Hanlon had intended to die in silence, but he changed his mind, and stepping forward, threw up his right arm and, gesticulating with it, said in a loud voice, which however faltered after he had uttered 2 or 3 words, "To those who have ever injured me or have ever done me any wrong, I forgive them and ask God to forgive them. And to all whom I have injured in any way whatsoever, or against whom I have had any ill feeling, I ask their forgiveness and God to forgive me." When the speech was ended, he shook hands with and bade good-bye to the clergy and sheriff. The priest descended to the ground, and the sheriff and officers adjusted the noose around the neck, the white cap over the face, and the manacles on the hands, Hanlon doing what he could to aid them. The priest, kneeling on the stairway, held up the crucifix. Hanlon exclaimed in a low, moaning, anxious voice, "Jesus, have mercy upon me. Holy Mary, pray for me. Saint Joseph, intercede." The cord was pulled by the sheriff, the platform fell, and Hanlon, falling, was choked as his last earthly prayer was uttered. End of section 40. Section 41 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3 by John D. Lawson. Trial of William Boott for delivering a challenge to a duel, Boston, Massachusetts, 1834. The narrative. Not only in the South and Southwest, but even in the New England states, challenges were sent and duels were fought a little over 75 years ago, and this is in the face of statutes prohibiting and severely punishing both acts. In a political quarrel, Robert C. Hooper had challenged John S. Jones to fight a duel in Rhode Island, and the duel was actually fought. William Boott was a friend of Hooper. He had gone with him and had been his second on the field. So when the parties returned, Boott was indicted under the Massachusetts statute for unlawfully delivering the challenge. But at the trial, the prosecution had a hard time of it. None of the witnesses could remember much of the affair, and nothing of Boott's connection with it, and the jury promptly acquitted him. The trial. In the Municipal Court, City of Boston, June 1834. Honorable Peter O. Thacker, Judge. June 15. The indictment previously found by the grand jury under Massachusetts Statute of 1804, Chapter 123, Revised Statutes 125 and 7, charged that Robert C. Hooper on the 29th day of January 1834 at Boston did unlawfully and maliciously by a written message provoke, excite, and challenge one Joseph S. Jones to fight a duel with him, said Hooper, with dangerous weapons, to it with pistols, no duel being or having been fought thereon within said Commonwealth of Massachusetts, and that the said William Boott did become and then and there voluntarily and knowingly was a second, agent, and abettor of him, the said Hooper, in the giving, sending, and delivering of the challenge and message aforesaid from the said Hooper to the said Jones, against the peace and contrary to the form of the statute in such case made and provided. Mr. Parker for the Commonwealth, Charles P. Curtis for the defendant. Witnesses for the Commonwealth. Reverend E. S. Gannett, am acquainted with Mr. Hooper, saw a portion of the correspondence, heard him read some papers signed by himself and some which were signed by Mr. Jones or Captain McNeill, did not read the signatures. They related to the difficulty which had taken place, not to a duel. He stated that a duel took place in consequence between himself and Mr. Jones. I never knew who were seconds except from public rumor. I never conversed with Mr. Boott, had but one conversation with Mr. Hooper. Cross-examined. Could not identify the papers he read, because I had seen some of them before in others' hands, and I think it would be difficult for me to say which he read to me. Mr. Boott was not present at that interview, saw no original letter, and have no recollection of seeing any copy of a letter signed by Mr. Jones. Cannot swear that I saw any letter addressed to Mr. Jones. Joseph H. Buckingham had two conversations with a gentleman whom I supposed to be Mr. Hooper. The first conversation was in a barber shop, and we adjourned into my office. Am junior editor of the Courier. The conversation related to a duel. Mr. Parker. Did Mr. Hooper say he had fought a duel? Mr. Curtis. Mr. Boott is not to be tried or convicted by the declaration of Mr. Hooper or any third party when he, Mr. Boott, is not present. So far from Mr. Boott being party or privy to Mr. Hooper's statements, the testimony which Mr. Buckingham is apparently about to make is a complete surprise. Thacker, J. As the jury must be satisfied that a challenge was sent by Robert C. Hooper, any evidence tending to prove his guilt is admissible, although he is not upon trial. Even if Robert C. Hooper had been tried and convicted of the principal offense, in which case the record of his conviction would be admissible evidence of that fact upon this trial, it would yet be competent for the defendant to contest the fact of the guilt of the principal and to offer evidence to prove his innocence. Mr. Buckingham. I left the barber shop first, and he followed to my counting room. The gentleman in the shop came and handed me a paper which he wished me to read. Read it, put it in my pocket, and told him I would be in my office all the forenoon. He followed me to my office. The paper related to a duel, and I advised him to drop the matter. Presumed he wished to have the paper published. It had no signature. He did not say who was the challenger. He said the duel was fought with a Mr. Jones. Do not remember whether the paper said that Mr. Jones was the person with whom he fought. I should not know the paper again. Saw it was a very improper one to publish and handed it back to him. Do not know Mr. Boott. Cross-examined. The paper was not a correspondence. It was a statement of the facts which led to the duel. The duel, he said, was fought in Rhode Island. William G. McNeill. No, Robert C. Hooper. Never had any conversation with him about a duel fought in Rhode Island. Was not present at the duel. Do not personally know that Mr. Hooper challenged Mr. Jones. Do not recollect to have seen any correspondence between Mr. Jones and Mr. Hooper. Do not know who were the seconds, except from rumor. Have never had any conversation with Mr. Boott about any duel, nor about the challenge. Don't know that Mr. Boott was agent, second, or abettor in sending a challenge to Mr. Hooper. General H. A. S. Dearborn had a conversation with Mr. Hooper previous to the duel, and understood from the conversation that he had challenged Mr. Jones. Don't know that I ever spoke to Mr. Boott until after the duel took place. Saw him once after the duel, and that was accidentally in the street. He then gave no information that he had been second or carried the challenge or had taken any steps in sending the challenge. Mr. Parker, is it not unusual that the person who acts as second carries the challenge? Thacker, J. Whatever is usual on such occasions, it might so happen that in this instance, if any challenge was given, it was not in writing, and that it had been carried by someone else. Whatever the defendant has done, whether within the county of Suffolk or elsewhere, may be proved, but it will be necessary to prove some act done within that county in order to bring the offense within the jurisdiction of the court. If the challenge was written within the county and sent out of it, or if it was written out of the county and sent into it, it will be sufficient to sustain the jurisdiction of the offense. Crimes are in their nature local, and if not proved to have been committed within the county where they are laid, the party accused is entitled to a verdict of acquittal. Where a misdemeanor consists of distinct facts, the whole can be tried in the county wherein any distinct part can be proved to have been done. It was said by Abbott J. in pronouncing an opinion on this point in the case of Rex versus Sir Francis Burdett, 4 Barn and Ald 180. I am clearly of opinion that if any such part of an entire misdemeanor be proved to have been done in the county in which the indictment is preferred, there is enough to satisfy the locality of trial. In this case, the charge against the defendant is for acting as second in the giving, sending and delivering the challenge to Hooper. He is not on trial for acting as a second in fighting the duel. That act, having been done without the Commonwealth, was not an offense against the law of this Commonwealth. It ought to be shown that the defendant advised, dictated, wrote, or carried the challenge, or that he arranged the preliminaries of the meeting which afterwards took place in Rhode Island, or that he procured the pistols or did some other act within this county from which the charge in the indictment could be fairly inferred. Otherwise he must be acquitted. I cannot therefore permit the question to be answered. General Dearborn, I never saw Mr. Boott and Mr. Hooper together in my life. Cross-examined. Mr. Hooper was at my house when he told me he had challenged Mr. Jones. It was 1 or 2 days before the duel took place. My house is in Roxbury. Dr. H.G.R. Dearborn. Know Mr. Hooper. Understood from him that he had challenged Mr. Jones. Don't know who carried the challenge or whether it was in writing. Was not present when the battle was fought. Went to Rhode Island about the time. I did not go in company with any of the parties. Returned with Mr. Boott and Mr. Hooper. Joined them at the halfway house in Walpole. Believe they arrived there first. I had no one with me from Rhode Island to the house but the driver, and thence to Boston with Mr. Boott, Mr. Hooper, and the driver in a 4-wheeled carriage. We took supper at the halfway house, it being after dark. They stated there had been an exchange of shots. Remember nothing respecting loading the pistols. Don't recollect that it was said in Boot's presence who fired first, or who gave the word of command. Do not know who came with Mr. Hooper to that house, as I did not see them get out. Mr. Boott got into the carriage with Mr. Hooper in town to go out. Knew something of the quarrel, but I had no conversation with Mr. Boott about it. Do not know who carried the message to Mr. Jones. Don't remember that Mr. Boott ever said anything about carrying the challenge or about the manner of fighting. He told me that he thought it was probable a duel would take place. Thought he was the friend of Mr. Hooper, but cannot say upon what that inference was founded. Know of no other person who acted as Mr. Hooper's friend. Cross-examined. Mr. Hooper and Mr. Boott did not get into the carriage together in Boston, but in Roxbury. Heard no conversation on the road before the duel. Did not accompany them at all to Providence. Went to Providence with a letter to Mr. Boott. Don't know what the letter was. Did not receive it from Mr. Jones. Met them at the halfway house accidentally and not by concert. Never heard Mr. Boott say that he carried the challenge to Mr. Jones. Don't know how long it was before the duel that I saw Messrs. Boott and Hooper in the street together. Do not know that the challenge was in writing. Left Providence 2 or 3 hours after I arrived there to come home, and did not see the gentlemen on the road until I found them at the halfway house. It was said that the exchange of shots took place in Rhode Island. Was not the medical friend of either party. Did not know that they had pistols at my father's house. Don't think that Mr. Boott provided Mr. Hooper with pistols. Jones lived at the Tremont house. Daniel Parkman. Do not know that Jones and Hooper fought a duel. Never had any conversation with Mr. Boott. Had a process against Hooper and Jones. Know nothing which implicates Mr. Boott. Captain William A. Howard. Mr. Hooper admitted to me that he had fought a duel with Mr. Jones, Know nothing about Mr. Boott. Saw the challenge. It was written and signed by Mr. Hooper. Saw Mr. Boott and Mr. Hooper together about this time. Have no recollection of any conversation between them about Mr. Jones. Know nothing which Mr. Boott has said or done which leads me to believe him to have been a second. Think that Mr. Boot's name was not in the challenge. Don't know who went on the ground with Mr. Hooper. The challenge was in Mr. Hooper's possession when I saw it. Don't know that it was ever sent or that Mr. Hooper ever said that the challenge was sent. Henry W. Sargent. Had some conversation with Mr. Hooper previous to the duel. Knew from him that he and Jones were about to fight. Know nothing from Mr. Boott. Did not see Mr. Boott from the Monday previous to the duel, which was on Friday, until day before yesterday. Thomas K. Davis. Know Mr. William Boott and Mr. Jones. Know nothing of this business except what I know as professional advisor of Mr. Jones, and my interview with Mr. Boott was in consequence of this relation which I bore towards Mr. Jones. Mr. Boott was no client of mine. Went to see him a week or 10 days after the duel, having heard that Mr. Hooper had been very imprudent in his statements, and asked him to advise Mr. Hooper to be more prudent, as both were under heavy bonds to keep the peace. Mr. Boott concurred with me in opinion. We then went into general conversation upon the events of the duel. Remember, he said a duel had been fought in Rhode Island. I understood from him that he was second to Hooper and Gibbs second to Jones, that the weapons were pistols and that both parties fired. Do not remember that he said who were on the ground. He said nothing about the challenge. Think he said the word was given by Mr. Gibbs. Never saw the challenge. Do not know who gave the challenge to Mr. Jones. Whether we regard the interest excited at the time or the effect upon the parties under the law, this is a very important case as it regards the law of the land. It is undoubtedly an offense to carry a challenge. Still, you must look into the evidence without favor or affection. There is no evidence introduced for the defendant, and he rests solely on the defects of evidence in the government. You must forget all that is said out of doors, and confine yourselves to the evidence before you. The indictment, in the first place, charges Robert C. Hooper with having committed the offense of sending a challenge in this county, and secondly, it charges the defendant as aiding and abetting him in that act. You must take no notice of offenses in another county or in another state. Both may be guilty, or Hooper may be guilty, and the defendant innocent. Are you satisfied that Hooper wrote such a challenge and caused it to be sent? Both Hooper and Jones lived in the same house, and in that house Hooper had in his possession a written challenge directed to Mr. Jones, and soon after the parties meet and exchange shots. You must first inquire if the offense of sending the challenge in this commonwealth is merged in the offense of fighting the duel in another state. But I consider the sending a challenge to fight is a substantive offer, whether the duel is to be fought here or elsewhere. We know not whether fighting a duel in Rhode Island is an offense. Probably it is, but it does not appear that the parties have been charged with the offense in Rhode Island. If they had been tried there, then the question would have become one of more consequence. They then would appear to have been tried as well as for the act as for the preliminaries. To allow this objection to prevail would be to instruct our citizens how to evade the laws. Satisfy yourselves, then, whether Hooper gave a challenge in this county. If he did, then so much of the indictment is proved. But the defendant is charged not for Hooper's act, but for his own. Are you, from the evidence, satisfied that the defendant in this county acted as second in aid to Hooper? Was he seen in company with Hooper dictating, advising, or carrying the challenge? Did he adjust the preliminaries or procure the pistols? I cannot find one of these things proved. Dr. Dearborn says he saw them once together in the street, but they started together from General Dearborn's in Roxbury, and they were together in Providence. But you are to say if he did anything in this county. If you find him guilty, you will say that his agency commenced in a material respect in this county. It is a question of fact for you to settle. If you have doubts as to any of the points which must be proved to constitute the offense, they must operate in his favor, and then you must acquit him. Otherwise, you must find him guilty. The jury returned a verdict of not guilty. End of section 41. Section 42 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3 by John D. Lawson. Trial of Robert C. Hooper for sending a challenge to a duel, Boston, Massachusetts, 1834. 2 months after the trial of Boott for delivering the challenge, Robert C. Hooper was tried for sending it, but the evidence being about the same as in the Boott case, ante page 370, and quite as unsatisfactory, Hooper was acquitted also. The trial in the Municipal Court, City of Boston, August 1834. Honorable Peter O. Thatcher, Judge. August 11. An indictment under the same evidence as that in the Boott case, ante page 370, was returned at the February term 1834 against Robert C. Hooper for sending a written challenge to fight a duel to Joseph S. Jones. The same counsel were employed as in the Boott case. Witnesses for the Commonwealth. Captain W. A. Howard was in defendant's room at the Tremont House. Defendant showed me a letter which he had written to be sent to Jones. Saw at the same time several other letters, but only one addressed to Jones. It was a call on Jones for an apology for an insult offered by him to defendant on a former occasion. I advised defendant to alter some of the expressions, which I thought too severe, and defendant did so. Did not know that defendant had sent a challenge to Jones, and had not heard defendant say that he had done so. Might, on the trial of William Boott, have said I had seen a written challenge from Hooper to Mr. Jones. Think I had confounded the correspondence between defendant and Captain McNeill with that between the defendant and Mr. Jones. Cross-examined. Recognized the paper which defendant showed me, on which was written the letter to Jones, which was afterwards cancelled, and underneath it, in the original draft of the letter which was subsequently sent, the letter was in these words: Tremont House, Tuesday morning. Having terminated my affair with Captain McNeill, I now offer you an opportunity of apologizing to me for your expressions and conduct on Saturday evening. It was subscribed by defendant and addressed to Mr. Jones. Henry W. Sargent, about 3 o'clock on the day when above letter was sent, saw the defendant get into a coach to go to Charleston, and defendant stated to him that he did so to avoid breaking the peace of this county or state. Defendant told me that Jones had agreed to fight him or to meet him, cannot recollect which. Mr. Parker then put in written statement of the testimony of 4 witnesses, Gannett, Buckingham, H.A.S. Dearborn, and H.G.R. Dearborn, from the minutes taken at the trial of Boott, all of whom are either permanently or temporarily absent from the Commonwealth, and by whose testimony was admitted by defendant. Counsel for the defendant contended that the government must prove 1. That the challenge was in writing, 2. That it was in the possession of the defendant who had been required to produce it at the trial, or that it had been by him destroyed, and 3. That no duel had been fought within this Commonwealth. He read in evidence a certified copy of the law of Rhode Island against dueling. It was authenticated by the signature of the Secretary and was under the seal of the state. Thatcher J. Gentlemen of the jury, you will consider the case on trial without regard to public reports or to anything which you have heard or read before the trial. You are to render your verdict not according to a general and undefined belief of what may have been done, but upon the law and evidence. Upon the general subject of dueling, it is sufficient to add what has already been said with so much ability, that whoever takes the life of another in a duel voluntarily engaged in, whether he gave or received the challenge, and under whatever circumstances of provocation, is deemed in law guilty of murder, unless the duel was fought under such circumstances, immediately following the provocation that it might be considered a homicide in heat of blood, upon a sudden falling out between the parties which might reduce the offense to manslaughter. The indictment is founded on the following clause in the 6th section of the Act of 1804, Chapter 123. If any person shall by word, message, or in any other manner challenge another to fight in a duel, as aforesaid, when no duel shall be fought thereon, he shall be punished as a felonious assaulter, etc. To understand the nature of the offense and the meaning of the phrase, as aforesaid, we must recur to the preceding clause of the section. If any person shall voluntarily engage in a duel with rapier or small sword, back sword, pistol, or other dangerous weapon to the hazard of life, when no homicide shall ensue thereon. The challenge must be to fight with a dangerous weapon to the hazard of life. A challenge to fight a boxing match with fists would not be within the statute, because it would not be considered a deadly rencounter with a dangerous weapon. The challenge may be given by word or by a verbal message communicated by a friend of the challenger. Or it may be in writing, delivered by the party himself, or sent by a third person, or it may be given in any other manner by which it may be understood that one challenges or provokes another to a deadly contest. The offense may be described in all these ways, or in any of them, according to the fact. But as they may be uncertain, it may be described in each of these ways in separate counts, so as to meet the evidence at the trial, in any aspect in which it may then appear. The legislature can punish only those violations of peace which are committed within its own jurisdiction. Whatever crime is done in another state is against the law of that state and punishable there only, but high treason may be committed out of the limits of the Commonwealth. It consists in levying war against the state to which we owe allegiance, and from which we are entitled to claim protection. This may be done by a citizen within its territories or by joining himself to its enemies, and committing acts of hostility against his own country. The challenge to fight in a duel must be given within this Commonwealth. The law does not say where it is to be fought, and therefore I consider that it is not material whether it is to be fought within our own Commonwealth or within a foreign state. If a duel is fought upon such challenge within the Commonwealth, the offense of sending the challenge is merged in the act of fighting the duel, both acts being committed against our own law. But where no duel is fought within the Commonwealth, no offense is committed against our law, but that of sending the challenge. If the duel is fought out of the Commonwealth, then as our peace is not violated by that act, there is nothing in which the offense of sending the challenge can merge. It would not be reasonable to say that no offense has been committed against our laws because a greater offense has been committed against the laws of another state. The laws of both are violated, and each may exact the penalty when the offender can be found within its limits. It is a mere act of discretion whether the state will punish the offender for the minor offense, committed within its own limits, after he has suffered perhaps an adequate punishment for the greater offense, committed within the limits of a foreign state. These being the general principles of law, we are next to look at the indictment, which contains a description of the offense. In describing an offense against a statute, it is necessary to bring it within the letter of the statute. But that the party accused may be enabled to prepare for his defense, it is always necessary to show the manner in which an unlawful act was done, as well as the time when, and the place where, it was done. The verdict of the jury is to be composed of what is alleged and what is proved, and to establish the guilt of the accused, the proof must, in every material respect, support the allegations. In this indictment there seems to be a double description of the offense, one of which is nearly in the words of the law and is undoubtedly sufficient. It is in these words, that R.C.H. on, etc., etc., intending to kill and murder one J.S.J., did unlawfully and maliciously by written message challenge the said J.S.J. to fight a duel with him and H. with dangerous weapons, to wit, with pistols, no duel being or having been fought thereon against the peace and contrary to the form of the statute, etc. But for the sake of a more full, and as it was undoubtedly deemed by the learned and faithful attorney of the government, by whom it was drawn, a more accurate description of the offense, the indictment goes on from the word pistols to repeat the allegation relative to the challenge, and adds, and that he, the said R.C.H., a certain challenge in the name of him, the said H., and in the form of a written message to him, the said J., directed, exciting and provoking him, the said J., to fight a duel with the said H., did then and there wilfully and maliciously write and direct the cause to be written and directed, which said challenge and written message was then and there concealed and destroyed by the said R.C.H., or some other person to the jurors aforesaid unknown, so that they cannot set forth the tenor or the substance thereof, and that he, the said R.C.H., the said written message, did then and there wilfully and maliciously send and deliver and cause and procure to be sent and delivered to said J., no duel being or having been fought thereon within said Commonwealth of Massachusetts, against the peace, etc., and contrary to the form of the statute. If you are satisfied from the evidence that a written message was sent by the party to H within this county, you will be authorized to find a general verdict of guilty, although the written message is not produced nor evidence given of its destruction, and notwithstanding it shall appear that the duel was fought within the limits of a foreign state. The government is not presumed to have the original challenge in its possession, and it seems to account sufficiently for its non-production that all the parties concerned, principals and seconds, are indicted for the offense. Where the offense consists in making the paper itself, as in forgery of an instrument, the written paper should be produced or its absence accounted for. Because, whether it was a deed or a note, whether it was written the statute or at a common law, and whether genuine or counterfeit, may be important questions at the trial. A challenge may be verbal or written. The offense consists in sending the message, not in the form in which it is sent. By averring that a challenge was in writing, the government makes that fact material to be proved. But the express language is not necessary. It will be sufficient to prove the substance of the message, and that the party sent it. Because it will be equally an offense, whether it was in words or in writing, it was wholly unnecessary to aver that no duel was fought within the Commonwealth, because the offense was committed by sending the challenge, and the legislature have not undertaken in this act to prescribe a punishment for any offense committed without the limits of this Commonwealth. The expression within said Commonwealth of Massachusetts is not in the statute, but is inserted by the grand jury in the indictment as the construction which they gave to the phrase no duel being or having been fought thereon. The indictment would have been sufficient without it, and it was therefore unnecessary to be inserted and need not be proved, for allegations which are not essential to constitute the offense and which may be omitted without affecting the charge or vitiating the indictment do not require proof and may be rejected as surplusage. The government is not bound in this case to prove that no duel was fought within this Commonwealth. In indictments founded on statutes, if there be any exception contained in the same clause of the act which creates the offense, the indictment must show negatively that the defendant or the subject of the indictment does not come within the exception. If, however, the exception or proviso be in a subsequent clause or statute, or although in the same section, yet if it be not incorporated with the enacting clause by any words of reference, it is in that case matter of defense for the party and need not be negatived in the pleading. In indictments upon statutes where an exception or proviso is mixed up with a description of the offense in the same clause of the statute, the indictment must then show negatively that the party or the matter pleaded does not come within the meaning of such exception or proviso. These negative averments seem formerly to have been proved in all cases by the prosecutor, but the correct rule upon the subject seems to be that in cases where the subject of such averment relates to the defendant personally, or is peculiarly within his knowledge, the negative is not to be proved by the prosecutor, but on the contrary, the affirmative must be proved by the defendant as matter of defense. And that is, the defendant must prove those facts from which the jury must infer the negative matter. But on the other hand, if the subject of the averment do not relate personally to the defendant, or be not peculiarly within his knowledge, but either relate personally to the prosecutor, or be peculiarly within his knowledge, or at least be as much within his knowledge as within the knowledge of the defendant, the prosecutor must prove the negative. But as this court cannot take cognizance of any offense which is not committed within the limits of the county of Suffolk, it is essential that it should be proved that the challenge was set within this county. If, however, any material fact constituting that offense was done here, it will be sufficient. For all matters of crime are so local that if be not proved to be done in the county where it is laid, the party accused is as innocent as if he never had done the thing. It appears in evidence, and was admitted by the counsel on both sides, that the duel was fought within the state of Rhode Island, and also that Hooper gave the challenge, but it does not appear by any direct evidence where the challenge was given, nor whether it was verbal or in writing. It is for you to say whether such circumstances appear as satisfy you that a written challenge was sent within this county. If the challenge was written here and sent to another county, or if it was written elsewhere and sent into this county by the defendant, it will be sufficient. The burden is upon the government to prove the fact. Because the duel was fought in Rhode Island by two persons residing in Boston, it by no means follows that the challenge was sent within this county. Nor, because it is assumed that the fact is known to the defendant, is he required to show where the challenge was sent, because a man may rest on his own presumed innocence, and no man is bound to accuse or give evidence against himself, nor ever to give evidence in denial or extenuation of a fact charged against himself until the prosecutor has made out a probable case of guilt. The jury returned a verdict of not guilty, and the defendant was thereupon discharged. End of section 42.
Section 43 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Harris Seymour, Moses Roberts, Holloway Hayward, Henry Howard, and James Ganson, for the abduction of William Morgan, New York, 1827, Part 1. The narrative. In 1826, a bricklayer named William Morgan, who lived in Batavia, New York, and was very poor, and who belonged to the Masonic Society, conceived the idea of earning some money, or satisfying a personal grudge by writing an exposure of the secrets of Masonry. Footnote. Morgan was born in 1776 in Culpeper County, Virginia. By trade, he was a stonemason and bricklayer, but saving up a little money, he opened a small shop in Richmond. He moved to York now Toronto, in Canada, where in 1821 he became a brewer and was acquiring a confidence when a fire reduced him to poverty and forced him to remove to Rochester and then to Batavia, New York, where he resumed his trade. He became a member of the Lodge of Masons at Leroy in 1825. Different reasons have been given for his subsequent hostility to the order. One is that in 1826 he signed a petition for the establishment of a chapter at Batavia, but objection was made to his signature because if the charter was granted, he would become a member of the new lodge, and he was not desired. So a new petition was drawn up and signed without being shown to him, and when the charter was issued and the chapter was organized, he was deeply mortified to find that he was not a member. He at once determined to be avenged not only on his fellow townsmen, who had excluded him, but on the whole Masonic fraternity, by writing a book revealing the secrets of Masonry. 5 McMaster History, People of the United States, 109. A newspaper of the period gives another reason. The fact is, as we heard it from a gentleman who heard it from Captain Morgan's own lips, that ill-fated martyr to liberty had been a brave officer in our army, and in that capacity had traveled over the Union, and been conversant with all the lodges and chapters. He had counted the number of Masons, and found it alarming. He had penetrated all their dark intrigues and maneuvers by which they had contrived for years to monopolize all the honors and emoluments of the government. He had discovered 1,000 proofs of their undue influence and management, and he was bent upon preparing as a continuation of his illustrations of Masonry, a full and luminous development of all these things, and it was to prevent him from going on with this work, more than to punish him for what he had done, that his death was determined on. He told our friend that he considered it a sacred duty which he owed to his country, to unveil the plots and intrigues of the order, which were, he said, equal to those of the Jesuits in cunning and duplicity. That he knew he should risk his life and in all probability lose it. But, said he, I am old and cannot live much longer, and I can do little good in any other way than that which I propose, and do it I will, let the consequences be what they may. The generous and gallant patriot, the glorious and exalted martyr in the cause of freedom, did not live to do what he intended, but the purity of his intentions and the awful consequences to himself of making them known are now sufficiently brought to light to entitle his memory to our everlasting veneration and gratitude, and his persecutors and assassins to the detestation and abhorrence of the present and of all future generations. Reported the trial, New York, 1827, Post. End of footnote. He obtained a publisher in the person of Mr. David C. Miller, the editor of a local newspaper. The Masons, learning that he had written such a book and had obtained a publisher, caused his arrest and imprisonment on a frivolous complaint, and searched his house for the manuscript in his absence. Later he was arrested again for a debt of $2 and imprisoned under an execution for the debt and costs. The next evening a man named Lawson appeared at the jail, paid the debt, and persuaded the wife of the jailer, who was absent, to release him. At the door he was seized by a number of men, and despite his struggles and cries was hurried into a carriage and taken to Fort Niagara, at the foot of the river, which was unoccupied at the time, and placed in a cell. At this place all trace of him disappears. He was never seen afterwards. Some months later a body was found floating in the river, and identified by several persons as the body of Morgan. But this the Masons stoutly denied, and the body was afterwards identified as that of a missing Canadian. In the meantime, great efforts had been made to obtain the manuscript of the book. Alarmed for the safety of her husband, Mrs. Morgan, the next day after his abduction, departed from Batavia to Canandaigua, under the pretended protection of 2 Masons, who agreed to bring her to him on condition that she would give them certain manuscripts, which he had directed her to keep safe. Here she was detained, Her fears magnified until the manuscripts were obtained by the men, when she and her infant were sent back to Batavia in the stage. A few hours later, a crowd of men with clubs appeared and forcibly seized David C. Miller on a pretended criminal process issued by a justice in the county and carried him to an adjoining village, where he was detained until dark, locked in a room and guarded by 5 men. When his friends and counsel at last found him, and he was brought before the justice, it appeared that the process was a civil suit, and no one appearing to prosecute it or to declare the cause of action and no warrant being returned, he was discharged. A few days later, his printing office was discovered to be on fire, with all the marks of an incendiary. Such a series of outrages in which the fraternity seemed degraded into a lawless mob, for the subversion of civil rights and personal liberty, could not fail to arouse the people. Public meetings were held in most of the towns and counties near the scene of action. Addresses voted and committees of investigation appointed. Indictments were found against a large number of the suspected persons, and rewards were offered for information as to the whereabouts of Morgan and for the discovery of the offenders by the local authorities, the governor of the state, and the lieutenant governor of Upper Canada. At the court held at Canandaigua in January 1827, Lawson and 3 others were found guilty on their own confession of the abduction of Morgan from Batavia and sentenced to imprisonment in the county jail for different terms, from 2 years to 1 month. In August, Harris, Seymour, and 11 others were tried on the same charge, but acquitted. The public charged that the defendants on the first trial had pleaded guilty to prevent the investigation of the crime, and that the jury in the second had been mere tools in the hands of the Masons. The opinion that Morgan had been murdered and that the body found in the Niagara River was his took possession of a large number of the people of the surrounding country, notwithstanding the verdict to the contrary of a coroner's jury, and a violent wave of indignation against the Masonic fraternity spread through New York and the adjoining states. Anti-Masonic societies were formed on all sides, and they resolved themselves into a political party. The anti-Masonic party entered the arena of national politics, nominated William Boott of Maryland for President of the United States, and carried one state, Vermont, in the election of 1832. The trial. Footnote: Bibliography. The trial of James Lackey, Isaac Everston, Chauncey H. Coe, Holloway Hayward, Hiram Hubbard, John Butterfield, James Ganson, Asa Nolan, Harris Seymour, Henry Howard, and Moses Roberts for kidnapping Captain William Morgan at the Ontario General Sessions, held at Canandaigua, Ontario County, August 22, 1827. Nor wife nor children more shall he behold, nor friends nor sacred home. New York, printed for the publishers, 1827. Illustrations of Masonry by one of the fraternity who was devoted 30 years to the subject, with an account of the kidnapping of the author. New York, printed for the author, 1827. End of footnote. In the Ontario General Sessions, Canandaigua, New York, 1827. Honorable Nathaniel Howell, Honorable Micah Brooks, Honorable Alfred Loomis. Judges. Footnote: Howell Nathaniel, 1770 to 1851. Representative in Congress, New York, 1813 to 1815. Died Canandaigua, New York. Brooks Micah, 1775 to 1857. Born Cheshire, Connecticut. Justice of the Peace, New York, 1806. County Judge, 1807 to 1827. Member of Assembly, New York, 1808 to 1809. Congressman, 1815 to 1817. Member of State Constitutional Convention, 1821. Presidential Elector, 1824. Loomis Arfashad, 1798 to 1885. Born Winchester, Connecticut. Member of Legislature, New York. Member of Congress, 1837 to 1839. End of footnote. August 22nd. The following persons had been indicted by the grand jury for conspiracy and abduction. The indictment contained 4 counts. First, for conspiracy to assault, false imprisonment, kidnap and carry away to parts unknown, William Morgan. Second, for a conspiracy to carry him to parts unknown. Third, for the forcible abduction and kidnapping of him. Fourth, assault, false imprisonment and carrying him away out of the jurisdiction of the state. Mr. Whiting, District Attorney, Jared Wilson, Bates Cook, John Dixon, O. Benjamin, and T. F. Talbot for the people. Footnote. Cook, Bates, Representative in Congress, New York, 1831 to 1833. State Controller, 1839 to 1841. Bank Commissioner, 1840. Died 1841. Dixon, John, 1783 to 1852. Born Keene, New Hampshire, Member of Congress, New York, 1831 to 1875. End of footnote. General Marvin, General Matthews, M. H. Sibley, H. F. Penfield, D. D. Bernard, Ebenezer Griffin, W. H. Adams, and W. Hubble for the defendant. Footnote. Marvin, Dudley, 1786 to 1856, born Lynn, Connecticut, Representative in Congress, New York, 1823 to 1829, 1847 to 1849. Sibley, Mark Hopkins, 1796 to 1852, born Great Barrington, Massachusetts, Member Assembly, New York, 1834-1835, State Senator, Member of Congress, 1837 to 1839, County Judge, 1846. Bernard David Dewey, 1797 to 1871, born Sheffield, Massachusetts, District Attorney, Monroe County, New York, 1826, Member of Congress, 1827 to 1829, 1839 to 1845, United States Minister to Prussia, 1850 to 1853, author of numerous reviews and speeches. Hubble, William S., born New York, Member Assembly, New York, 1841, Congressman, 1843 to 1845. End of footnote. Mr. Whiting, District Attorney, called the defendants, viz. Harris Seymour, James Lackey, Isaac Everston, Chauncey H. Coe, Holloway Hayward, Hiram Hubbard, John Butterfield, James Ganson, Asa Nolan, Henry Howard, and Moses Roberts, and moved for their trial. General Marvin said that he should move separate trials for certain of the defendants. The court suggested an arrangement with the counsel for the people. Mr. Whiting said that he had reflected upon the propriety of trying the defendants separately, and designed to try Everson and Hubbard together after the trial of the others, the guilt or innocence of all the defendants resting as it did upon the same facts and evidence. The propriety of trying them together must be apparent to all. Several trials would consume more time than the court could devote to criminal business. General Marvin asked the court for 4 separate trials, putting Hubbard, Coe, and Lackey in the first, Ganson in the second, and Nolan and Butterfield in the third, and the other defendants in the 4th class. The court, at the suggestion of the district attorney, directed that Seymour, Roberts, Howard, Hayward, and Ganson be tried first, and the others together subsequently. The following jurors were then impaneled: Ira Case, Allen Brown, Isaac T. Holmes, John Nicholson, Josiah Moff, John Motehill, Gideon Hurd, Anson Howell, George Brudbridge, William K. Pound, Jeremiah Like, Adonijah Skinner. Several others were drawn on the jury but asked to be excused from serving, as they had made up their opinion as to the guilt of the defendants. Mr. Whiting, to the jury. Nearly an entire year has passed away since the abduction of William Morgan, and yet we have no knowledge of his fate. If it was proper to bring the perpetrators of that crime before courts of justice to answer for the breach of laws and to receive punishment for their great and unparalleled violation of the liberty of the citizen, it is now more proper than ever, for time has confirmed our fears and left the community fully justified in the belief that their worst apprehensions for Morgan's fate had been well founded. It is therefore just and proper that these prosecutions should be persisted in till the laws are vindicated and the guilty brought to punishment. There is one advantage, however, which we can do and derive from lapse of time in relation to our inquiries. The excitement which follows the commission of great offenses has in some degree subsided, and though our views of the enormity of the transaction are the same, yet now when passion is silenced, we can deliberate upon this subject with calm and sober judgment, and in whatever we may do, we proceed with that dispassionate reflection which should always mark the conduct of men deliberating upon great and serious subjects, and the right decision of which concerns the best interest of public liberty and the private security of the citizen. The crime, with the commission of which the defendants stand charged, is that they conspired together to secure and falsely imprison William Morgan, that in pursuance of such conspiracy, they seized him by force and carried him against his will, and without any legal warrant or justifiable cause, to parts and places without the territory and jurisdiction of the state of New York, and in one count to parts and places unknown. They were also charged with having assaulted him, seized him, falsely imprisoned, secreted and detained him from the day of his capture to the time of finding the indictment. These charges constitute the offenses committed by the defendants and others against the laws of the state, in the forcible and violent abduction and detention of this man, as the law existed at the time of committing the offense. In order to prove a conspiracy, it is not necessary to establish the fact that a conspiracy was actually formed and a precise agreement entered into. The conspiracy and confederacy among men to effect an unlawful purpose is derived and inferred from their acts and conduct, and hence if it be established that two or more men are committing acts which tend to the perpetration of a crime or to injury of an individual, the law infers that they act in pursuance of an agreement previously formed, and there is good reason for this rule, for if the prosecutor were held to prove a positive agreement among conspirators, justice would in almost every instance fail. Men do not call witnesses to their criminal intents and conduct. Offenses are designed and generally committed in secret, and in such manner as to elude observation and detection. The rule, therefore, in this case, is one of necessity and of salutary effect, and by it your views of the offense charged on the defendants will be governed. The facts which gave rise to the conspiracy which, I am authorized to say, existed among the defendants and others, are briefly that William Morgan was compiling a book professing to reveal the secrets of masonry, which book was printed in Batavia by David C. Miller. The means of suppressing or preventing the publication of that book was the subject of deliberation among Masons in various parts of the country, and we expect to be able to show that it was determined that the only effectual mode of preventing that publication was the removal of the man, or having the power over him to prevent his agency in the work. If they could have obtained possession of the papers then prepared by him, he would have written others, so that without the power of preventing his ability to write, their project would have been useless. In pursuance of this plan and governed by these views, we say that these defendants procured a warrant for Morgan from a magistrate in this county, went to Batavia and brought him here. On his examination, he was discharged. He was then committed to jail on an execution for a debt due one of the conspirators, and on that next evening, the 12th of September last, was decoyed from the jail, and by force seized by several men, put in a carriage, driven to Rochester and from thence to Fort Niagara, at which place all intelligence ceases, and every inquiry as to his subsequent fate is proven fruitless and unsatisfactory. Now I am not bound to prove all these facts as to his removal to Fort Niagara. If I can show him in their hands by force, and that they removed him secretly, it is enough. The man is then in their custody, and the laws, the sovereignty of this state, may demand him at their hands. If they had a right thus to arrest a citizen and thus to transport him, let them show it. But if they do not, we have a right to infer that their acts were lawless, and to charge them with the destruction of the liberty of this unhappy man. And if his blood be shed, that is also upon them. With this brief statement of the law and facts, I invite your close attention to the testimony which I will now proceed to introduce, and refer you to that for a particular knowledge of the case. End of section 43.
Section 43 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claudia Perry. American State Trials, Volume 3, by John D. Lawson. Trial of Harris Seymour, Moses Roberts, Holloway Hayward, Henry Howard, and James Ganson for the abduction of William Morgan, New York, 1827. Part 1. Witnesses for the People. David C. Miller. Have resided many years at Batavia. Know William Morgan, who resided there in September last, and was engaged in writing a book of Freemasonry. Am the editor of a newspaper in which the subject of the book was frequently mentioned. It was publicly known for 4 or 5 weeks that Morgan was writing the book before he was taken off. The subject excited much feeling in the community. Morgan left Batavia on the 11th of September. Hayward and others took him off. Morgan's family still resides there. Morgan has never been heard of since. Heard of Morgan's arrest soon after sunrise, and that he was confined in a room at Darnold's Inn, under charge of strangers. Went in pursuit of counsel, and did not see Morgan until he got into the carriage, when I told him he must not go away, as I was his bail for the limits. Hayward said Morgan must and should go. Observed that Morgan's countenance was pale and ashy, and his eyes set and glassy, and he paid no attention to what I said. Spoke again to Morgan, who then started to rise, but was told by those who sat by him, in a low tone of voice, to sit still. I stood by the door to the carriage, but was pushed aside, and the officer told the driver to hurry on. General Marvin. I object to anything that was said or done at Batavia concerning the bringing of Morgan to this place. The conspiracy charged alleges that Morgan was removed from this place, Canandaigua. They cannot, therefore, go into conspiracy to remove Morgan from Batavia. They may say they mean to connect the conspiracies, but such testimony would be irrelevant. The acts at Batavia were a mere assault. Mr. Dixon. We intend to connect the transactions at Batavia and Canandaigua. We shall show such connections clearly. We shall show common acts and common objects, and although we may not combine all the offenders, still the testimony now offered is admissible. Mr. Wilson. If they show that the overt acts of the parties in all the counties tended to a common object, it was admissible, otherwise the prosecutors could establish nothing that was consummated in any one county. The overt acts were continuous and extended to several counties. Evidence showing generally the character of the conspiracy is strictly legal. All that is necessary to show sufficient acts done in this county to give the court jurisdiction. General Marvin. I contend that before the prosecution can go into testimony showing a conspiracy abroad, They must prove overt acts done here. The court overruled the objection, saying that it could not restrict counsel in cases of conspiracy, particularly in the order of testimony. Mr. Miller: Hayward told the driver to go fast. The stage went off so fast that some of the party was left, and had to run to overtake it. 4 or 5 persons were in the coach, and one sat on the box with the driver. Cross-examined: Have testified in part to the same history before. Don't recollect whether I then stated the appearance of Morgan's countenance and eyes, but have said so frequently in conversation and in my paper. My impression is that Hayward is the man who said Morgan must and shall go. Dr. Samuel Butler: Live in Stafford. Major Ganson then kept a public house there. Saw a coach driving up to Ganson's door on the Saturday evening previous to Morgan's being carried away from Batavia. Was introduced by Ganson to a man he called Seymour from Canandaigua. He said he had a warrant for Morgan and passed into the dining room where several persons joined him. I asked what they expected to effect by taking Morgan off. One of them replied, "We have started for that purpose and shall go." E.G. Smith, Pratt of Leroy, Willard, Eddy, and some others were in this room. Told them it was bad policy to meddle with Morgan. Was requested to inform Follett and Seaver that they were coming. Saw Follett at Batavia that evening and gave the message to him. He replied, "Tell them not to come. Our village has been troubled enough already." Met the party on my return, 2 miles east of Batavia, and told them what Follett said. Ganson was with them. The Canandaigua party got out of the coach, and one of them said, "I have started to go to Batavia, and shall go there." The Canandaigua men walked on foot, and the coach returned. Ganson and others returned with the coach. A small wagon, in company with the coach, turned about also. It was 8 or 9 o'clock in the evening. I knew previously that Morgan was publishing a book on Freemasonry. More than 6 persons were in the carriage, had talked with Ganson about the book. Was invited to attend a meeting on Friday evening previous, at Leroy, to concert measures for the suppression of the book, but did not go. Ganson told me that men of Canandaigua, Batavia, Rochester, and Buffalo had met on the premises Friday evening to concert measures to support the book. Don't know that either of the parties now on trial attended that meeting. Saw Ganson, Leslie, Towner, and Eddy the evening of the day Morgan was taken off, with others devising means to obtain his manuscript papers. Cross-examined: Can't say positively that it was Seymour or Sawyer that was introduced to me. Don't know how I got the impression, don't know, but I might think it was Schofield if I knew that a person of that name was present. Never heard Ganson say anything about carrying off Morgan. Ganson was at home on Monday, Tuesday, and Wednesday, engaged in mowing. Francis Hopkins: Lived at Batavia in September last. Drove a stage east from Batavia on the morning of 10th of September. Chesbro, Harris, Seymour, Hayward, Morgan, and 4 other persons were in the stage. Chesbro rode on the seat with me. Was told to drive fast till we got out of the country. Did drive fast. Chesbro was afraid that Morgan would be rescued. Drove to Avon, 25 miles, in 3 hours. First hesitated about going for fear that I was doing wrong, but was induced to proceed on Chesbro's assurance that Ganson would indemnify me. Ganson passed his word that I should not be harmed. Could not understand any of the conversation in the coach. Cross-examined: Heard on starting that Morgan was on the limits. This was a reason why I hesitated. Knew there had been a good deal of trouble about Morgan. Ganson said, "Drive on. There is no danger. I will see you harmless." David said, "They are going to smuggle Morgan away." Heard no complaints in the stage. Think Morgan got out at Leroy. Chesbro hurried me on. He often rose up, looked back, and said that if anyone came to take Morgan, they would not get him alive. William Thompson. Am sheriff of Genesee County. Saw none of the present defendants at Canandaigua on the 10th of September. Saw Chesbro and informed him that Morgan was on the limits. Israel R. Hall. Saw a post coach pass through Leroy on evening of 10th of September. Hayward, Howard, Chesbro, Voorhees, and others were in it. Have seen Morgan, but don't recollect him. Supposed the party had come to Leroy to assist in laying the cornerstone of an Episcopal church with Masonic honors. Nathan Follett. Saw Chesbro, Seymour, and others at Batavia on the morning of 11th of September. Saw Dr. Butler on the evening previous. Was at Darnold's when the party left with Morgan for Canandaigua. Talked with Chesbro about their object at Batavia. Geoffrey Chipman. Morgan was brought before me on a warrant on 11th of September, examined and acquitted. Hayward the officer was with him. Dr. Lakey, Everton, Lawrence, Chesbro, Kingsley, and Boge were in my office during the examination. After Morgan was acquitted, Chesbro asked for a warrant against him for a tavern debt of $2 at Ackley's, for which judgment was rendered and execution was issued. Morgan offered his coat to Hayward as security, but it was refused. Hayward asked Morgan to step out of doors, and I saw no more of him. The execution amounted to $269. Chesbro applied for the first warrant on a charge of theft in stealing a shirt and cravat of E.C. Kingsley. Heard Dr. Lakey speak of Morgan as a bad character and not to be trusted. Mr. Kingsley. Knew William Morgan. In September, Dr. Lakey asked me to walk into Chipman's office, when after considerable conversation a warrant was issued. Objected at first to the course, but finally consented. Evertson, Chesbro, and Lakey said Morgan was a man of base character and an impostor. Chesbro said that Morgan was not a Mason. Lakey also appeared very indifferent at Morgan's conduct. When Morgan first came here, he was well received by Lakey and Howard. Supposed that Morgan was a lecturer on Masonry, was induced by their representations to proceed against Morgan, should not have proceeded against him otherwise, did not request Chesbro to call on Squire Chipman. Cross-examined. Squire Chipman presented a paper in the form of an oath, necessary to be taken before a warrant was issued. I objected because I did not think the shirt business amounted to larceny, and did not think the law would justify such a proceeding. May have said that Morgan had disgraced himself and ought to be disowned. May have said to Masons that their brother Mason had stolen his shirt and cravat. The Masons were all busy about Morgan. Dr. Lakey once said he would rather pay the value of the shirt and cravat than have a Mason so disgraced. Aaron Ackley. Don't know William Morgan. He never was indebted to me. Never assigned any debt against Morgan to Chesbro. Chesbro never had the right to prosecute in my name. Never found Morgan's name on the tavern books. David Darnold's. Saw a party at Batavia where I keep a public house in September last. Knew Seymour only. The party was said to be from Canandaigua. Recognize Hayward as one of them. There were 5 or 6 of the party. It was on Sunday evening. Morgan was taken away by them the next morning in a coach, sun half an hour high. Cross-examined. Morgan took breakfast with me, which was paid for by one of the party. Colonel Miller came up, shut the coach door myself, saw nothing unusual from cases of arrest of criminals. Mrs. Mary H. Hall. Am the wife of the jailer. General Marvin. We admit all that is alleged in taking Morgan to parts unknown, but deny that the present defendants were parties to the act. Mr. Whiting. After a consultation with associate counsel, I feel that it would not facilitate business much to accept the admission. We prefer to proceed with the testimony. Mrs. Hall. Morgan was released on Tuesday evening between 9 and 10. He had been committed for debt, which Lawson paid. Lawson led Morgan out of the prison, and while locking the door I heard a cry of murder. Ran to the door and saw 2 men leading Morgan off, who was struggling. Lawson, Chesbro, and Sawyer were assisting to liberate Morgan from jail. Heard a rap upon the well curb, which appeared to be the signal for a carriage which immediately passed down and soon returned. Objected to release Morgan at first, but finally let him out on Mr. Chesbro's assurance. Cross-examined. Did not see Howard, Hayward, Roberts, or Seymour that night. Mrs. Martha Davis. Reside nearly opposite the jail. Recollect the evening that Morgan was taken off. Went to the door for wood. Saw some persons standing near Bull's shop. One of them went away, and the other, Mr. Chesbro, came along near me. I spoke to him, but he did not answer me. The other man soon came back, and both walked away. Heard a whistle. Soon saw a scuffle and heard the cry of murder. Counted 9 men about there. Saw the coach pass and repass. The man who cried murder was dragged by 2 others. He cried 3 times, and then seemed to have his voice suppressed. Heard a heavy groan. Saw Chauncey H. Coe near the jail. It was a very light night. Think Colonel Sawyer was the person I saw with Chesbro. Samuel Greenleaf. Mr. Chesbro paid me for the use of a coach to go to Batavia, September last. The bill was dated on the 10th of September. Don't know who went in it. It was an extra. Willis Turner, a colored boy. Saw Sawyer and Chesbro near the jail. As they passed by me, Sawyer picked up a stick. They went by the jail corner where they stood and talked. While drawing water, heard a cry of murder, and saw 3 men coming off the jail steps. Sawyer came to the well and gave 2 raps on the curb, and then went towards the 3 men. Chesbro went the same way. Something was put into the middle man's mouth by Chesbro. Morgan pulled back, lost his hat, and Sawyer picked it up. A carriage overtook them. The door was opened, and Morgan was put into it. 4 besides Morgan got in, and the carriage came back. Don't recollect whether the curtains were up or down. Had seen Morgan in Chipman's office. Did not know the men who came out of the jail with Morgan. Cross-examined. Saw 6 men only at that time. Saw the carriage turn Kingsley's corner. Saw Sawyer and Chesbro first. As he came out of the gate, kept near enough to see them. Had not got to the tavern when Chesbro put the handkerchief in Morgan's mouth. They hurried Morgan on as fast as they could. He cried murder twice after they got off the steps. They went beyond the pound and went fast. Chesbro and Sawyer was along with them. Sawyer did not catch up at first. Saw nobody about the streets when the carriage drove off. Mr. Osborne picked up the hat and handed it to Sawyer. Chesbro had on a snuff-colored surtout coat and a black hat. Sawyer was dressed in gray clothes and a white hat. Mr. Whiting stated that the circumstances against Nolan were so slight he would now enter nolle prosequi in his case. Asa Nolan. Reside at Avon. Saw a party at my tavern on 10th of September. Harris, Seymour, Chesbro, Hayward, Howard, Roberts, and a man named Schofield or Scoville. Voorhees was not of the party. I got into the stage at Hosmer's and went to within 2 miles of Batavia. Butterfield joined the party at Caledonia, Smith at Leroy, and Ganson at Stafford. The party from Canandaigua got out of the carriage and went on foot. Did not know the reason why the coach returned. Had no object in going further. The object of the party was to get William Morgan on a warrant for stealing clothing, though it was best from all circumstances for him to go back. Heard no reason from the Canandaigua party getting out of the coach. Did not discover anything connecting the Batavia affair with their object. Was in the room with 12 or 20 persons, but did not hear what they were conversing about. Don't know whether they were in conversation about Morgan or not. Saw Ganson at supper. Smith and Butterfield returned with me. Ganson came back on the box. Did not hear the conversation with Dr. Butler when the coach turned about. Did not tell Butterfield it was better for them not to hear what was passing. Told him he had better have kept away, and go home again. Something was said about the book. Don't recollect what it was. The coach went 11 miles back that night. Saw the party with Morgan the next day. Mrs. Lucinda Morgan, am the wife of William Morgan, was in Canandaigua in September last. Returned to Batavia the next day. Saw Ganson at Leroy on my return. Asked Ganson if he thought I would ever see my husband again. He said if I did not see him in a year, I need not be surprised, and if I never saw him, I should be handsomely supported, and my children educated. Ganson said he was glad to see me, for he was then going to Batavia to make arrangements for my support. Have never heard from my husband since he left Batavia in September last. Great but unavailing exertions have been made to obtain information of him. We have 2 children. James Sibley. Mr. Whiting, have you ever conversed with any of the defendants about William Morgan? Mr. Sibley, I ask the court whether I am bound to relate a private conversation with a friend. The court, you are bound to tell all you know relating to these defendants. Mr. Sibley, shortly, 2 or 3 days, after Morgan's abduction from Canandaigua, Harris Seymour informed me that he and others had been to Batavia for Morgan and brought him in. Seymour told the manner of arresting Morgan, who was of the party, and how they got him to Canandaigua, and how he, Seymour, got left and had to run after the stage. After Morgan was in the stage, some persons got hold of it and tried to stop it from going. One of the party jammed their hands off and the party started. He told how Morgan was examined at Chipman's office and acquitted, when one of the party came forward and accused Morgan of owing him $2. Morgan confessed judgment, and an execution was immediately taken out, and Morgan, not having bail, was committed. Seymour then told me the particulars about Morgan being taken from the jail on the evening of the 12th of September. The court. We cannot allow the confession of one of defendants to be taken as evidence to criminate the associate defendants. The district attorney contended that where the confessions of a party went to establish what was charged in the indictment, the evidence was at least good against himself. The court allowed the witness to proceed with the facts without mentioning the names of others than Mr. Seymour. Mr. Sibley, Seymour said a certain person went to the jail and pretended to be Morgan's friend, offered to pay the debt, invited Morgan home with him, and offered to furnish him with money. There was some difficulty on the part of Morgan and Mrs. Hall, but the man finally got him out, took him by the arm, and led him along until they met another man who was introduced as a friend, but by a false name. When they got into the street, they, those who were named to me, came up, and Morgan resisted. He said something about Morgan being bound or blindfolded. Morgan was put into a carriage and taken to near Hanford's Landing. He was then shipped into another carriage and taken to Fort Niagara and put into the powder-house. And that was the last they had heard from him. This confession was a few days after Morgan left here. Something was said about a scuffle, but don't recollect what it was. Heard a conversation, the object of which was to dispose of Morgan and prevent the publication of his book. Heard many times that Morgan was about to publish a book revealing the secrets of masonry, but not from these defendants. Saw several persons from the West on that business. One man from Batavia called on me and opened the subject of the book, stating that Morgan would publish it if means were not taken to stop it. This was about 2 weeks previous to the abduction. He stated that Morgan would publish the book with the higher degrees. Another person from Canandaigua said it must and should be stopped, by some means or other. Seymour told me that he was urged into all that he did, and seemed to lament that he had engaged at all. 2 parties went after Morgan. The first time nothing was accomplished. The second time they brought him in. Mr. Whiting asked the court if it was not competent for Sibley to disclose the names of the 2 persons alluded to in his examination, as concerting to suppress Morgan's book. Mr. Sibley, the gentleman alluded to yesterday from Batavia was Chauncey C. Church, and the Canandaigua gentleman was Nicholas G. Chesbro. Have not had conversation with any others upon the subject. Church told Chesbro that Morgan would go on with the book, unless measures were taken to stop it. Chesbro said the thing must be stopped, and Morgan must be taken care of. Church did not assent or dissent. Heard no other conversations about carrying Morgan off. Heard Hayward say he was bound by his oath to go after Morgan. Did not see Smith or Whitney here in September. Cross-examined. Church is a silversmith, as also am I. Church used to work for me as a journeyman. Don't know when or how the story came out about Morgan's going only to Genesee River. Seymour said he was urged to go to Batavia, that Hayward was along. In all transactions subsequent to Morgan's confinement, he spoke of them as they. Howard said there was no harm in riding out and back, if Morgan was in the carriage. Heard the several facts of Morgan's being taken from jail, but did not know the particulars until Seymour told me. The person who urged Seymour to go to Batavia was Chesbro. Seymour told the story without saying that any person had told it to him. Harvey Olmsted. Lived in Greece, Monroe County, near Hanford's Landing. About the middle of September, saw a carriage standing in the road between daylight and sunrise, a little south of F. Hanford's Tavern. The curtains were closed down. The horses were much fatigued. A man was on the box. Afterwards saw the same carriage under Hanford's shed. Saw no persons in the carriage. When the carriage returned from off the ridge in about 3/4 of an hour, the curtains were up, and 4 or 5 persons got out. The driver was a small man, a stranger to me. The carriage was yellow. Joshua Christopher. Lived in Rochester in September last. Knew Hiram Hubbard. Saw him in Rochester just before breakfast. About the middle of September. It was the next morning after Morgan is said to have been taken from Canandaigua. He drove gray horses. Have spoken to Hubbard about it several times, but he said nothing of any importance. Cross-examined. Keep a public house. Hubbard said he had been driving all night. Hubbard has always said he did not know who was in the carriage. It is not common to ask names of persons who want carriages when drivers are sent. Ezra Platt. Live at Rochester and keep a livery stable. Cannot say whether I hired a carriage and horses on 12th of September. About the time of the installation at Lewiston, some person came before daylight to my house, woke me up, and inquired whether I had horses and carriages to let. Answered that I had, and inquired where it was wanted to go, and got the impression that it was wanted to go to Lewiston to the installation of a chapter, but can't recollect the precise words. Was told to send the carriage to Ensworth's. Called a driver, told him to harness a team and take it to Ensworth's. Can't recollect who the driver was. Believe it was Parker or Parkhurst. Don't know where he is now. It was a yellowback with bay or black horses. Supposed that the grand officers who went to install the chapter had it. Now think I was imposed upon. Have never been paid for it. Don't know whether I ever asked who rode in it. Don't know how far horses or carriage went. Don't do business that way generally. General Marvin. We again offered to admit all that is charged in the indictment, but deny that the defendants upon trial were parties to the outrage so abundantly proved. The Court. We cannot interfere with the course the public prosecutor thinks it is his duty to pursue. The testimony is admissible to prove a conspiracy, and if he is not willing to take your admission, it must proceed. Solomon C. Wright. Lived at New Fane, on the Ridge Road in Niagara County. On the 12th of September saw carriages pass that day. Saw one in particular, which was driven into my barn. This one arrived in the afternoon, and baited, and left there after candlelight. Did not see any passengers in it, or see any get out of it. A person got some horse feed, and some men got supper there that night. Don't know who they were, how they came there, or how they went away, or what they were doing there. They came and went about the same time the carriage alluded to came and went. Did not expect a party there that night. Don't know William Morgan. Some man, not the driver, called for the horse feed. Jeremiah Brown was about there some time during the stay of the carriage, and went away about the same time. Don't know whether he went away in the carriage or not. Did not see Eli Bruce there that day. All who eat came into the house. David Maxwell. Am gatekeeper on the Ridge Road. Recollect a coach passing the gate on evening 13th of September, about 10 o'clock. Live about 8 rods from Solomon C. Wright's tavern. Heard a buzz upon the hill near the gate, and then heard a carriage pass. Opened the door upon Jeremiah Brown, and said, "How do you do, Captain Brown?" but received no answer. Captain Brown handed a shilling, which is the toll on a 2-horse coach. Asked Brown, "What is the matter?" Who answered nothing, and passed on. Brown came back in a coach the next morning about sunrise. This gate is 19 miles from Lewiston. Saw no other coach pass on the 13th. Eli Bruce. Am sheriff of Niagara County. To a question whether he knew Jeremiah Brown, Mr. Bruce appealed to the court for protection against questions that might tend to implicate himself. The court. The provisions which, under all circumstances, protect witnesses from being brought into difficulty by their own testimony, is the most excellent one in our system of criminal jurisprudence, and this court will at all times endeavor to preserve it strictly. We will judge of the propriety of the questions as they are put, and see that the witness is not entrapped by improper questions. Mr. Bruce, know Jeremiah Brown. Was at Wright's Tavern on the 13th September last. Saw Burge Smith that afternoon. Was at Lewiston on 14th September. Was not at Fort Niagara on 14th, 15th, or 16th. Mr. Whiting, were you at the fort on 13th September? Mr. Adams objected. The court said that it was for the witness to object to the question. Mr. Adams presumed it was competent for the witness's counsel, in which relation he had the honor to stand, to object to the questions. It was presumable, he said, that counsel understood the legal rights of witnesses better than they could know themselves. The court. The objection is sustained. Mr. Bruce was at Rochester or Canandaigua in September, and never saw Loton Lawson, except in the jail of this county. Declined to say whether I knew William Morgan. The court decided that witness was not compelled to say whether he heard conversation about Morgan on the 13th of September, and to the question whether he saw Morgan at Wright's Tavern, counsel interposed, and advised him not to answer any further questions. Mr. Bruce stated to the court, in explanation, that he had been twice examined on charges relating to this affair, and that it was a subject of complaint against him to the governor, and that thus situated he did not know how far it would be proper for him to answer. Mr. Adams added that he understood also that the grand jury of that county had just found a bill of indictment against Mr. Bruce upon the same complaint. It would be unjust and illegal, therefore, to pursue the examination. The district attorney waived the question and called Corydon Fox. Lived in Lewiston in September. Drove a carriage to near Fort Niagara. It was 11 to 12 o'clock when we started. Was in bed when Major Barton called me to hitch a pair of horses. Mr. Bruce came and told me to drive around on the back street. Drove on the back street near a carriage. 1 or 2 men were standing near it. One got out of the other hack into my hack. 3 or 4 more got in. My horses were restless, and I had to pay attention to them. No horses or driver were with other hack. Drove down to Youngstown, stopped at Colonel King's. King got into the coach, then went down by the burying ground near the fort. There I stopped, and all of the party got out of the hack and went towards the fort. I asked if I should wait. They said, "No, go back about your business." It was Bruce that said so, only knew Bruce and Colonel King. Did not see anyone that was bound. Heard some person ask for water at Colonel King's. Don't know whether water was got or not. Ebenezer Perry. Live at Lewiston on 14th September, heard a noise at Barton's stage barn. About 1 o'clock in the morning, went to the door, saw a coach coming towards another coach without horses, with Fox and Bruce on the box. Bruce went to the other coach and opened the door. A man came out, turned round, and reached back into the coach. A man in a helpless condition was taken out of the coach by Bruce and another man. They walked along to Fox's coach and got in, all except Bruce, who walked to the first coach and took out a jug, which he carried to Fox's coach. Supposed the man they helped was intoxicated, was confirmed in this opinion by the sight of the jug. They all got into the coach and started off towards Youngstown. The helpless man seemed to have a handkerchief bound round his head, had no hat on. Recognized Bruce the next day at Lewiston. Daniel Weaver. Had some conversation with Harris Seymour last January at James Everingham's store. A man came in to see his account. Seymour says, "I won't have a Bloomfield man or a Quaker on my jury." Seymour said he would go barefoot and bare-legged through the snow from here to New Orleans, through jeopardy to do the same thing over again, told Seymour, alluding to the Morgan affair, "It is a bad business." The answer was, if you had a full Quaker jury, they would do justice. End of section 44. Section 45 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claudia Perry. American State Trials, Volume 3, by John D. Lawson. Trial of Harris Seymour, Moses Roberts, Holloway Hayward, Henry Howard, and James Ganson for the abduction of William Morgan, New York, 1827. Part 3. Mr. Adams to the jury. The illness of one of the leading counsel for the defendants has cast upon me the duty of opening the defense. And as I had not expected to be called upon to address any remarks to you in the course of the trial, I beg leave to bespeak your indulgence, if in discharging my duty I should be somewhat desultory. If the jury, or the respectable and anxious defendants, expected that any part of the defense consisted in denying that the offenses charged in the indictment had been committed by some persons, they would be disappointed. And if anyone expected that the defendants' counsel were about to deny that many of the Freemasons, and the defendants among them, had wished to suppress the publication of Morgan's book, he was to be disappointed. Whether such a wish was criminal was immaterial to the legitimate purposes of this investigation. Their counsel are free to admit that a nefarious conspiracy had been formed to kidnap Morgan, and that he had been violently carried away under circumstances which had called forth the virtuous indignation of the country, and the counsel for the defendants and the defendants themselves hoped that this indignation would be directed against the proper objects until all the offenders should be brought to punishment. We only deny that the defendants had participated in the guilt of these transactions. If this were an ordinary prosecution, carried on under common circumstances, the defendants' counsel would only feel called upon to repose the case of their clients on the insufficiency of the proof on the part of the people. For although much had been proved, which commanded the earnest attention of the jury, very little had been done to sustain the charges set forth in the indictment against the defendants. It was natural that, in listening, as they had, to the whole history of the outrages committed upon Morgan, they should lose sight of the real subject of inquiry before them, namely, the charges contained in the indictment against these defendants. The real issue to be tried was, are the defendants guilty of what is alleged? To this I beg leave now to call your attention. The jury would remember that the only acts proved against the defendants consisted in what they had done in relation to bringing Morgan from Batavia to this place on criminal process. For this transaction they had, some of them, been tried and acquitted, and besides, unless this was done as a part of a concerted plan to carry him away from jail, it did not involve them in the guilt here charged. Something had been shown of the declarations of Mr. Seymour, respecting his knowledge of the foul means by which Morgan had been removed, and of the fate of the unfortunate man. But on understanding the imposing statement of the witness, Mr. James Sibley, it appeared that Mr. Seymour was only relating what he had learned from others after the dark deed had been done, except in so far as related to bringing Morgan from Batavia. A knowledge acquired after the commission of these crimes did by no means imply guilt in Mr. Seymour. He might have been stating what was rumor, and what many persons might have related. And even if he had derived that knowledge from some suspected and guilty person, by the use of that key which unlocks the bosom of a brother. It did not implicate him in transactions of which he had no knowledge at the time. He might have availed himself of the relation in which he stood to such person, and have drawn from him this appalling relation for the purpose of gratifying the same curiosity which prompted Mr. Sibley in his inquiries, and he might have had in view the further and higher purpose of rebuke and admonition. I am instructed to say that the defendants will show to the entire satisfaction of the jury that Morgan was brought from Batavia with no other motive than to have him punished for a petite larceny, of which the defendants had good reason to think him guilty. It was well understood that Morgan was about to publish a book which would bring dishonor on the Society of Freemasons. The defendants were members of that society, and with many others doubtless wished to have Morgan convicted. If he was guilty, that his infamy as a man and his treachery as a Mason might make their way together in the community. The defendants would further show that the plan of bringing Morgan from Batavia was originated and the process procured for his arrest by other persons without their knowledge, that a coach was hired and they invited to ride before they knew the object of the journey, that with the exception of Mr. Hayward, the constable, they had nothing to do with his arrest, detention, conveyance, or subsequent examination and discharge before the justice, that his still subsequent arrest for debt, and commitment to jail on the execution, was by the sole procurement of Chesbro, when they were at their homes and without the least knowledge of what was doing, and that his abduction was still an afterthought, suggested by persons with whom the defendants had no communication, and executed while they were quietly pursuing their ordinary avocations, and enjoying at places remote from the scene of violence the society of their families and friends. The defendants will further show such explanations of the evidence on the subject of the Batavia expedition as will remove whatever suspicions may have been attached from that quarter, and on the whole I feel assured that I shall hear from the eminent and faithful counsel for the prosecution expressions of gratification at the verdict of acquittal which you will return. I ought not to sit down without adverting again to the great excitement which these outrages had produced, and which had pervaded the community. The indignant feeling that had burst forth and spread with such rapidity was honorable to the country, and while directed against its proper objects should not subside. But the honest and righteous zeal to vindicate the majesty of the laws and punish the guilty might be perverted to the unworthy purposes of a political or personal nature, and when so perverted it would become dangerous. The jury have seen here and elsewhere sufficient to admonish them that they ought to see it, that their understandings are not surrendered to or even influenced by this feeling. A number of the respectable freeholders who had been returned on this panel candidly declared here in court that they had formed an opinion that the Freemasons of this vicinity as a body were concerned in these outrages. In such a state of feeling, when there was so much eagerness to convict somebody, there was great danger that to be suspected would be to be convicted. The most sanguine hopes of their counsel would be realized if the innocent persons who had fallen under suspicion should escape unjust conviction and punishment. But on this subject, counsel and the defendants themselves looked with confidence to the court for its advice to the jury, trusting that such advice would be received with the great respect to which it would be entitled. Witnesses for the defense. Mrs. Sally Griswold. Reside in the family of Mrs. Seymour, mother of Harris Seymour. Saw Harris Seymour on the evening of 11th of September from candle lighting till 10 o'clock at Mr. Phelps, where I watched with old Mrs. P., who died that night. Charles Seymour was of the party. Charles Seymour. Recollect a party on the evening alluded to by Mrs. Griswold. My brother Harris was with the party till it dispersed. Miss Clark, Miss Savon, and Miss Everingham were of the party. Peter A. Warden, Thomas Neal, and Austin Wilder swore that Mr. Howard was engaged in the store all the evening of the 12th of September. Joseph McMillan. Roberts and I worked for Chesbro. Found Roberts in bed on the evening 12th of September, about 8. Do not know where Roberts went the day before. Major General Brooks and Major William Blossom testified that Holloway Hayward was at military reviews at Bristol and Bloomfield on 11th and 12th of September last. Johnson Goodwell was in Batavia the morning Morgan was arrested, went to Darnold's just as Morgan had got into the coach. Miller went to the coach door much agitated and said, "You must not ride in that coach, as I am your bail." Morgan said he was arrested on a criminal process and must and should go and satisfy the people in Canandaigua that he was not guilty. Morgan said, "You are not holden when I am arrested on a criminal process." Miller said, "Where in hell are you going?" Mr. Darnold closed the coach door, but saw no scuffling. Miller inquired by what authority they took him off. Hayward answered, "I have a warrant for larceny." Miller said he should endeavor to stop him. Hayward said he should take Morgan. Saw no violence. Did not see Morgan rise up in the coach. Never heard anyone talk about suppressing Morgan's book. Am a Freemason. The book Morgan was writing was considered disadvantageous to Masonry. Timothy Hosmer. Live in Avon. A party called at my house on 11th of September and got some refreshments. No restraint was exercised upon Morgan. Party was there an hour. Don't recollect who paid for the refreshments. Geoffrey Chipman. Recalled. Don't recollect that any particular house was mentioned where Morgan was to be found. Chesbro said Morgan was about 6 miles off. Don't recollect that Chesbro or Lakey said that Morgan was not a Mason. Chesbro told me to put his, Chesbro's, name into the process. I gave criminal process to Hayward generally. I am not a Mason. The warrant was directed to the sheriff, any of the constables, or Nicholas G. Chesbro. Ira Wilder. Was bail for Ackley, who had got into bad habits. They took possession of the house from Ackley till the 19th of August. The accounts were handed over up to August, but there was none against William Morgan there. An account of $2 was put upon the schedule after it was left at Justice Chipman's. Nicholas G. Chesbro. Received a warrant against Morgan in September. Handed it to Hayward to be served. Had no conversation with defendants about taking out that warrant. Went with the officer and these defendants to Batavia. They all went at my invitation. Asked Howard to take a ride, who said he would if he could be back that evening or next morning. Said nothing to him then about Morgan. When I took out the warrant, I believed Morgan would be convicted of larceny. Spoke to Harris Seymour about going to Batavia. Seymour said he had business at the bank in Rochester next day, and if he could get round from Batavia to Rochester, he would go. Requested Roberts, who was his foreman, to go also to Batavia. Asked the defendants to go, merely for a ride. Called for Howard at his home. Had no previous conversation with defendants. Had no other design upon Morgan at that time than to convict him of larceny. Defendants took no part in the arrest of Morgan, except Hayward. The other defendants were in bed. Morgan was not bound, and was treated indulgently. Seymour and I got out at hotel. Did not see defendant at the examination of Morgan. Was informed that Morgan was discharged on the charge of stealing. When I presented a demand for $2, upon which he confessed judgment, can't say whether the $2 demand was put upon the Ackley schedule before the criminal process was issued. Morgan's name had in September become notorious. Never conversed with any of these defendants about removing Morgan from jail. Was informed that Morgan would go away peaceably. Was told that Morgan had agreed to go away. Defendants had no agency in removing him. Knew Morgan was about to publish a book and wished to separate Miller and Morgan, but did not intend a violent separation. Understood that Morgan wanted to get rid of Miller and discontinue his book. The conspiracy to take Morgan west from the jail originated here after Morgan was discharged from the criminal charge. As a Mason, I wanted to suppress the book. Did not anticipate any force or resistance in taking Morgan from jail. It was nearly night before Morgan would consent to go from the jail. Requested driver to go fast from Batavia. Saw Miller at Darnold's. He threatened to pursue Morgan. Went and returned to and from Batavia in a usual public manner. James Sibley introduced Mr. Church of Batavia to me in September. Either Sibley or Church mentioned the subject of the book, but little was said. Nothing was said about removing Morgan in that conversation. No plan was agreed upon. Cross-examined. Think there was conversation about Morgan's being at Lima. Took the stage for Batavia. Told Howard the object of the visit to Batavia. Perhaps I told it to all. Was induced to engage in the business, to suppress the book. Had heard that Kingsley accused Morgan of stealing. Can't say whether I asked Kingsley to complain. Told Howard I had a warrant for Morgan. Told all the party that I had a warrant for Morgan. I hired the carriage and paid $10. Told defendants my opinion that Morgan's conviction would derange the publication. Did not know Ganson before. Don't think I talked with Ganson about Morgan. Did not know Dr. Butler. Stayed at Darnold's. Did not see Church. Went out with Hayward, but did not see Morgan arrested. Left Darnold's and drove fast. Ganson indemnified the stage driver. Got here before sundown. Demanded $2 of Morgan, for which Morgan confessed judgment. Heard Morgan was a worthless, intemperate man. Got to examination against Morgan to punish him for writing the book. Gave no directions to Hayward. The first idea of removing Morgan from jail was on the evening of 11th. Several persons said they would go away with Morgan. Was told at Batavia that Morgan was anxious to be kept away from Miller. Supposed if Morgan went among his friends at Rochester, they would induce him to stop the book. After he was put in jail on debt, his friends at Rochester were informed that he was here. Understood he had lived at Rochester. Understood that Morgan said that if the debt was paid, he would go with them. Don't know who paid the debt. Saw Cole, Sawyer, and Lawson about the jail. Got the impression that the persons who took Morgan away were from Rochester. Got no information that I can rely upon as to what became of Morgan. My object was to suppress the book. Did not intend going to Rochester when I started for Batavia. Ganson was probably apprised of my object with Morgan. The Court. Chesbro, I now ask you a question under the solemn responsibility of the oath you have taken. Were these defendants, or either of them by words, significant signs, hints, writings, or in any other manner apprised of the intention to take Morgan from the jail of this county? Answer: they were not. The counsel for the people and the defendant, after consultation, concluded to submit the case to the jury under the charge of the court without argument. Judge Howell, I wish that counsel would sum up, as I feel too much exhausted to go through with the testimony at this late hour. The reading of my minutes alone would consume more than an hour. Counsel declined. The judge's charge. Judge Howell to the jury. The counsel, by declining to sum up the case, have thrown a very unexpected burden on my hands, and they must not complain if I should fail to notice the whole of the testimony as fully as they might desire. The crime with which the defendants stand charged by the indictment is one of very great enormity. They were charged with having formed a wicked conspiracy to seize a citizen, under the protection of our laws, and enjoying the rights and entitled to the privileges of a free man, and without authority to transport him from the gaol of Ontario County to foreign parts, and there to secrete and imprison him, and with actually having carried into execution this conspiracy. The counsel for the defendants had cautioned the jury against the influence of popular excitement, It was true that great excitement had prevailed, and the court rejoiced that it was so. The crime was one that ought to call forth the indignation of all virtuous citizens, and it was to be hoped that the excitement would never cease until the actors in this dark and probably tragical affair are brought to light, and the guilty punished. At the same time, the jury are bound to divest themselves of all passion and prejudice, and to know nothing of this cause but what they are derived from the testimony given them in the box where they are sitting. The judge defined a conspiracy and commented on the nature of the evidence by which it must, in most cases, be established. It was not to be expected that a secret and wicked combination could be proved by producing the original compact, but by showing the acts of many individuals acting in concert, all tending to the same unlawful end. The first question to be determined by you under the first and second counts will be, has such a conspiracy as that charged in the indictment been proved to have been formed by any person whatever? And if so, are the defendants on trial, or either of them, parties to it? The second, are the defendants, or either of them, guilty of kidnapping and imprisoning Morgan as charged in the other two counts? As to the first question, the evidence produced on the part of the prosecution establishes most conclusively the fact of the conspiracy between certain persons, and it then becomes the important question whether either of the defendants were parties to it. The prosecution do not profess to offer any direct evidence of such participation, but would infer it from the acts of the defendants. It then becomes important to bear in mind the precise object stated to have been designed by the conspiracy charged in the indictment, to wit, the carrying of Morgan from the gaol of Ontario County, and to inquire what acts of the defendants tend to accomplish that object. It is not contended that any direct agency had been proved against any of the defendants, either in removing Morgan from gaol or in his subsequent imprisonment. It has indeed been fully proved that he was violently removed from the gaol at Canandaigua, and carried by night as far as the Ridge Road beyond Hanford's Landing in Monroe County, and that he has not been heard of by his family or friends since that time. And although not so clearly proved, yet the evidence leaves but little room to doubt that Morgan was carried in the same unlawful manner to Lewiston, and from thence down the river to the burying ground near Fort Niagara, and from that period his fate has not been disclosed, whether living or dead, no one has informed us. But were either of the defendants engaged in his abduction? Some of them have proved conclusively, and others very satisfactorily, that at the time of Morgan's abduction they were engaged in other places about their ordinary business, and it does not appear that they had subsequently engaged in it. Did then any of the acts or deliberations of the defendants satisfy the jury that they had entered into the conspiracy to remove Morgan from the gaol? If the jury, after carefully examining all these, should have any reasonable doubt of the guilt of the defendants, they must acquit them. But if from all the evidence you are satisfied that the defendants had been parties to the conspiracy charged in the indictment, or had participated in the unlawful abduction and imprisonment of Morgan charged against them, then you must fearlessly promote your verdict of guilty, however distressing the consequences may be to the defendants. The acquittal. The jury retired, and after an hour's consultation, returned a verdict of not guilty as to all of the defendants. End of section 45.
Section 46 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of William Dandridge Epes for the murder of Francis Adolphus Muir, Petersburg, Virginia, 1848, Part 1. The narrative. On the morning of February 2nd, 1846, Francis Adolphus Muir, a young man of one of the leading families of the state of Virginia, rode on horseback to the plantation called Grampian Hills, belonging to his neighbor and friend William Dandridge Epes, also a member of a Virginia family, numerous, wealthy, and respectable. 5 years before, Muir, as the executor of his father's estate, had sold the plantation to Epes, who had given bonds and a deed of trust to secure part of the consideration. He had not been able to pay these, as they fell due, and had been more than once pressed by the executor, who finally informed him that unless paid by Christmas 1845, the land would have to be sold under the deed of trust. But he was ill at Christmas time, and he had put off the demand several times by promises of money, which he failed to obtain. And now Muir, being unwilling to grant any further forbearance, journeyed to the Epes house with the bonds in his pocket to demand payment and to inform the debtor that the next step would be the sale of the place by the sheriff. Muir left his brother John's house with that statement, promising to return the next day. A servant on the plantation saw the debtor and creditor ride off together from the Epes residence, but Francis Adolphus Muir was never seen alive again. Diligent inquiries were made in the neighborhood, but to no purpose. A little later, John Muir received a letter from Petersburg, a town nearby, signed F. Adolphus Muir, which said that he had collected the debt from Epes, and on his way from the plantation to Petersburg, his horse had thrown him and a stranger passing by had taken him in his buggy to the town. A friend was writing the letter for him, as he could not write himself on account of the injury, and just as soon as he could, he would go north to buy a stock of goods with the money he had collected. A week later, John Muir received another letter signed by his brother, dated New York, but posted at Petersburg, which said he had left Petersburg with his head and soul full of business and anxious to get rich quickly. But when he got to New York, he found that there were better chances in Missouri, and he would go there. He asked pardon for not stopping to see his relatives on the way, but he had seen them lately, and it would be childish to do so when his business was so urgent. A gentleman whom he had met in New York had promised to take the letter to Petersburg and post it there for him to save postage. 3 months later, during all of which time the search for the missing man had been kept up, though for some time Epes was not suspected, another and extraordinary epistle was received by John Muir, dated also from Petersburg, and signed James P. Rollins. The letter stated that the writer lived in Texas, was going back there in the morning, but as he had learned that there were people here who were looking for Adolphus Muir, he wished to say that he had met a man of that name a few weeks before in Texas, whom he had seen before in Missouri. That he evidently did not wish to be known, for he was going under an assumed name. Later he had met him in New Orleans, and a day or two after, a black hat was picked up in the river, and on the lining was the name F. Adolphus Muir, Dinwiddie, Virginia. He had not heard of him since. During this time, Epes had maintained that he had paid the bonds on the day of Muir's visit, and he exhibited the bonds receipted by the executor. And he had more than once suggested that Adolphus had perhaps gone off with the money for the purpose of defrauding the other heirs. Suspicion at length was directed to him. The signature to the receipts was questioned, and finally a watch which was worn by Muir when he left for Grampian Hills was found in a jewelry shop in the town, and the jeweler identified Epes as the man from whom he bought it. Then it was discovered that Epes was in Petersburg at the time when the letters were mailed from there, and finally neighbors concluded to investigate at Grampian Hills. A committee was appointed, which went to Epes, told him he was suspected, and asked his permission to search the premises. The next day, though no trace had yet been found of the body, it was decided to arrest Epes, but he had fled. Further search was made, and on July 15, 1846, the body of Muir was discovered on the Epes plantation, buried a few feet below the ground in a grove of trees, about half a mile from the residence. Though much decomposed, it was easily identified, and wounds in the back and the front from a shotgun were found to be the cause of the death. In February 1848, Epes was arrested in Texas and brought back to Virginia, making on the way a partial confession of his guilt to the sheriff's officer. In September, he was indicted and tried for the murder. The evidence was very strong on all points, but his lawyers fought strenuously for his life. But he was convicted, and on December 22nd, he was hanged in the presence of a great multitude of spectators from every part of the county. Before his execution, he made a full confession of his crime. The trial. Footnote. Bibliography. Trial of William Dandridge Epes for the murder of Francis Adolphus Muir, Dinwiddie County, Virginia, including the testimony submitted in the case, the speeches of counsel, etc., to which are added the confessions of the prisoner, an account of his execution, etc., etc. Petersburg, Virginia, J.M.H. Brunette, Reporter, 1849. End of footnote. In the Circuit Court of Law and Chancery for Dinwiddie County, Virginia, September 1848. Honorable John W. Nash, Judge. September 19th. An indictment had been previously found charging the prisoner with the murder of Francis Adolphus Muir. It contained 2 counts, the first charging that the deceased was killed by a gunshot wound, received in the back just above the hips. The second that he came to his death by a bullet wound in his hips. The prisoner being placed at the bar pleaded not guilty. David May and Thomas S. Ganson for the Commonwealth. Footnote. Gralson Thomas Saunders, 1809 to 1868, born at Goldsville, Virginia. Graduated University of Virginia, 1829. Judge Circuit Court, 1853. Member Confederate Congress. End of footnote. William T. Joines and Thomas Rives for the prisoner. Footnote. Rives Thomas, born Nelson County, Virginia, 1806. Member Virginia State Legislature, 1835 to 1861. Judge Supreme Court of Appeals of Virginia, 1866 to 1869. United States Judge, Western District, Virginia, 1871. End of footnote. The panel being called, the rest of the day was occupied in selecting the jury. September 20th. The jurors were selected today by lot. They were George Williamson, Edward Williamson, Hartwell W. Williams, Thomas Perkinson, Hartwell Wells, Daniel N. Jolly, Edmund Haddon, Thomas Warren, John S. Hardaway, John F. Young, John Major, James H. Chappell. September 22nd. Witnesses for the Commonwealth. John A. Muir. In 1841, there was a sale of my father's estate. The land was advertised to be sold for 1/3 cash, and the balance in 1 or 2 years with the deed of trust on it. My brother Adolphus stated before the land was sold that if it would be any inducement, the credits would be extended to 1, 2, or 3 years, if buyers wished. No one asked it, and he considered it sold upon the terms advertised. When my brother, the acting executor, came to have a settlement with him, Epes claimed the 1, 2, and 3 years credit, which my brother would not allow. But as Epes would not settle in any other way, brother concluded to concede rather than take the land back. Epes several times promised to settle but did not. Finally, brother told him he would sell him out if he did not pay. Epes then promised to pay at Christmas 1845. Brother went to see Epes at Christmas but could not, as he was confined to his bed. On the 2nd of February 1846, brother left my house to see Epes and have a settlement. He promised to return to my house that night and stay with my wife as she was alone. I started for Petersburg the same morning, and he was to remain at my house until I returned on Wednesday. On Wednesday 4th, started home and met Epes about 17 miles from Petersburg. He said that he called by my house that morning, expecting to meet with my brother, and they would go to town together, as he had promised to meet him in Petersburg on that day, but found the house all shut up. Told him brother had said he could not stay more than one night at my house, and I expected to have met him at Mr. Warsaw's on Tuesday night. When I got home and found he had not been there, I thought it very strange, as he had promised to return. Epes then said that he parted with him at his outgate on Monday, and said brother told him that he had some business in Brunswick, but would meet him in Petersburg on Wednesday. Epes went to Petersburg, and when he returned brought me a letter dated 4th February, 1846, about 8 days old, telling me pretty much the contents before I read it. It said that his brother was going to town, his horse threw him, and got away. Sprained his right hand so much that he could not use it, and he had to get a friend to write that letter for him, and said, fortunately for him, a gentleman came along and offered him a seat in a buggy to Petersburg, which he accepted, and also that he had an offer of going into business in Petersburg, and would leave immediately for the north, and that Captain Epes had paid every dollar that was due upon the land. Asked Epes if my brother told him what kind of business he was going into. He said no. Said he met him near Jarrett's Hotel, went up to his room, had a settlement, after which he had very few words with him, as he, brother, appeared anxious to get off. He afterwards met brother, who handed him this letter and requested him to forward it to me. The letter was sealed, was in the woods where the Negroes were at work when he handed it to me. Brother did not have any clothes with him except what he had on. He left his saddlebag at my house, and his trunk was at Mr. Warsaw's. On Tuesday, 10th February, Mr. J. W. Bailey sent a horse to my house by his son, which was found in his field the day before, to know if I knew whose horse it was. Told his son that I thought it was Mr. Warsaw's. It proved to be Mr. B.'s horse, and the same which my brother rode from his house. Received another letter, dated New York, February 12th, 1846, mailed in Petersburg. In that letter there were 2 notes enclosed to me, one on Captain W.H. Cousins, the other on Mr. Berthier Boott. About the last of April, Epes came to my house for the purpose of getting a release deed. We went to Captain Cousins and there signed the deed. He showed me the bonds and receipts. Was satisfied they were the same bonds that he had given for the land. Was not as particular in examining them. Received another letter signed Junius P. Rollins, dated Petersburg, May 23, 1846. Did not suspect foul play until I got this letter. When I got to my house, told my wife brother was murdered, and that Epes was the man. On 18th of June, Mr. Borso came to my house, and next morning we went over to Epes to inquire about brother. He was not at the house. His wife said he was out with the Negroes, but the overseer sent word that he had rode off. As we passed by a place called Moor's, a place on Epes' land, we saw his dog come out of the pines, and the thought struck me he, Epes, had been to the place where he had concealed the body. Did not see Epes then. Saturday morning he came to my house after breakfast. Captain Cousins was there. He and Epes were talking together. Told Epes of our visit to make inquiry about brother, as I intended to trace him as far as I could, and he was the last one who had seen him. He said he knew nothing more than he had already told me. That is, that he parted with him at his outgate, and met him in Petersburg on the 4th, and had a settlement with him. Asked him how much money he paid my brother. He said, including interest, over $3,200. He thought someone must have killed him, or he had acted the rascal and run off with the money. That there were many persons who would kill another for $5. I asked him if he ever had any reason to think he would act the rascal. He said no, he never had. He then told of a hat being picked up on the Mississippi, and said it was frequently the case. A man in traveling would lose his hat, and they would not stop to get it. Do not think Epes could have heard of the contents of that letter then, as I had only mentioned it to a few of my particular friends, though firmly believing he had murdered my brother, was unwilling suspicion should fall upon him until I had investigated. About the last of June, I went to Petersburg, inquired at railroad and steamboat offices to find if he had left by any public conveyance, found no trace of him. None of his intimate friends had seen him any time in February. Went to Richmond, made the same inquiry with the same result. Returned home convinced that Epes was guilty. The following Tuesday heard that Epes had traded a watch in Petersburg. My brother had his watch with him at my house on Sunday, 1st February. On 9th July, a number of the neighbors met at Captain Cousin's mill. A committee was appointed to search and tell Epes that we had concluded that he was murdered in the neighborhood, and he was the man. It asked his permission to search the premises, but had to ask him the second time before he consented. He straightened himself and said he did not fear hell, death, or the devil. Dr. Edwards asked him if he would not go in the search. He said yes and went. Asked him if he had had those bonds with him, and he said he had. Requested him to show them to the company. He did so. The bonds had their names torn off, and one of the bonds had a receipt on it which I told Mr. Boisseau was forged. Epes requested Mr. Booth to call Mr. Boisseau and myself to him, and told us he would pay the bonds again without a suit. We searched the woods and fields, and went to the house and examined the wells, and Epes got the key to the ice house and insisted that we should examine it, saying perhaps he is secreted there, if he thought him damned rascal enough to commit such a deed. Someone took the key and examined it. After the watch was found Wednesday, we went over to Epes to arrest him, but he had left Monday morning. Benjamin J. Vaughan. Am sheriff of the county of Dinwiddie. Have seen Mr. Epes write, and was well acquainted with his writing. Have particularly examined the letters handed. On the first letter, that dated 4th of February, the handwriting is evidently disguised. Believe the handwriting of the letter is that of the prisoner. Charles Coiling. Never saw Mr. Epes write. Received letter from him which I had compared with these, and there is a very strong resemblance. Am a druggist in Petersburg. Claudius P. Bevel. Had a great many business transactions with Mr. Epes. Had examined these letters at the examining court, and believe every one to have been written by him. Perry L. Derby. Do not remember having seen Mr. Epes write. Have seen his name signed. Have frequently received orders from him. I am a shoemaker. The orders were for shoes. Believe myself well acquainted with his writing. Have examined these letters at the previous court. Believed them then and believe them now to be in the same handwriting. Mr. May then read the letters as follows. First, Petersburg, February 4th, 1846. Dear John, I have arrived in this place and will give you a small sketch of the times. On my way here, my horse threw me, sprained my right hand, and got away from me. My hand is at this time so painful I am obliged to get a friend to write this letter for me. I hope my horse has returned either to your house or Peter's. Fortunately for me, a gentleman came along in a buggy and offered me a seat to town, which I accepted. Captain Epes has paid me every dollar due upon his land, etc. I have had an offer to go in business in this place. I shall leave immediately for the north, where I shall remain for several weeks and see the prospect of laying in a stock of goods. I shall not be in your part of the country for several weeks. I love to all. Your brother, F. Adolphus Muir. Mr. John A. Muir, Dinwiddie, 2nd. New York, 12th February, 1846. Dear John, with a bad pen and my hand still very sore, I attempt to write you a few lines as follows. I left Petersburg in a very great hurry, when there last with my head, body, and soul full of business, calculating in a very short time to possess an estate almost equal to old Gerard. But my prospects were soon blighted. A short time after reaching here, I met with a gentleman from Missouri, an acquaintance of our relations of that place, informing me that they were getting on rather slowly, etc. Perhaps we would be glad of money. I have, therefore, thought it best to go to Missouri and see them and supply their wants and return to old Virginia probably next fall. I shall start immediately. It would be but little out of my way to call on you all, but having seen you so recently, I have thought it unnecessary to be so childish. I shall travel the greater part of the route by private conveyance. You find this letter mailed from Petersburg. I met with the gentleman on his way to that place by whom I sent it, with a request for him to have it mailed in Petersburg to old Darville's. The postage was small, to be sure, but I thought had as well be saved. Enclosed you find all the papers I had with me, which you can manage to suit yourself. After reading this, enclose it to Peter so as to let him know of my intentions. I expect he thought strange of my not calling at his house on my way to Petersburg, but I could not do so on account of being in a buggy with a stranger. My sincere love to you all in haste. Your brother, F. Adolphus Muir. To Mr. John A. Muir, Darville's Den, Virginia. Postmarked 5. Petersburg, February 26, Virginia. 3rd. Petersburg, May 23, 1846. Sir, on my arrival in this place, I inquired if any of the family of Mr. Gustavus Muir still lived in Virginia. I was informed of your name and residence. Although a stranger to you, I have taken the liberty to address you on a subject by no means agreeable to either of us, but think it my duty to do so. I am a Virginian by birth and have resided in that state until a year or two past. I moved to Arkansas, from there to Texas, where I now live, and shall leave for home this morning. I became well acquainted with F. Adolphus Muir, whom I understand to be a brother of yours, while he lived in Richmond. I also saw him while he lived in Missouri, and on my way to this place I met with him at Orleans. I immediately addressed him as Mr. Muir. He called me by name but seemed to be much confused, and immediately left the room. A friend of mine was standing by who asked me if I was not mistaken in that gentleman's name. I told him I was not, that I had known him well for years. My friend then remarked that in the month of February last, that they traveled together from New York to Orleans, and he certainly traveled under a fictitious name, which name I cannot think of at this moment. He said he seemed to have plenty of money, and said his object was to go in business in Orleans. Why he should have changed his name, I am unable to say. On the next morning after I met him, a black fur hat was picked up floating on the river, and I understand underneath the leather lining was found the name of F. Adolphus Muir, Dinwiddie, Virginia. Whether he drowned himself or what became of him is unknown. I stayed there some time afterwards, and he had not been heard of when I left. With respect, Junius P. Rollins. Mr. John Muir, Darville's Den, postmarked Way 5. W.N. Friend. This word way is in my handwriting. Do not know when it was done. Remember the morning. Way was written on this letter. Someone came to the office and asked if the mail had gone. After the bag was closed, he handed me a letter and said it was important that Mr. Muir should get it. Wrote the word way and marked the figure 5 upon it. Opened the bag and put it in. The letter was afterwards brought to me by Mr. Muir. As soon as I saw it, I remembered the circumstances. Do not remember who it was now. Mr. Epes came to my house on the 20th and left on the 25th, and postmaster at Petersburg, and proprietor of Powell's Hotel. Mr. Epes was not at my house in February. John Jarrett. Mr. Epes' name is on my register 4th February 1846. Did not see F.A. Muir there then, and proprietor of Jarrett's Hotel, Petersburg. Marcus J. Gaines. Saw prisoner in Petersburg on 25th and 26th February 1846. Went with him from a hop the latter night to the house of a relative of his and a friend of mine, where we stayed all night. Peter F. Cogbill was well acquainted with Francis A. Muir, resided in Petersburg in February 1846. He used to make the office of B. Boisseau and Company his stopping place, in whose employ I was at the time. His Western letters from Missouri came to the care of B.B. and Company by my request, so that they might be put in our box. Don't know of his ever coming to Petersburg without calling at the office. Don't recollect to have seen him since February 1846. I was at home on the 4th of February, 46. Mrs. Mary C. Harrison, in 1846, lived at Captain Epes. Mr. Muir came there quite early in the morning after I was done breakfast. Don't think he stayed long. He was on horseback, alone when he came. Captain Epes rode away with him. Captain Epes had a gun, but Mr. Muir none. Have not seen Mr. Muir since. Don't recollect when Captain Epes came back. Saw them as they passed around out of the gate. Understood they were going deer hunting. Think it was early in February. Trent E. Harrison was overseer at Mr. Epes, was engaged in burning the patches on the plantation in January and February. My rule was when working in the field to send 1 or 2 of the women to the house to suckle their children, and when they returned they brought the breakfast or dinner to those working in the field. Ross, a Negro, was the carriage driver, and when not employed by his master, was under my orders and worked in the field. While I was burning, he was absent about 2 days. Did not know what he was engaged about. About the end of February, I put Ross to hauling wood, but discovered him lurking about the kitchen. Was going to whip him for disobeying my orders when he ran to his master. Captain Epes said I had a prejudice against the Negro, and that I must whip him over his clothes for this offense. He afterwards told me he was going to make Ross a house servant and keep him to wait on himself and family, and I must not consider him a field hand any longer. William H. Cousins. Captain Epes came to my house about 1st May to obtain a release deed. He brought the deed and bonds and handed them to Mr. John Muir, who seemed to be satisfied. There were 3 bonds. John W. Bailey. The horse was found on my plantation on 9th February 1846. Peter Boisseau. Francis Muir rode my horse from my house sometime about the close of January. Said he was going down to Stony Creek, then to John's, and then to Captain Epes to get the money for the bonds. Mr. Muir made my house his home when here, and I told him he could get a horse whenever he wanted one. Knew the horse as soon as I saw him. It is about 20 miles from my house to John Muir's, and I think it probable if the horse had been turned loose on the public road, he would have come home. The bridle and saddle used by Mr. Muir when he rode away were mine, and the bridle exhibited by Mr. Allgood is mine. William F. Thompson, M.D. On the 15th of July, 1846, I went to the place pointed out to be the grave of F. Adolphus Muir on the Grampian Hills, the plantation of William D. Epes, about half a mile from Epes' residence. It was in a piney forest on an eminence, at the foot of a large dead cherry tree, surrounded by a beautiful cluster of cedars. I had to stoop very low to see the grave, directed the limbs of the cedar to be cut away, which bore no marks of having been previously touched. The grave was almost level with the surrounding earth. The surface was well covered with pine leaves, and unless closely examined would have escaped suspicion. Ordered the earth to be carefully removed out of the pit, which was about 3.5 feet in depth. We found a human form, removed a handkerchief which was tightly fitted to the face, readily recognized F. Adolphus Muir, whom I had known from his infancy. There were the prominent teeth, the strongly marked features, the hair, and even the eyes not gone. Have no doubt of its identity with F. Adolphus Muir's. The neighbors watched the grave until the next day, the 16th, when the coroner's inquest was held. Was on the jury. We had the handkerchief removed. His acquaintances recognized him, though the decomposition was rapid. discovers 8 or 9 large shot holes driven through the old bluish Petersham overcoat in which he was wrapped, and which I had often seen him wear. Traced these through his black cloth dress coat, through the back of his vest, and the waistbands of his pantaloons to the left side of his body. From the scattering of the shot, I suppose he was some 8 paces distant when fired on. There was a large round hole through his clothes into his chest, not far from the sternum, between the 5th and 6th ribs. There was not much hemorrhage externally. I made no dissection, being satisfied that either wound would have proved fatal. Believed that he received the shot in the back first. If he had not, there would have been no necessity for it, as the one in front would have caused death almost instantaneously. It was certainly the body of F. Adolphus Muir, and the injury, in my opinion, caused his death. B.B. Vaughan was present when the body of Mr. Muir was found, was intimately acquainted with him, was with the party that went on the 9th of July to search for the body on the premises of Mr. Epes, wrote the note and handed it to Mr. Epes myself, stating that it contained our views. He at first hesitated, but at last gave his consent. I am as confident as that I live that the body found was the body of Mr. Muir, recognized the clothing worn by the deceased, and likewise a button in his bosom with the letters L.B. upon it, saw a wound in the back and another in the breast, which the doctors pronounced a second shot. A hairbrush was found in the pocket, believe it to be the same I had seen him use. Marcus J. Gaines, recalled, was present at the search when the body was found. It was in a remarkable state of preservation with the exception of the nose, which was decayed. Was acquainted with Mr. Muir. I am confident it was his body. Deceased had a very peculiar head of hair, nearly red, and although it did not curl, it had a rigid waving appearance. Would have identified the body anywhere. Saw the marks of shot, some 7 or 8 in the back, and in front a wound was apparently made by an ounce bullet or musket ball. Peter Boisseau, recalled, was present when the grave was opened, and have no doubt that the body was that of Francis Adolphus Muir. He had frequently stayed at my house, and no doubt has ever entered my mind as to the identity of the body. He was one of the most amiable young men I ever saw. He stayed 1/3 of the time at my house, and I have never known a young man who was more generally beloved. To show his kind feelings for others, I was one day speaking to him of the prisoner, when he observed that I didn't like Epes. Adolphus remarked, "You don't know him, and have got a wrong opinion of him. I am intimate in his family. When I go to his house, he treats me like a gentleman. I know the watch very well and would swear to it. Believe he bought it in Missouri. The last time he was at my house, he had his watch. The next time I saw it was at Mr. Lumsden's store. Had the watch here. The day of the search, John Muir and I went to where prisoner was standing. He asked me if I had said that Mr. Lawson had said that he could be made to pay the bonds over again. I answered yes. He then said, "You needn't trouble yourself about bringing a suit, as I will pay the money over again." John Muir stayed at my house the night of the 2nd February and went to Petersburg on Tuesday. Got the watch in my possession on Tuesday after the search. Got a warrant out then, and when we got to Mr. Epes, he had got off and was gone. End of section 46. Section 47 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of William Dandridge Epes for the murder of Francis Adolphus Muir. Petersburg, Virginia, 1848, Part 2. Charles Lumsden. On the 21st of May, 1846, I traded with Mr. Epes for this watch. On 1st September, 1843, I had repaired the same watch for Mr. F.A. Muir. When a person leaves a watch of any value to be repaired, and the repairs are of any importance, it is my custom to take down the name and number. By reference to my book, I find that this is the identical watch I repaired for Mr. Muir. The name of the maker and the number are the same. Persuaded Mr. Epes to have it repaired, as it was a valuable jeweled watch. It had evidently had a fall or jar of some kind, and the cost of repairing would have been about $6. Epes is the prisoner at the bar. Cross-examined. When I traded for the watch, I did not recognize it. I identify a watch by the name of the maker and the number, which are marked upon it. Every man who makes watches of any value puts his name and a number upon them. Would not recognize a watch by the name of maker without a number. Mr. Epes looked like a gentleman, and I did not suspect him. The watch I gave Mr. Epes for his was as large, but I do not think as thick as the one I got from him. I was bred to the watchmaking business. My experience tells me that a maker never puts the same number on two watches. William Harrison, the maker of this watch, is a very uncommon name. Do not remember to have seen another watch with the same name upon it. Were I to make a watch complete, I would be familiar with it in all its parts. A great many watches are called Tobias watches, which I never saw. This watch was evidently a good one. William A. Muir. Know the watch. Was with my brother when he bought it, of a schoolmaster in Missouri, named Burns, who was at my uncle's house. William M. Gill. On the day preceding the first search for the body, I was requested to attend and assist in making an examination on the premises of the prisoner on the next day. This was the first intimation I ever had that suspicion attached to prisoner. Went next day and joined one of the squads or parties engaged in the search. We passed near the prisoner, who was in the field where his hands were at work. He joined us and commenced a conversation with me in relation to the reports in circulation. Remarked to him that I had said that morning I would as soon suppose he would kill a man in anger openly as any individual with whom I was acquainted. But, sir, that you are capable of committing such a dark, cold-blooded assassination as this, I cannot find it in my heart to believe. He replied that a man who was incapable of a mean act himself was slow to believe anything to the prejudice of his fellow man. I told him of the excitement and indignation that existed in the community, called his attention to the suspicious circumstances attending the disappearance of Muir, and besought him, for the sake of his family, if he himself had no regard for public opinion, to relieve himself, if possible, from some of them. He admitted that appearances were against him, and declared his innocence, but failed to account satisfactorily. He said, why cannot the people as readily believe that the damned rascal has run off with money in order to defraud his brothers and sisters, as that a man of my property and respectability of family and standing would condescend to do such an act? I said it would be impossible to make any man who knew him believe he was such a fool, that he had a perfect right to collect the money, bid his friends farewell, and go when and where he pleased, openly and publicly. He replied, well, he supposed the current of public opinion was against him, and he could but submit. Said I, sir, if you paid Muir the amount which you say you did in Petersburg, you can certainly show where you obtained the money. He said he could, but did not attempt to do it. I took occasion to mention it twice again. He replied in general terms he could. Dr. J. M. Hurt. A few days after the first search, I, being with Captain Epes on the road, asked him to detail to me the particulars of the whole transaction. He said Muir came to his house on the morning he left his brother's for the purpose of having a settlement with him, that they attempted to settle but failed to do so. They then agreed to meet the second day following in Petersburg for the same purpose, a short time after which Mr. Muir left his house, saying he believed he would ride over in Brunswick a little during which ride he was accidentally thrown from his horse and crippled in the right arm, his horse getting away from him at the same time. A friend in a buggy passed along soon after and conveyed him to Petersburg, when he, Epes, met him according to agreement, and concluded the settlement by his paying off the bonds. Muir left Petersburg for New York, intending to engage in the mercantile business, which intention he declined, as he received a letter in New York from his family in Missouri, urging him to come immediately home, as their wants required the funds he had collected in Virginia. Asked him if there had been no tidings of Muir since his departure from New York, to which he replied by adverting to the Junius P. Rollins letter, giving at the same time the contents of that letter. Mr. Benjamin Irby, who was present with other gentlemen, had been listening to the conversation, remarked that in his opinion the writer of that letter was the murderer of Adolphus Muir, to which Epes replied by insinuating a suspicion that he had embezzled the funds in his hands and absconded to Texas, said that in my estimation Mr. Muir was a gentleman of unexceptional character, and I believed him to be thus regarded by the public at large, and asked him if he ever knew him guilty of any conduct that could taint him with the least dishonor. He replied that whilst the land he bought of the estate of Muir was under the hammer of the auctioneer, and after it had been cried some time, and seemed likely to go off heavily, F. Adolphus Muir, as an inducement to purchasers, publicly proclaimed a willingness to grant to the purchaser, if he desired it, an additional credit of 1 or 2 years on the purchase bonds. He became its purchaser, and in executing his bonds for the same, claimed the additional indulgence Muir had voluntarily offered to concede, which Muir then refused, but on his representing to him the unfairness of such a refusal, and offering to prove to him by any number of respectable witnesses present that he did make the tender of credit, he claimed. Mr. Muir yielded the point, and matter was then satisfactorily adjusted. William Boott went in pursuit of the prisoner the day the body was found, started with 2 or 3 others, and went as far as Farmville, when we returned. On Monday following, again starting from Dinwiddie Courthouse, went to Lynchburg, where I ascertained that he had sold his horse. Knew the horse by marks upon him, had frequently seen him drove to Epes' carriage, pursued him to Texas, as far as Galveston, to which place he had traveled under the name of B. Davis. B. Vaughn, recalled, was at Mr. John Muir's the morning the body was discovered. Something transpired which induced me to believe that Ross knew where the body was buried, and he was taken up. The duty of examining the Negro was imposed on Messrs. Woodworth, Allgood, and Gill. Peterson, Allgood. There was an understanding between us that Mr. Woodworth was to go in front with the Negro. When he dismounted, we were to ride up and dismount also. Mr. Woodworth dismounted near the cherry tree, where we all 3 commenced searching, and Mr. Gill and myself discovered the spot. The Negro would not tell where the body was buried. Charles Lumsden, recalled, was called on once or twice by Mr. John Muir to ascertain the name of the maker and the number of Adolphus Muir's watch. Was called on by Mr. Peter Boisseau also. After he left, I endeavored to recollect, and after referring to my book, found the watch entered on the 1st September, 1843. Left a memorandum to that effect at Boisseau and Cargill's on Saturday night. Called on Mr. Collier, stated that I had heard several rumors in relation to a watch. Told him Mr. Boisseau had called at my house and that I had given him the name and number. I then ruminated in my mind. I had made this trade with Mr. Epes, but had fixed some other name in my mind, thinking it was a gentleman of Sussex County. Mentioned the name of the young man I thought of, but was told I was mistaken. Referred to my books and found the name of W.D. Epes. Consulted with a friend who was strongly impressed with the belief that the prisoner should be arrested. Mr. Cogbill suggested that I should see Mr. Colson. Went to him and told my suspicions. I thought the evidence sufficient. Mr. Lawson thought not. Benjamin J. Vaughan recalled. On 23rd February 1848, William D. Epes, alias Judge Lucius V. Shelby, was arrested in Nashville on the river Brazos in Texas. After his arrest, we started in a buggy for Austin. Captain Epes was not disposed to converse much, but on the second day he commenced by stating he had seen in the newspapers that he had murdered his own son, his mother-in-law, and a hog drover, which charges he said he was not guilty of, but stated that this case was bad enough without charging him with others. He went on to say that Muir had come to his house for the purpose of collecting the bonds, which he owed him, that he had made arrangements to pay him, in consequence of his having been in bad health for some time, that he intended to have raised the amount by getting Claudius B. Bevel and Edward G. Booth to become his endorsers on a negotiable note, and get the money out of bank. Asked him if he did get the money out of bank to pay those bonds. He told me he did not. Asked him if he was with the party of gentlemen on the day the search was made for Muir. He told me he was. Asked him how near any of the gentlemen were to the place where Muir was buried. He told me that at one time some of them were not more than 3 or 4 feet. Said to him that I thought it was very strange they had not discovered that the dirt was fresh dug. He replied that he was particular in having all the dirt put in the grave, and had covered with pine tacks and brush, which made it resemble an old hog bed. Asked him if the body of Muir had been found at that time. What would he have done? He said he did not know, but supposed he would have had to have given himself up. The speeches to the jury. Mr. May for the Commonwealth. Mr. May, gentlemen of the jury, if nothing else had admonished me, my own feelings would admonish me, on this occasion, not to indulge in any harshness of expression or opprobrious epithets in relation to the prisoner at the bar. It was predicted by the prisoner's counsel that this prosecution would be conducted with harshness and severity. I here assure this jury that in the view which I shall present to you, I shall attempt dispassionately to lay the case fairly before you, to state to you the facts proved in the cause, and to urge you to make only fair and legitimate deductions from them, without myself indulging or expressing any angry or vindictive feelings towards the accused, or attempting to excite them in you. If the evidence which you have heard, if the detail of facts which have been so fully proved before you, do not arouse feelings of indignation in your breasts, then, gentlemen, no effort should be made by counsel to arouse them. I shall read to you the law. I shall bring in review the testimony, and I feel confident I can show that in accordance with that law and that testimony, the prisoner has been guilty of an offense for which he should forfeit his life. The prisoner is charged with having committed the crime of murder in the first degree. We are to maintain on behalf of the Commonwealth that the prisoner is guilty of the willful, deliberate, and premeditated killing of F. Adolphus Muir. The first important point which we must establish is that F. A. Muir has been murdered. I shall not consume much time in reviewing the testimony upon this point. From the cross-examination of witnesses called on to prove the identity of the body, it will probably be contended that such identity was not fully established. Dr. Thompson proves that the body was found on the 15th of July, 1846, that he had been intimately acquainted with the deceased, and is confident it was the body of F. A. Muir, that the body was in a remarkable state of preservation, so that there was no difficulty in anyone who had known him while living deciding whether or no it was his body. On the next day, an inquest was held on the body. A vast number of persons were present, and no question was raised as to the identity. John A. Muir, Peter Boisseau, Marcus Just Gaines, and Benjamin B. Vaughan, one the brother, another the brother-in-law, and the other friends who were well acquainted with the deceased, all swear to the identity. The peculiar growth or position of the front teeth, and the plug of gold in one of them, the hair, the shape and size of his person, the clothing, the gold stud found in the shirt collar, which P. Boisseau so fully recognized, all proved the positive fact that the body found was the identical body of F.A. Muir, and then the circumstance must not be overlooked that among the vast number of acquaintances, friends, kinsmen, and neighbors who saw the body, no one has been brought forward to testify that any contrary opinion was entertained. I shall therefore, without recapitulating the testimony showing that the person whose body was thus found came to his death by gunshot wounds, assume the fact is fully established that F.A. Muir was murdered by someone, and that his body, found on the prisoner's farm within half a mile of his house on the 15th of January, 1846, was his. The next point which we have to establish is that the prisoner at the bar was the murderer, and let us inquire first what inducement there was for his commission of the murder. It appears from the testimony that in the year 1841, the tract of land on which the prisoner resided, where the murder was committed, was sold by F.A. Muir, the executor of his father's estate, at public auction, and purchased by the prisoner on a credit of 1, 2, and 3 years, bonds and a deed of trust on the land to secure their payment being given, that the prisoner had not been able to pay the bonds as they fell due, and that in the latter part of 1845, the prisoner was pressed to pay them, and was informed that unless paid before Christmas of the year 1845, the land would be sold under the deed of trust, that the prisoner was unwell about that time, and was not called upon at Christmas, and that on the 23rd of February, 1846, there remained due about $3,000. Here, then, was the powerful inducement which prompted Epes to commit the foul deed. He owed a debt which he was unable to pay. He had expected to get the money from the bank on a note, which he hoped Bevel and Booth would endorse, as he confessed to B.J. Vaughan, but had not been able to do so. His forbearing creditor had gone over to obtain payment with the bonds in his pocket. The last day of grace had arrived, and the next step was to be a sale of his house and home over the heads of his family. Let us now, gentlemen, review the circumstances proved in the cause, tending to prove that the prisoner yielded to this strong temptation, and perpetrated the dark deed with which he stands charged. On Sunday evening, the deceased arrived at his brother John's residence about 4 miles from the prisoner's, about 6 o'clock in the afternoon, and remained there that night. The next morning, February 23rd, he left his brother's on horseback, having Epes' bonds in his possession, alleging that he was going over to the prisoners to receive payment of the amount due. It was furthermore agreed that the deceased was returned to John Muir's, where he was to stay that night, as John was unwilling that his wife should remain alone, he, John, having to go to Petersburg that day. It was furthermore understood that on Tuesday morning John Muir's wife was to go over to her father's, William H. Cousins, and the deceased was to meet John at Peter Boisseau's, about 5 or 6 miles from Petersburg, where both were to stay on Tuesday night. The deceased did go to the prisoners. He himself has over and over admitted it, and Mrs. Harrison has proved it. Mr. Harrison also proves that after the deceased had stayed there not very long, she saw the deceased and the prisoner riding off together on horseback out of the front gate, the prisoner with a gun, the deceased without one, that they thus left the house about 10 o'clock in the forenoon. That, gentlemen, was the last time the unfortunate young man was seen alive. Several witnesses have proved that diligent inquiries were made in the neighborhood, in Petersburg, amongst his acquaintances, and in every way that would probably have elicited information had he been seen, but all to no purpose. Nobody has ever been found who professed to have seen him after Mrs. Harrison proved he left the prisoner's house, but the prisoner himself, who said he saw him in Petersburg on the 4th of February. His body was found buried in a secret spot on the prisoner's plantation, not more than 1/4 of a mile from his house. John Muir proves that he himself left home on the 2nd of February, after the deceased had gone to Epes, went on towards Petersburg, stayed at Peter Boisseau's that night, went on to Petersburg the next morning, and returned to Peter Boisseau's on Tuesday night, expecting to meet the deceased there according to their previous arrangement. The next morning, Wednesday the 4th, he left Boisseau's on his way and met Epes on the road, who told him he was on his way to Petersburg, where he had agreed to meet the deceased and settle with him, that he had called at John Muir's, expecting to find the deceased there, so that they might travel down together, but had found the house shut. The prisoner went on towards Petersburg, and John Muir went on home. About 8 days afterwards, the prisoner went over to J. Muir's and handed him a letter, purporting to be from the deceased, dated the 4th of February, which has been read to you. The letter was sealed. The prisoner went on to state to J. Muir, in substance, the contents of the letter, alleging that he had heard the statement from the deceased at Jarrett's Hotel. This letter is proven by the most incontestable evidence to be in the handwriting of the prisoner, and was delivered out of his own hand, sealed to John Muir. It happens that it can be proved by Jarrett's books, as you have heard in evidence, that the prisoner was at Jarrett's Hotel in Petersburg on the 4th of February, but no proof that the deceased was there. The prisoner gave no intimation that he wrote the letter for the deceased. That it was not dictated by the deceased seems manifest. After the arrangement which had been made about the deceased staying with J. Muir's wife on Monday night, does it not strike you as most unnatural that in this pretended letter he could make no excuse for violating his promise, that he should not mention where he stayed on Monday night? If, gentlemen, he was not murdered on Monday, is it possible that after so much excitement and inquiry, there should be no one found who could tell you where he was on Monday afternoon, and where he stayed on Monday night, and where he stayed on Tuesday night, the 3rd? You will observe also the improbable statement in regard to the horse contained in this letter. The horse was Peter Boisseau's, who had owned him many years. From your knowledge of the nature and habits of this animal, is it not most improbable that if he got away from the deceased, as pretended, he would have remained astray for a week without going to J. Muir's, where he had been staying, not more than a mile or two off, or to Pete Boisseau's? He was found on Mr. Bailey's plantation a week after F.A. Muir's disappearance, a plantation adjoining Epes's, where he had been last seen by Mrs. Harrison when the prisoner and the deceased rode off together. The next link in this strong chain of testimony is the fact that the bonds belonging to the estate which John Muir proves the deceased had in his possession on the morning of the 2nd, when he went over to the prisoner's, are next seen in the possession of Epes the prisoner. This is a powerful circumstance. But what next? John Muir tells you that when Epes exhibited the bonds to himself and William H. Cousins, the trustee, upon the occasion of his applying for a deed of release, one of the bonds had a receipt in full upon it, purporting to have been signed by Francis A. Muir, that at that time he had no suspicion of any foul play, and did not scrutinize the handwriting closely. He knew that they were on the identical bonds which his brother had held, and seeing them in Epes' possession, and having received the letter just mentioned, and then believing all to be right, he consented to the release. He furthermore stated that on the 9th of July, after his suspicions had been aroused, and after the neighbors had assembled to search for the body, and after Epes had been informed of those suspicions and called upon to explain, he again produced those bonds, that he, J. Muir, then noticed the signature of the deceased on the back of the bond, particularly, and stated openly in Epes' presence that the signature was not his brother's writing. That afterwards, on that same day, in the presence of Robert C. Booth, the prisoner offered to J. Muir and P. Boisseau to pay the amount of the bonds over again without suit. Since that time, these bonds have never been produced. These circumstances show foul play. If that receipt be genuine, Why is it not produced here before you? When all his neighbors and friends were around him, calling for some circumstance tending to relieve their minds from the suspicions forced upon them, when all suspected that F.A. Muir had been murdered on the 2nd of February, that circumstance could have so well dissipated all suspicion as proof of his having executed with his own hand a receipt on the 4th. Had he not felt conscious that the receipt was a forgery, would he not have kept it as the apple of his eye? The prisoner's family's connections are numerous, wealthy, and respectable. If evidence could have been procured to prove the genuineness of that receipt, can this jury believe for a moment it would not have been done? But, gentlemen, are these bonds the only property of the deceased found in the prisoner's possession? Where was his watch found? It has been proved by J. Muir, as you will remember, that the deceased had the watch on the Sunday evening before the fatal 2nd of February. Is there a man upon that panel who doubts that the watch which the prisoner traded off to Mr. Lumsden on the 21st of May, 1847, was the same? Mr. Lumsden said Epes brought the watch into his shop in Petersburg, he being a watchmaker, and offered to trade it off, alleging that he wished to get a lady's watch, that he examined it, found it had been jarred as from a fall, and advised Epes to have it repaired, telling him it was a very fine watch, and could be repaired for $5 or $6. Epes replied he would prefer trading it off, and finally traded for a gentleman's watch, about the same size and thickness, giving Lumsden $20 to boot, instead of getting a lady's watch. And it is quite likely, gentlemen, the watch he got was worth $20 less than the one he gave. Now, where did he get this watch? Peter Warsaw, Jonathan A. Muir, and William A. Muir proved that it was the watch of the deceased, so far as they could judge from general appearance from long acquaintance. But providentially, Mr. Lumsden is enabled to identify it with certainty almost infallible. In 1843, William A. Muir had carried this watch at the request of F.A. Muir to Mr. Lumsden's to be repaired. Mr. Lumsden, as is the custom of watchmakers, entered on his books the number and maker's name, repaired it, and delivered it to F.A. Muir. In May 1847, Epes traded this watch off with the same watchmaker, inquiry being made about it after Epes was suspected of being the murderer of Muir. Upon reference to his books, Lumsden ascertains that the watch he repaired for F.A. Muir in 1843 was the same watch he received of Epes in May 1846. William A. Muir proves that F.A. Muir had kept the same watch from 1843 till his disappearance. Around the neck of the deceased, when found, it is proved there was part of a watch guard which appeared to have been cut with a sharp knife. How did the prisoner come to the possession of this watch? It was certainly the property of the deceased, and was in his possession when he went to the prisoner's on the morning of the fatal 2nd of February. Can you resist the conclusion that Epes first murdered the deceased, then rifled his pockets of the bonds, and then taking his watch without waiting to take the guard from around his neck, hurriedly cut it with his knife and pocketed it himself? I anticipate that the prisoner's counsel would contend that we have not identified the watch as Muir's. You will be told that it is a possible thing, yes, that our own witness, Lumsden, admits that it is a possible thing for the same maker to put the same number on two different watches. Indeed, that he has seen watches with the same number and the same maker's name. But, gentlemen, remember Mr. Lumsden said that it was only on very common, indifferent watches that this occurs, watches on which the real maker's name is not placed, but some other name than his, that he has never known this to be the case in fine watches, such as this was, that when a maker makes a good watch he puts his own name on it, that he may establish his credit, and that in all his experience he has never known two fine watches made by the same maker with the same number on them. Watchmakers, gentlemen, number their watches as regularly as banknotes are numbered. They commence with number 1 and go on progressively and regularly. but I will not detain you longer in reviewing the testimony which so fully establishes the identity of the watch. We have thus, gentlemen, produced on the part of the Commonwealth what seems to me conclusive evidence, first, of the identity of the body of the deceased, second, that the letter of the 4th of February was in Epes' handwriting, third, that the receipt on the back of the bond was a forged receipt, and fourth, that the watch of the deceased was soon after the murder in the prisoner's possession. Now I call for the proof to rebut those facts. Where, among all that vast concourse of people who saw the dead body, is the man who will say he did not believe it to be that of Adolphus Muir? Where is the witness who will swear he believes the handwriting of the letter not to be Epes's? Where is the witness to prove that the receipt on the bond is genuine? Where is the bond itself? Who is brought to prove to you that Epes was the owner of that watch? Where did he get it? How long had he carried it? The prisoner furnishes you no proofs to excite a doubt as to the truth of the evidence thus produced against him. End of section 47. Section 48 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of William Dandridge Epes for the murder of Francis Adolphus Muir, Petersburg, Virginia, 1848, Part 3. There is another circumstance to which I will now call your attention, connected with this watch, which seems very important. The prisoner had met the assembly of his neighbors, had heard face to face a statement of their suspicions, had witnessed with undaunted boldness the search made for the dead body, even when within a few paces of the grave, had firmly withstood the earnest appeals of William M. Gill in regard to the source from whence he had obtained the money to pay off the bonds he pretended to have taken in. All this he had withstood, unintimidated. He saw that without proof no harm was to be done him, and yet, so soon as it was rumored about Petersburg that the watch had been found, and sufficient time had elapsed for the intelligence to be communicated to him, we find him suddenly and rapidly absconding and fleeing beyond the confines of the United States. But, gentlemen, those bonds and the watch were not the only property of the deceased which we can trace to the prisoner's possession. You have heard a letter read, purporting to be a letter written at New York by the deceased, dated February 14, 1846, addressed to Jonathan A. Muir, Darville's. This letter is proved by V.J. Vaughan, Perry L. Derby, and C.P. Bevel to be in the handwriting of William Dandridge Epes. Several other witnesses have proved that it is not in the handwriting of F. Adolphus Muir, and here again we look in vain for any rebutting testimony. No one among the numerous acquaintances of these two individuals, both men of business and men of good education, who will say that he believes that letter not to be in Epes's handwriting, and no one who will say he believes it to be F. Adolphus Muir's. Can there be a rational doubt as to the fact that the prisoner wrote that letter? Or did that letter contain two bonds which Jonathan A. Muir proves were in the possession of the deceased the morning of February 2nd, when he left his house? It was certainly a most ingenious contrivance to lull suspicion and confirm the impression on the mind of Jonathan A. Muir that his brother had in fact gone to New York. But so soon as suspicion was excited and the letter and circumstances canvassed, we find manifest evidence to confirm the belief that Epes wrote this letter. It purports to have been written, as before stated, at New York on the 12th of February, and was, as appears by the postmark, mailed at Petersburg February 26th. Where was Epes on the 26th? Marcus J. Gaines tells you he was in Petersburg, that he slept in the same room with him the night of the 25th in Petersburg. Upon reading that letter, you see that the deceased is represented as being so penurious as to send this letter by a stranger in order to save 5 cents. But again, you will find in the letter the following remarks. You find this letter mailed from Petersburg. I met with the gentleman on his way to that place, by whom I sent it with the request to have it mailed in Petersburg to Old Darville's. Was there ever a more bungling blunder? You find this letter, etc. I met with, etc., by whom I sent it, etc. The writer of that letter had in his possession 2 bonds which were enclosed in it, and which the deceased had in his possession when he left J. A. Muir's on the morning of the 2nd of February. Who was the writer of that letter? Is not the evidence conclusive to show that it was the prisoner at the bar? But, gentlemen, there is a 3rd letter. It purports to have been written by a man named Junius P. Rawlins. Where was Epes on the 23rd of May? Mr. Fenn tells you he arrived at his hotel in Petersburg the 20th of May and remained till the 25th. Mr. Lumsden tells you he was in his store in Petersburg on the 23rd and traded off the watch as before stated. Who wrote this letter? The same witnesses, Von Derby and Beville, prove it to be Epes's. Mr. Derby, a very intelligent gentleman, well known to you all, I believe, to be a just, calm, conscientious man, tells you that although there is manifestly a great effort to disguise the hand, which you yourselves, gentlemen, upon inspection will perceive, especially in the capitals at the commencement of the letters, yet there is scarcely a line in the letter where his handwriting is not manifest. That this whole letter is a tissue of falsehood you cannot doubt. Let us read it. Here Mr. May read from the letter. Now, gentlemen, what is the impression intended to be produced by this letter? Why, that Adolphus Muir had collected this money, which, as executor, he had a right to collect, and in which his brothers and sisters had an equal interest with himself, had gone off with it to New York, had absconded under pretense of going to Missouri, had then thrown his hat into the river so as to induce his family to believe he had been accidentally drowned, and had gone off under a fictitious name with the money, intending to appropriate it all to his own use and defraud his brothers and sisters out of their just proportions. Who wrote this letter? The prisoner at the bar. Gentlemen, was it not enough to have deprived this amiable, unsuspecting young man, his friend, of his life, to have murdered him in cold blood, and to have rifled his pockets? But much deeper injury be inflicted on him. Must he be robbed of his character also? Was it not enough to inflict it upon his affectionate relatives, the loss of one so dear to them all? But must they suffer the severe pain of having it instilled into their minds that their brother in whom they had confided had proved to be a dishonest man, had defrauded his family, and either absconded with the money or destroyed himself by committing suicide? I said in the commencement of my remarks that I desired to apply no harsh epithet to the prisoner, but what epithet could indicate so deep a state of depravity as the bare recital of the conduct of the prisoner, as proved in this cause? But there is other evidence tending to prove who was the writer of this letter. There are other corroborating facts proved, showing that other efforts were made to insinuate into the public mind a belief of the suspicion attempted to be inculcated by this Junius P. Rawlins. Pointing to the prisoner, what did the prisoner say to produce that impression? He asked Mr. Gill if it was not as reasonable to suppose that the damned rascal had run off with the money with the intention of cheating his brothers and sisters, as that he should have murdered him. He, forsooth, is so great a gentleman that he is above suspicion. What? Could he be suspected of committing so base an act? He who was so high and lofty that he would not condescend to speak to his poor neighbors, nor to a member of a patrol in the discharge of his duty who went to his house. Mr. Joines, what evidence was there to that effect? I appealed to the court. Mr. May, I beg pardon for having referred to that circumstance which, I admit, was not in proof before the jury. I am glad the counsel interrupted me. Both he and the court, I am sure, are aware how I was led to refer to that fact as if it had been in proof before the jury. Footnote: the circumstance here referred to by Mr. May was stated by a freeholder summoned as a juror who was sworn on his voir dire and made the statement before the panel was completed and the jury impaneled. End of footnote. I regret that I was not sooner interrupted, for if I know myself, I would not state a single fact to the prejudice of the prisoner, which I am not warranted in doing by the legal evidence in the cause. The impression, gentlemen, which Epes attempted to make on the mind of the public was identically that which this letter of Junius P. Rawlins was intended to inculcate. You recollect the same idea was presented in the conversation he had with Dr. Jethro Hurt. Before he knew he was suspected, he sought to make Dr. Hurt believe that Mr. Muir had gone off with the intention of defrauding his family, that he had proved to be a villain. There are other circumstances showing that the same individual who wrote the New York letter wrote the Junius P. Rawlins letter. If you will observe the word New York, which occurs in both letters, you will see they are perfect facsimiles of each other. You will also observe that the word Missouri, which also occurs in both letters, is misspelled Missouri, M-I-S-O-U-R-I. I do not observe another misspelled word in either letter. Is it not remarkable, then, that Mr. Muir, who had resided in Missouri, should not have known how to spell the word correctly, and that J.P. Rawlins, who had spelled every other word in a long letter correctly, should have made the same blunder? You can readily account for it when you learn that the same hand, that of the prisoner at the bar, penned both. You see that all the testimony tends the same way. The main stream of itself would bear you on to the same conclusion, but all the minor currents falling in with it still increase the tide and make it more irresistible. I know it is important you should be satisfied beyond a reasonable doubt that the prisoner wrote both these letters. Perhaps the similarity of the handwriting of the word New York, the mistake in the spelling of the word Missouri, the concurrence of sentiments as expressed in one of those letters, which those expressed by the prisoner to Mr. Gill, Dr. Hurt, and others, would not be alone sufficient. But when these are brought in to corroborate the positive evidence of B.J. Vaughan, Perry L. Derby, and C.P. Bevel, that they are the prisoner's handwriting, the negative evidence of P. Boisseau, Dr. Thompson, and John Muir, that the New York letter is not in the handwriting of F.A. Muir, and further, when you take into consideration that among all the numerous acquaintances and the intelligent, wealthy, and respectable family connections of the prisoner, not one has been produced to testify either that he believes the letters to be Muir's, or that they are not the prisoner's handwriting. Can you, gentlemen, harbor a rational doubt as to their authorship? Are you not forced to the conclusion that the prisoner wrote all three of those letters? Another circumstance to prove the prisoner's guilt is his flight, his escape. You will be told, no doubt, that flight is no proof of guilt. It is admitted that if there were no other evidence against the prisoner than the fact of his flight, you might entertain doubts. We can well imagine the case of a man without friends or connections, charged with a heinous crime, who, though innocent, might flee. There have been such cases reported, and probably some may be read to you by the prisoner's counsel. But this is not such a case. The prisoner had had abundant proof that no violence would be done him. He had numerous relatives and friends. He had witnessed the cautious prudence of those who suspected him, how unwilling they were to make the charge, how solicitous that he should clear himself if innocent, even after the watch had been found. What an unwillingness there was to arrest him unless further proof could be obtained. And why? Because of his previous character, of his respectable family connections. No one was willing to believe him guilty of so base an act without the strongest testimony. Had he been a timid man, had he been a stranger in a foreign land, his flight would not have been so strong a circumstance of guilt. But he was not a timid man. He had faced with calm courage a host of his neighbors, who could have demolished him in an instant had they been disposed to act without proof. He was not a stranger, but was with his family and friends. What then but conscious guilt could have induced him to fly from his home, his country, his family and his friends, to seek under a false name an asylum beyond the limits of the United States? I appeal to you, gentlemen, whether in this case the prisoner's flight is not a powerful circumstance against him. But there are minor circumstances all tending to swell and strengthen this strong current of proof of guilt. How was the grave discovered? You have been told by Mr. Allgood that it was through a slave named Ross, then the property of the prisoner. The prisoner had made his escape on the 11th of July, and on the 15th of July, Ross shows the grave. Now remember, Mr. Harrison, the overseer, proves that on the last day of January he had finished burning one plant bed, and the next Monday, which was February 2nd, had commenced getting up another. He remembers that in the early part of that week, what day he does not state positively, when he left the plant bed, where Ross was engaged cutting wood to go to his dinner, he left Ross at work. He returned to the plant bed after dinner, and Ross had left his work. He did not see Ross, that is, Ross did not return to work till the second day after. Now, gentlemen, if it be surmised that Ross might have committed the murder, I think you will see that it could not be. Mrs. Harrison proves that Mr. Muir left Epes in the early part of the second day of February. Mr. Harrison proves that Ross was at work on that very day till the afternoon. I admit Mr. Harrison does not prove that Ross did leave his work on Monday. It might have been Tuesday or Wednesday, but it certainly was not till the afternoon of either Monday or Tuesday, or some other day of the first week in February. And as Mr. Muir left there in the early part of Monday, Ross could not have seen him. Besides, there was a want of inducement on the part of Ross to commit such an act, as well as the improbability that he could have procured a gun. The irresistible conclusion to which this testimony must bring to your minds seems to me to be that the prisoner murdered Muir in the morning and had the services of Ross in the afternoon of the 2nd, and the whole of the 3rd of February, in burying and concealing the body, and that on the 4th, after Epes left home for Petersburg, Ross returned to his work under the overseer. This view is strengthened by the circumstances related by Mr. Harrison of the subsequent disobedience of Ross, and of interference of the prisoner in his behalf, and especially his informing the overseer that he was no longer to consider Ross as under his control. The circumstance that the deceased was shot with buckshot, and that Mr. Bailey had, a few days before, sent the prisoner some buckshot, and the further circumstance that the horse of the deceased was found at Mr. Bailey's, adjoining the prisoners, are not to be overlooked. Alone, they would have but little weight, but in this case every circumstance, whether strong or weak, tends to point to the prisoner as the perpetrator of this bloody deed, and taken together they form a chain which cannot be broken. But last of all, gentlemen, comes the voluntary, unsolicited confession of the prisoner. On the 24th of February, 1848, the prisoner was arrested for the murder of F.A. Muir by B.J. Vaughn in the town of Nashville in the state of Texas, by authority from the governors of Virginia and of Texas. Mr. Vaughn traveled with him in custody on his way back to Virginia that day, and set out the next morning again on his journey. After proceeding some miles on that second day, the prisoner, himself introducing the subject, remarked that he had seen a statement in the paper that he had murdered a hog drover, his own son, and his mother-in-law, that he was not guilty of those charges. This case is bad enough. He then, in reply to inquiries by Mr. Vaughn, described how he buried and concealed the body of Muir, stated that he was with the company who searched for the grave, and that some of the company came in a few feet of it. Also that he had not paid the bonds, having been disappointed in getting money, etc. Compare this acknowledgement in regard to the non-payment of the money with what poor F.A. Muir was made to say in the letter of February 4th, which was handed to John Muir by the prisoner, and say, can all these facts be consistent with the innocence of the prisoner? Do they not prove beyond all rational doubt, almost beyond the possibility of error, that the prisoner is guilty of this grave charge? I have thus, gentlemen, reviewed the whole testimony in this cause. I have endeavored to do so calmly and justly, and while I have nothing extenuated, I have endeavored to set down naught in malice. To say that I do not feel indignant towards the perpetrator of an act, such as I think the evidence so clearly proves the prisoner at the bar to have perpetrated, would be to acknowledge myself devoid of all honorable sensibility. At the same time, I hope and believe I have not suffered my feelings to bias my judgment as to the weight of the evidence, nor to betray me into any misstatement of the proofs. I have attempted to state the evidence fairly, and to deduce from it none but fair and just inferences. Is there any man of proper feelings, any man who has a heart to feel, who would not desire to see the perpetrator of such an act as I think the evidence in this case proves the prisoner to be guilty of, punished according to law? Who would be willing to see him go unpunished? Ought not the attorney prosecuting on behalf of the Commonwealth to exert every lawful effort to bring the offender to punishment? Ought the jury to hesitate, whatever may be the consequence, to do their duty like men, and bring in a verdict according to the fair, legitimate effect of the law and testimony? Ought the judge to hesitate, should you find the prisoner guilty, however severe the penalty imposed by law, to pronounce the sentence which the law imposes? If he be found guilty and condemned, the fault will not be mine, nor yours, nor that of the judge, but of his own evil heart. Neither the attorney who prosecutes him, nor the witnesses who testify against him, nor the jury who finds him guilty, nor the judge who passes sentence on him, nor the executioner who may execute him, should he be condemned to death, should feel one pang of regret that the guilty perpetrator of such a deed shall have been brought to justice, or that they should have been the instruments of bringing about the result. All should feel regret that anyone should be found base enough to commit such a crime, but all should be willing to meet cheerfully the responsibility of vindicating the outraged majesty of the law. Take the case, gentlemen, and decide it under the solemn sanction of the oath which you have taken, according to the law and the evidence which you have heard. End of section 48. Section 49 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of William Dandridge Epes for the murder of Francis Adolphus Muir. Petersburg, Virginia, 1848, Part 4. Mr. Rives for the prisoner. Mr. Rives. Gentlemen of the jury, I rise to open the defense for the prisoner at the bar, under a state of embarrassment far more weighty than any which I have ever heretofore experienced. The great responsibility which rests upon us all must now be met, and I am free to confess, when viewed in connection with what has passed before us, I doubt whether we can divest ourselves of all the extraneous influences which have operated upon our passions and aroused our sympathies during the examination of the witnesses, whether we can stem the torrent of public indignation on the one hand and sever the cord of sympathy on the other, which has been woven by the eloquent tears of the relatives of the deceased. This heart-rending spectacle was witnessed by you. This feeling is known to exist to a certain extent by all, and I pray you to search well your own hearts, test yourselves, and recollect those wise words of Solomon. Man, know thyself. Yes, gentlemen, know yourselves. Know that the 1,000 outdoor rumors are running against the prisoner at the bar cannot and shall not have any influence over your minds. Know that the deep-rooted prejudice which is known to exist in the bosoms of those who are now present, and I may add, of the entire community, shall not intimidate you in the discharge of your duties. Whatever impression may have been made on your minds by the many rumors which have spread far and wide over the land, I ask you now to forget. Yes, gentlemen, forget all but your oaths, the testimony, the Commonwealth, and the accused. This I know you can and will do. But can you, in the face of what has transpired before you, resist the rush upon your sympathies, caused by the eloquent tears which softened the accents and melted the hearts of the two intelligent brothers, who were testifying as to facts which they believed established the death of a favorite brother, and that the prisoner at the bar was his murderer? It was a rich, a lovely scene. What nobler impulse of the heart, what purer stream of nature, than the briny tear tracing the redolent cheeks of a heart-stricken brother? What heart did not sympathize when the swimming eye and palsied tongue told what grief had the mastery? Who, I ask, did not wish to weep with them? Sirs, I loved the manly tear. I felt that, in it, I saw the inner man was right. I looked back at my own days of sorrow and recollected that I, too, had had to weep over a dead brother. I looked on you all and thought that you, too, might have had the same sad duty to perform, the same feelings of grief to give vent to, over the death of a son, a wife, or a brother. Then it was I thought I saw an impression made upon your feelings, which I feared and still fear it would be difficult, if not impossible, for you to eradicate, and approach this trial uninfluenced by its operations. But justice, truth, and the oath you have taken all tell you that it must be done. Then know yourselves. Know that your minds are in such a state that you can stand indifferent between the Commonwealth and the accused. Recollect that before you sits the prisoner, downtrodden, humiliated, one against whom every hand seems to be turned. Recollect that he has no friend upon earth to do him justice, save yourselves, the jury of his country. Recollect that you are sitting upon the trial of a fellow being, that you are sitting upon the trial of one made in your own image, aye, in the image of God himself. Recollect that the great ruler of the universe, who sees and knows the deeds of all, has spared his life from the origin of this charge to the present day, that you are now treading on holy ground, upon the confines of divine power. Recollect that the glory and beauty of our institutions guard him against such a sham trial as was awarded to Christ, the Savior of man. There the cry of crucify him, rung in the ears of the judge. Here, however depraved and abandoned he may be, he is entitled to an impartial trial by a jury of his peers, and I thank God that there is no man so reckless and so lost to honor who will, in the momentous struggle against all odds for the life of a fellow creature, cast the sword of Brennus into the scales of the Commonwealth. I will now, gentlemen, attempt to meet some of the arguments advanced by the prosecutor for the Commonwealth, Mr. May, who has opened the prosecution in a spirit of candor and fairness, which is so characteristic of that gentleman, and permit me here to say in advance, in the presence of his honor, and in the hearing of all here assembled, that it is not my intention to reflect upon the credibility or to attempt to impeach the veracity of a single witness who has been examined. On the contrary, I will say for them that for integrity, intellect, and respectability, I have never seen them surpassed in the trial of any cause, either civil or criminal. But you must recollect that what they testify to are circumstances and facts founded on their belief, from which you are to draw conclusions. Not one of them has told you that he saw William Dandridge Epes strike Francis A. Muir a blow, or give him a harsh word. If such an assertion had been sworn to by any one of them, I should have turned my back upon the prisoner, and left him to you to have inflicted upon him that punishment which he would have so richly deserved. It is your province to look at all the circumstances, weigh well the facts, and when you shall have done so, if there is not a rational doubt on your minds as to the guilt of the prisoner, then you must find him guilty. If, on the other hand, you have any such doubts upon any fact or circumstance necessary to his conviction, then he is entitled to that doubt, and you must find him not guilty. Like yourselves, before I heard the evidence, I was induced to believe from the rumors afloat that the proof at the trial would be so full, clear, and convincing that the work of conviction would be complete. Instead of that, we find a long train of circumstances from which you are to make up your verdict, which will require more than ordinary effort of the mind to give to each its proper place, and that weight to which it is entitled. It was the close and studied effort of the counsel for the Commonwealth to bring to your notice every circumstance which he thought would operate against the prisoner, and with like tact and ability, he failed to mention one single fact that might be considered in mitigation or explanation of the conduct of the accused. In reviewing the positions which that gentleman assumed to be true, I shall, unlike him, after stating the facts, leave you to come to such conclusions as you may think proper, right, and just. I shall not tell you any fact is so or not so, because I hear witnesses say they believe from circumstances such facts do exist. It is for you, after you shall have heard the testimony of witnesses, to see whether their opportunities of seeing, discriminating, and judging were such that they might not reasonably err in what was supposed to exist. The whole of the evidence being presumptive or circumstantial, I ask you as an act of justice to the prisoner, as a duty you owe yourselves, to weigh well the bearing of each and every circumstance which has been laid before you. You were told there was no doubt of the guilt of the prisoner, that the Commonwealth had a case so clear that he who runs might read. Why, gentlemen, cast your eyes around, and let the Commonwealth tell you why it is that she has brought to her aid the forensic eloquence and legal abilities of my worthy friend, Mr. Thomas S. Lawson, who now occupies a stand at the head of his profession in his own town, and I may almost say in the circuit. Why, I ask, were his services engaged, if it were not by argument and ingenuity, to remove some doubts which it feared might defeat the effort to obtain a verdict of guilty? There can be but one opinion about the Commonwealth being here, doubly present today. Think you, gentlemen, if the Commonwealth's prosecutor had to carry this book, holding up a book, across the room, anybody would ever think of employing an assistant to act with him? Your good sense will at once answer no. But if he had to carry a weight which he could not himself well manage, then there would be necessity of aid for fear of a failure. So it is here, not that there is any fear that the legal and rightful prosecutor cannot fully and ably represent the interest of the Commonwealth. None who know him doubt his ability to do this, but there is fear that he cannot draw the picture dark enough. Hence, you find the talents of my friend enlisted, whose eloquent tongue is more powerful than the pencil of the painter in coloring his canvas. But I warn you, gentlemen, to act for yourselves. Yours will be the troubled conscience, if in an unguarded hour you should bring in a hasty verdict that might cause future regrets. You were told by the prosecutor that the prisoner stood charged with the murder of F.A. Muir, and that it was necessary to prove that the dead body found on the plantation of the accused was the body of F.A. Muir. To do this, he referred you to the testimony of Messrs. John A. Muir, B.B. Vaughan, M.J. Gaines, Dr. Thompson, and others, who all spoke with great certainty as to the identity of the body, the preservation of the features, except the nose, all of whom seemed to be satisfied that they could not be mistaken. The characters of these gentlemen stand so deservedly high that it will not be necessary for me to apologize for attempting to show from scientific medical authorities that if the murder of F.A. Muir took place at the time when he was last seen with the prisoner, to wit, on the 2nd day of February, 1846, that it would have been impossible, if the authors to which I refer are correct, for any or all of them to speak with that certainty of the identity of the dead body, as to leave no doubt about the probability of their being deceived. You will remember, gentlemen, that each and all of them stated that there were no peculiar physical marks on the body, or private mark on the clothes by which they could identify it, only from its general appearance after death, when compared with the resemblance in the mind's eye in life, did they pretend to speak of its identity. And here, gentlemen, let me appeal to you as men of experience and observation, to reflect on the sudden changes from life to death. What do you often hear is the first expression of those who are looking on the corpse of some deceased friend? "Oh, I never saw anything like it. He looks as natural as life." Whilst of others you hear it frequently said, "Bless me, I never saw such a change. He does not favor himself at all." I venture there is not a member on that panel who has not heard such declarations within 48 hours after the death of some friend or acquaintance. Yet you are called upon, in the face of your own observations and every day's experience, to give up settled facts which have come within your own knowledge, and place implicit confidence in the opinions or belief of others, who, like all of us, are liable to err. The witnesses formed their opinions from what they saw before them, and you are to decide whether, under the circumstances, the condition of the body, the length of time it had been interred, whether it was such that they could not only tell that it was the body of F.A. Muir, but that he was murdered by the prisoner on the 2nd of February, 1846. Bear in mind that the body was disinterred on the 15th of July, 1846, and consequently, if it was the body of F.A. Muir, and that he was murdered on the 2nd of February, 1846, it must have lain in the ground, in a shallow grave, for such is the proof, for 5 months and 13 days, without a coffin, and nothing to protect the face save a thin handkerchief thrown over it. You are aware, gentlemen, that Dr. Thompson, an intelligent physician, introduced by the Commonwealth, was examined as to the degree of temperature and condition of the body after death, most favorable to putrefaction and decomposition. How long before putrefaction commences, and on what parts of the body it first takes place, to which questions the doctor gave answers as accurate as is usual for one who has not had much experience in post-mortem examinations of bodies, with a view of ascertaining their identity, his present recollection not coming up to his early reading, and differing in some important particulars from standard writers on medical jurisprudence. Permit me, in order to remove every doubt, to read from such works as are recognized to be eminent in this branch of their profession, that the above position may be clearly defined. First, temperature necessary to putrefaction. Guy's Medical Jurisprudence, page 385. Putrefaction is arrested by a temperature of 212 degrees and of 32 degrees. In the former case, the body is reduced to dryness by the evaporations of the fluids. In the latter, the fluids are congealed. The most favorable temperature is from 70 degrees to 100 degrees. Putrefaction, therefore, takes place more rapidly in summer than in winter, and other things being equal, varies with the temperature. Mode of interment. Guy's Medical Jurisprudence, page 388. In dry, elevated situations, putrefaction goes on slowly. In low, swampy grounds, rapidly. A dry, absorbent soil retards, a moist one accelerates putrefaction. The nature of the soil exercises an important influence. In sand or gravel, the change goes on slowly, and adipocere is rarely met with. The deeper the grave, certius paribus, the slower the putrefaction. The more completely the body is defended from the air by clothes or coffin, the more slowly does putrefaction go on. It is rapid where the body is exposed to the soil, but very slow when buried in a coffin hermetically sealed. Where does putrefaction commence? Guy's Medical Jurisprudence, page 385. The body naturally contains in all its parts moisture enough to ensure its decomposition, but those parts which contain the largest quantity of fluid are most prone to putrefaction, e.g., the brain and eye. Dropsical subjects, again, putrefy more speedily than those which are free from accumulations of fluid. How long before the features are destroyed? 2. Beck's Medical Jurisprudence, page 40. Orfilos says, in all his examinations of disinterred bodies, every portion of the face was destroyed between the 3rd and 4th month, although the bones remained slightly attached by their articulations. Let us now apply the test here laid down to the body sworn to by the witnesses. You find that the body was interred in a shallow grave, without a coffin, and nothing over the face except a handkerchief. For 1/3 of the winter, the entire wet season of the spring, and exposed to the sultry heat of half the summer, combining in the course of that period not one, but all the elements necessary to putrefaction, to wit, shallow grave, exposure of the body to the earth, the face particularly, moisture, and a temperature ranging as high as summer heat. Further, that part of the body, the eye and brain, under any circumstances most likely to putrefy first, being actually in a situation more exposed than any other. Did it lie in the ground long enough to undergo putrefaction? The writers say from 3 to 4 months. Here the proof is, it lay in the ground 5 months and 13 days. Gentlemen, is the experience of such men as Beck, Guy, and Orfila to be thrown away as not worth the paper on which their opinions and reports are written? I cannot and will not believe it. Writers who had obtained such eminence in their profession will be regarded by you as laborers in the vineyard of science, and you will give your opinions that weight, which they justly merit. The effort to identify dead bodies which had physical marks upon them has led to such glaring and flagrant errors that I beg leave to read you the celebrated case of Timothy Monroe and its identification with that of the murdered Freemason, William Morgan. Guy's Medical Jurisprudence, pages 31 and 32. The reader will, in this connection, call to mind the celebrated case of the discovery of the body of Timothy Monroe on the beach of Lake Ontario in 1827, and its identification with that of the murdered Freemason, William Morgan. The body, when found, was much bloated and in an advanced state of decomposition, and the coroner's jury gave in a verdict that it was the body of some person unknown to the jury, who had perished by drowning. The body was therefore interred. A rumor, however, soon got into circulation that this was the body of William Morgan, who had disappeared 13 months previously in a mysterious manner, and of course must have resisted the action of a summer's heat and a winter's cold, and still retained the form and semblance of the human form. The body was disinterred, another jury summoned, and a second inquest was held on the 15th of October, 1827, 8 days after the first, at which Mrs. Morgan was summoned, together with the family physician, John D. Henry, M.D., of Rochester, and several others who were intimately acquainted with Morgan during his lifetime. Mrs. Morgan testified that she had not a particle of doubt of the identity of the body, that she fully believed it to be that of her husband. It was bald, had a gray beard, with long white hairs in the ears, and much hair upon the breast. The left arm had the marks of inoculation upon it. Her teeth were double all around. In all these respects, the resemblances were said to be exact. 2 of Morgan's teeth had been extracted. The dentist who extracted them was now present, having the teeth with him. The body had also had 2 teeth extracted on the same side of the face, and the teeth held by the dentist fitted them as exactly as if they had been drawn from thence, while the hair, hands, feet, nails, fingers, and toes were, in Mrs. Morgan's opinion, exactly like those of her husband. A surgical operation had been performed upon the large toe of the left foot, which gave it a peculiar conformation, and precisely so was it with the body under examination. In short, it appeared most conclusively and beyond a doubt, from the testimony of many witnesses, physicians and others, that the body was that of William Morgan, and none other. The dress, however, bore no resemblance whatever to that worn by Morgan when he disappeared, or that he had ever worn. The pockets also were filled with tracts, published by the British Tract Society, a kind of publication which Mr. Morgan had never been known to be partial to, or to patronize particularly. Still, the verdict of the coroner's inquest was that the body was that of William Morgan. The body was therefore removed to Batavia and buried with great pomp and ceremony as that of a martyr. Soon after, an advertisement appeared in a Canada paper, offering a reward for the discovery of the body of Timothy Monroe, who was drowned at Newark in the Niagara River 5 or 6 weeks previous to the discovery of the body. From a minute description of the clothes, cravat, tracks, body, etc., it was perceived at once that they corresponded with those of the body which had been declared to be that of William Morgan. The body was once more disinterred, another inquest held, and now it was discovered for the first time that the body did not so closely resemble that of Morgan as had been stated. The teeth, for example, were not double all around in front, as were those of Morgan, and 5 had been extracted from this body, whereas Morgan had lost but 2. This jury, therefore, which sat on the 29th of October, 14 days after the last, declared the body to be that of Timothy Monroe of Upper Canada. Here you find 3 inquests, 36 men, all after due deliberation and strict examination, called under oath to view the same body, each inquest reporting the body to be that of a different person. And I ask you whether you ever saw or heard of a case in which a more minute and accurate description of a body was given, either of the dead or the living, than was given by the witnesses who testified to the bodies of Monroe and Morgan. It will not be pretended that the witnesses who testified to the body of F.A. Muir made any effort to ascertain whether they might not have been mistaken. One would suppose, when looking at the particularity and caution used in Monroe and Morgan cases, and that used in the case before us, that here there is not such an examination as would enable you to come to any other conclusion than that the examination was so slight that the witnesses seemed not to view it with an eye to its identity. In the cases read to you, it is seen that the witnesses were such as ought to know the bodies to which they were deposing. The wife, the family physician, the dentist, are certainly well acquainted with the individual when alive, equally as much so, at least, as those who have deposed to the body of Mr. Muir could have been with him whilst he was alive, and yet with the great intimacy of the wife, she preferred to rely on physical marks on the body, which he named, and so of the dentist, who would not be satisfied until he had inserted the teeth into the places from which he supposed he had drawn them, whilst Morgan was alive. But with all the caution used, they were mistaken, and what is still more remarkable, this mistake was made over a body which had been dead only 6 weeks, but was settled to be the body of Monroe, who had been dead but that length of time, whilst the body said to be Mr. Muir's had been dead 5 months and 13 days. No man can read the cases to which I have referred you without seeing the necessity of strict examinations upon all such occasions, and wherever they have not been made, doubts must remain, and it is not expected that a jury will supply anything which it was the duty of the Commonwealth to furnish. End of section 49. Section 50 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of William Dandridge Epes for the murder of Francis Adolphus Muir. Petersburg, Virginia, 1848, Part 5. I have thus far, gentlemen, attempted to show you the great difficulty of identifying a dead body after putrefaction has taken place. In connection with this part of argument, and further to elucidate the position that mistakes often occur in matters of identity, allow me to call your attention to one or two cases where living persons have been mistaken for others whom they resembled. Guy's Medical Jurisprudence, page 22. The following case is reported in the year 1772. One Mall, a barber's apprentice, was tried at the Old Bailey for robbing a Mrs. Ryan of Portland Street. The witnesses swore positively to the identity of the lad, and the whole court imagined him guilty. He said nothing in his defense, but that he was innocent, and that he could prove it. His evidence were the books of the court, to which reference being made, it appeared that on the day and hour when the robbery was sworn to have been committed, the lad was on his trial at the bar, where he then stood for another robbery, in which he was likewise unfortunate enough to be mistaken for the person who committed it. Here it is seen in open day before the court, and in the gaze of the crowd, a lad is positively identified, and no doubt is entertained until the records of their own court proved conclusively that it was impossible for the boy to have committed the robbery, because he was at that very time on trial before the same tribunal for a different offense. How much better the chance in this case to identify than if the youth had been dead and buried 5 months and 13 days. I will now read you the case of James Crow, alias Thomas Gedderly, who was executed at York for a burglary in the year 1727. Thomas Gedderly lived as a waiter with Mrs. Hannah Williams, who kept a public house at York. It being a house of much business, and the mistress very assiduous therein, she was deemed in wealthy circumstances. One morning her scrutoire was found broken open and robbed. About a 12th after, a man calling himself James Crow came to York and worked a few days for a precarious subsistence in carrying goods as a porter. By this time he had been seen by many, who accosted him as Thomas Gedderly. He declared he did not know them, and his name was James Crow, and that he never was at York before. This was held as merely a trick to save himself from the consequences of the robbery committed in the house of Mrs. Williams when he lived with her as a waiter. His mistress was sent for, and in the midst of many people, instantly singled him out, called him by his name, Thomas Gedderly, and charged him with his unfaithfulness and ingratitude in robbing her. He was directly hurried before a justice of the peace, but on his examination absolutely affirmed that he was not Thomas Gedderly, that he knew no such person, that he never was at York before, and that his name was James Crow. Not, however, giving a good account of himself, but rather admitting himself to be a vagabond and petty rogue, and Mrs. Williams and others swearing positively to his person, he was committed to York Castle for trial at the next assizes. On arraignment, he pleaded not guilty, still denying that he was the person he was taken for, but Mrs. Williams and some others swearing that he was the identical Thomas Gedderly, who lived with her when she was robbed, and who went off immediately on the commitment of the robbery, and a servant girl deposing that she saw him that very morning in the room where the scrutoire was broken open, with a poker in his hand, and the prisoner being unable to prove an alibi, he was found guilty of the robbery. He was soon after executed, but persisted to his latest breath that he was not Thomas Geddeley, and that his name was James Crow. And so it proved. But some time after, the true Thomas Geddeley, who on robbing his mistress had fled from York to Ireland, was taken up in Dublin for a crime of the same stamp, and there condemned and executed. Between his conviction and execution, and again at the fatal tree, he confessed himself to be the very Thomas Geddeley who had committed the robbery at York, for which the unfortunate James Crow had been executed. We must add that a gentleman, an inhabitant of York, happening to be in Dublin at the time of Geddeley's trial and execution, and who knew him when he lived with Mrs. Williams, declared that the resemblance between the two men was so exceedingly great that it was next to impossible for the nicest eye to have distinguished their persons asunder. Phillips, page 76. No one doubts that Mrs. Williams and those who swore to the person of Crow, for a moment, believed it was possible for them to be mistaken. Surely they would have much sooner expected a mistake if they had been swearing to the body of James Crow after it was dead as that of Thomas Geddeley, because it resembled him when alive. Then they would that the mistake should have occurred when both were alive, and yet they were mistaken, and innocent blood was shed. Another warning to us to guard against the errors into which men too frequently fall. But, gentlemen, did you not observe the living example on this subject introduced by the Commonwealth through one of her witnesses, Mr. Bailey, who told you that on the 9th of February, 1846, he found a horse in his field, supposed to be the one which the deceased rode, so much like one which his neighbor and friend Mr. Bevel owned, that he actually, under the belief that it was his horse, sent it to him, and yet he was mistaken, for it turned out to be the horse of Mr. Boisseau. And now, these very gentlemen who introduced this witness, who has himself practically exemplified the great doubts of questions of identity, sustaining the author from whose works I have read, and endorsing the experience of every man who has paid any attention to this subject, will tell you, whilst you might honestly be mistaken in identifying a live horse, yet other witnesses of theirs could not be mistaken in identifying the dead body of a human being that had not breathed the birth of life in 5 months and a half. Surely, out of their own mouths are they condemned. But why should I longer detain you by reference to examples within our day and generation? Follow me, I pray you, into that great and good book, where God, in the plenitude and fullness of his mercy and glory, has shown man what he is, and how frail his judgment is of the things of this earth. You all recollect, no doubt, the history of Joseph and his brethren who sold him into Egypt, unto Potiphar, an officer of Pharaoh's guard, where he interpreted the dream of Pharaoh, saying, there should be 7 years of plenty and 7 years of famine. And behold, when the 7 years of famine arrived, Jacob sent his sons, Joseph's brethren, into Egypt to buy corn. And Joseph was the governor over the land, and he it was that sold to all the people of the land. And Joseph's brethren came, and bowed down themselves before him with their faces to the earth. And Joseph knew his brethren, but they knew not him. Joseph conversed with his brethren. They engaged in the conversation. He told them they were spies, but they denied it, saying, we are true men. We are all one man's sons. He cast them into prison for 3 days, and on the 3rd day the fear of God came upon him, and he discharged them, save one, whom he kept as a pledge. Here, gentlemen, is the richest record of the liability of man to err. Upon this point, so necessary to be established, before you can find a verdict of guilty. 10 brothers buying corn from one who had been raised with them, conversing with him of their father, of their youngest brother. 3 days are they kept by him, and yet not one of them knew him. Not only in that instance did they fail to recognize him, but on the second visit they were equally ignorant that they were buying corn of their brother. How, I ask, how will you let these teachings of the Holy Bible, the book of our faith, the ark of our safety, pass by without warning you to take heed of what God has laid before you as a lamp to light your way whilst sojourning here below? It cannot be contended that Joseph's brethren were not thinking of him, and therefore he was not recognized by them, for it is expressly stated whilst in prison. They said one to another, "We are verily guilty concerning our brother, and that we saw the anguish of his soul when he besought us, and we would not hear. Therefore this distress came upon us." And Reuben answered them, saying, "Spake I not unto you, saying, Do not sin against the child? And ye would not hear. Therefore, behold, also his blood is required." Now, gentlemen, this conversation amongst the 10 brothers took place in the presence of Joseph, who turned himself about from them and wept. And I ask you whether this holy record does not merit the deepest reflection, whether it does not carry proof twofold to be resisted, whether the Commonwealth is not too weak upon this point to take life. Again, where do we find doubting Thomas when he was called upon to believe that Christ had risen from the dead? Was he satisfied by viewing his body and judging of it from its resemblance in life? No, no, gentlemen. He says, "Except I shall see in his hands the print of the nails, and put my fingers into the print of the nails, and thrust my hands into his side, I will not believe." Was Thomas reproved by Christ for wishing to have some proof other than that of mere resemblance, by which he could identify this body? Far, far from it. For beholding him crying to Thomas, "Reach hither thy finger, and behold my hands, and reach hither thy hand, and thrust it into my side, and be not faithless, but believing." What higher authority can be offered than this? The Savior of man, who not only believed it necessary to have marks of identity, but actually exhibited those marks, that one of his apostles might believe and no longer doubt. And shall fallible, feeble, erring men, after this example, feel himself above calling for such proof as will satisfy him fully that this was the body of Muir? I hope, gentlemen, you will excuse me for marching on this holy ground. It is the duty of man, when he reads the great and good book, to draw from it the knowledge which teaches him not only how to act upon this earth towards his fellow man, but to prepare his soul so to appear before his Maker, as to receive the happy plaudits of, "Well done, thou good and faithful servant, enter thou into the kingdom of thy Lord." But suppose in the view I have taken of this subject I am mistaken, and there should be no doubt left upon your minds as to the body found being that of Mr. F.A. Muir. The great and important question that arises, is the proof sufficient to remove from your minds every doubt as to the guilt of the prisoner? Or in other words, is the evidence such as to warrant a conviction? I know that the mere charge of murder too often carries with it a weight of prejudice that gives a coloring to all the circumstances, tending almost invariably to strengthen the charge made by the Commonwealth. I shall, however, commence a review of the testimony touching this branch of the defense, under the belief that your minds are free from all bias. It is in proof that a body was found on the 15th of July, on the plantation of the accused, from 1/4 to 1/2 a mile from the house. It is also in proof that a search was made on the farm of the prisoner on the 9th of July. What was the conduct of the prisoner when he was informed that he was suspected of the murder of Adolphus Muir, and permission asked to make the search? Mr. J.A. Muir, the first witness introduced by the Commonwealth, informed you that the prisoner readily consented that the search might be made, and at the suggestion of Dr. Edwards, accompanied the party to the campground, where 300 or 400 of the citizens had assembled, and readily went with them over the farm, giving them every facility in making the search, And when near night they went to the house to search in and around the premises, he at once gave them up the key of his ice house, and desired that they should search that. Nor was this all. When he was called upon to exhibit the bond which he had paid off to F.A. Muir, he at once handed it over for the inspection of the crowd. You will recollect that the prosecutor for the Commonwealth in the whole of his argument did not once allude to the conduct of the accused on this occasion, for the very obvious reason that it was nothing more nor less than that of an innocent man, and as plain, practical farmers, as men of common sense, I ask whether a guilty man would have acted the part of the prisoner under such circumstances. Suppose on your return home you were to find that a hog or some other piece of your property had been stolen, and you had grounds to suspect that it had been stolen by some of the slaves of a neighbor, and you were to go and inform him of the fact, and at the time intimated that you desired to make a search, and your neighbor were not only to agree that the search should be made, but should actually go with you, and insist upon searching his negro cabins, stacks, and such other places as you might desire. Would it be inferred from such conduct that he was the thief? You know too much of the nature of man to suppose for a moment that this would be the conduct of the guilty, and shall not the prisoner at the bar have as much charity and justice extended to him as is awarded to others who may rest under suspicion? Will you suffer the cry of murder to drive you from your propriety, and reverse the order of reasoning? The worthy prosecutor tauntingly asked where was the bond with the forged receipt on it, that it was not produced before you. And I asked the gentleman, why did he not tell you that the prisoner, so far from having any concealments about the bond, on the day of the search exhibited it to a crowd of 300 or 400 persons, some of whom it was supposed knew the handwriting of F.A. Muir, as well as they did their own? Was there anything said about a forged receipt on that occasion? If so, let the witness be named. That gentleman, as well as yourselves, knows too well the ways of the guilty to believe that he, who had shown a receipt to 300 persons, would be afraid to exhibit it to a jury of 12 men. Take the whole of the conduct of the accused with the witness, Mr. J. A. Muir, and it is consistent with his innocence, with the exception of the 3 letters, and if the prisoner was not the writer of those letters, he cannot be convicted of the murder of Mr. F.A. Muir. To the subject of these letters, I will now call your attention. End of section 50. Section 51 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of William Dandridge Epes for the murder of Francis Adolphus Muir. Petersburg, Virginia, 1848, Part 6. You are aware that the proof of an instrument of writing, like the proof of any other fact, is either direct when the witness sees the writing executed or acknowledged, or it is founded on his belief, from his knowledge of the general character of the handwriting. A witness is not allowed to compare the writing of the individual whose hand is about to be proved with the letter or written instrument which he is called upon to testify to. But whilst the law is thus rigorous in confining the witness to his knowledge of the general character of a particular handwriting, yet it is nothing more than a comparison at last, for whilst the hands do not act in holding the 2 pieces by the side of each other, that they may be viewed together, none will deny that it is at least nothing but an effort of the mind in drawing a standard of the handwriting in the mind's eye. And with that standard thus drawn, he compares that which is before him and about which he testifies. And I need not tell you that there must be a great difficulty in any mind, however capacious it may be, to throw out of view all the other writings which are flitting before it, and single out a particular specimen in the mind, and speak with that certainty as to its similarity to the one before it, as to leave no doubt. It is not pretended that anyone saw the prisoner write the letters, or any one of them, but it is admitted by the witnesses themselves that the letters are in a disguised hand, and to my humble judgment, there is perplexity enough in the mind to cause doubts, even when there is no disguise, much less to pass upon 3 letters, purporting to have been written by 3 different persons, all different in their appearance. You were told by Mr. Vaughan, Mr. Derby, and others that they believed that they were written by the prisoner, and they gave you their belief and nothing else. Let me call your attention not only to the belief, but to the acts of those who certainly, if they did not know the handwriting of Mr. Epes, must have known the handwriting of F.A. Muir, as well as those gentlemen could have known that of Mr. Epes. You were told by Mr. John A. Muir and Mr. Cousins that they were so fully satisfied that the receipt on the bond and the letter of the 4th of February and that of the 12th of the same month were in the handwriting of F.A. Muir, that on the faith of that belief they released a deed of trust which secured the payment of $3,000, thereby giving the strongest proof that at that time they had no doubts upon their minds as to the writer of the receipt and letter. And I submit it to you, in all candor, to say whether the brother and connections of the deceased were not more likely to know his handwriting than were Mr. Vaughan, Mr. Derby, and others, to know the handwriting of Mr. Epes. Suppose, gentlemen, you had never heard of this murder, and the question were put to you whether the receipt and the 2 letters of the 4th and 12th of February were written by F.A. Muir or by W.D. Epes, and you had to decide by the proof here given. How would you reason upon the matter? You would say, Vaughan and Derby speak as if there was little or no doubt in their minds that Epes wrote the instruments of writing. They only speak of it, however, from their general knowledge, as they would of any other handwriting. On the other hand, J. A. Muir is the brother of F. A. Muir. He has been raised with him, ought not to be mistaken in his handwriting. In addition to that, he never would have given his consent against his own interest and suffered the bond of $3,000 to be settled off if he had not been acting under what he considered an absolute certainty as to the genuineness of his brother's handwriting. Mr. Cousins, too, was trustee to the deed of trust, securing the $3,000, and as a businessman, he never would have consented to release the deed with the shadow of a doubt on his mind. Thus you would weigh them, and I say, if this murder had never been heard of, there's not a member of this jury that would not, under all the circumstances, have decided in favor of the opinions of Mr. J. A. Muir and Mr. Cousins. The question whether this is the handwriting of F. A. Muir or that of Epes should be decided without reference to the murder. It would be folly to say, I believed it to be F. A. Muir's writing until I suspected Epes of the murder, and certainly equally so, to believe Epes wrote the instruments of writing because he is charged with the murder. And yet, strange as it may seem, this handwriting has changed to be Epes since suspicion has fallen on him. Compare on your retirement the entry made by Epes in the Register of Jarrett's, proved and admitted to be made by him, with the letters in question, and if you believe that any individual can say with certainty that the individual who wrote that name in the register also wrote the letter here introduced, so clearly as to leave no doubt on your minds, then I admit a strong link is made in this chain of circumstances. The witness, Mr. Lumsden, told you that on the 21st of May, 1846, he traded with the prisoner for a gold watch which he repaired for F. Adolphus Muir on the 1st of September, 1843. You will recollect that upon the cross-examination the witness stated that he could only identify the watch by the number and name of the maker, and that at the time he traded with the prisoner for it, he examined it minutely, both externally and internally, and that he did not recognize it as the watch which he had repaired in 1843 for F. A. Muir. The whole of Mr. Lumsden's testimony then simply amounts to this, that he believes this watch to be the one which he repaired for F.A. Muir, because it has the same name on it as the maker, and the same number, which he finds entered in his book in 1843. Now I assert that Mr. Lumsden's knowledge of the identity of that watch is derived from an entry in his books, and not from anything that he relies on from looking at the watch. For if there had been no entry in his book, you would never have heard a word from him about its being Muir's watch. As proof of this, he traded for it, he says, and carefully examined it, having at the time that same entry in his book, and yet he did not for a moment suppose that he was trading for a watch, which he had previously repaired for Mr. Muir. And how could he know it, either then or at this time? When he tells you that it was the only watch which he had ever seen with the name Harrison on it as the maker, thereby showing that he knew nothing of the writing or engraving of Harrison, and any man might put the name of Harrison on a watch, and by Mr. Lumsden's own showing, he would not be able to tell whether Harrison was the maker, or whether his name was put there by another. Is it necessary for me to tell you that nothing is more common than making spurious articles with good brands? Let us, however, go to Mr. Lumsden's book. Was it impossible for him to make a mistake in his entry? The change of a single figure would alter radically the number, and are not mistakes of this character frequently made? Have you not, in writing or received a letter, often dated it wrong, not only as to the day, but the month and sometimes even the year? I will now test this method of identifying a watch. I hold in my hand my watch, which Mr. Lumsden repaired on the 5th of last April. He now sits before me, and he cannot tell my watch from another of the same pattern, nor he can, for his life, tell you the name of the maker nor the number of the watch. And yet if you let him go to Petersburg and examine an entry made by himself or his clerk, he could come and identify my watch at once. Yes, swear positively to it. How do we identify an object? By looking over our books for entries, or by an effort of the mind and action of the eye. You never could identify an object until you could see it, and the inspection of 1,000 entries would leave one where he started. Mr. Lumsden had the opportunity, when he traded for it and gave it the close examination of which he spoke, to know the watch, and fails, as he admits himself, to recognize it as the watch of F.A. Muir. Another strong reason why the watch traded for with Epes is not the watch which was repaired for F.A. Muir, is that Muir's watch was worth $130 to $150. That is the proof. Whilst the watch which Mr. Lumsden traded with the prisoner for, he only valued at $40 to $50, and allowed him that much in the trade for it. The prosecution for the Commonwealth informed you that the watch was found in the possession of the prisoner, that the prisoner was an intelligent, well-educated man. You have heard Mr. Lumsden's statement, and you can judge of the weight of his testimony, and decide whether the prisoner ever had the watch in his possession, which is now before the court. Mr. Lumsden does not pretend to identify it, only from circumstances, and whilst I say for him what I know him to be justly entitled to, that of being a gentleman of the strictest veracity, one whom I would as soon believe as any man in Virginia, yet I will not suffer him, nor should you, to draw conclusions for you. It is your province to scrutinize closely what he has said, and draw your own deductions. I must confess, I was somewhat surprised after hearing Mr. May speak of the prisoner as a man of education and intelligence, to hear him allude to the evidence of Mr. Lumsden to prove that this very intelligent man, Epes, should kill a man, rob him of his watch, carry it to a town within 20 miles of his residence, trade it off to a public watchmaker, and that, too, within 2 months and 20 days after the murder had been committed. Now I put it to you, if he is the man of intelligence which Mr. May describes him to be, and I think his description correct. Whether this fact of itself does not clearly show that nobody but a fool would have offered the watch within the time, and under the circumstances, and to the person to whom it is alleged he offered it. No, gentlemen, Mr. May has told you that his intellect was of such an order as to forbid the commission of an act so full of folly. It is only necessary for me to call your attention to one other point in the argument of the prosecutor for the Commonwealth in relation to the watch, to show you what little value he places on it as a circumstance worthy of your consideration in making up your verdict. He told you that it was known that the prisoner had traded off the watch in Petersburg before he ran off, and that he and his associate were consulted as to the propriety of arresting him from the existence of that fact. And what did he say was the advice given? Why, they advised against arresting him, and yet in the face of that admission made before you all, in the same speech, and before he takes his seat, he tells you that this very fact, that he traded the watch with Lumsden, should leave no doubt on your minds that he murdered Muir. Strange logic, this. That which was not strong enough to arrest a man on is now the very strongest reason why he should be convicted. The bare statement of the gentleman's admission so effectually overthrows his present position on this point that nothing further remains to be said by me. Your attention was next called to the flight of the prisoner from the state of Virginia to Texas, anticipating, I have no doubt, that your good sense would at once account for that circumstance by the unheard-of course adopted on that occasion. He thought proper, whilst he was referring to the transaction again, as in relation to the watch, to destroy whatever force he intended his argument should have, by accounting for the flight himself at the time he alluded to it, by telling you that it might be expected from a timid man under the circumstances. Yes, gentlemen, with the proof before him that a search had been made by 300 or 400 persons on the farm of the prisoner, and he in company with them all the time, exhibiting nothing like a disposition to flee. He tells you that others might have fled, and their timidity would have been their justification. And yet this exhibition of popular excitement, which he admits would have made the innocent flee, provided there was timidity, you are called upon to note as evidence of the prisoner's guilt. Does the gentleman expect you to close your eyes to such facts as he admits would not in others be construed into guilt, and make an example of the prisoner to satisfy the cormorant appetite of the Commonwealth? No effort of counsel can drive you from the correct conclusion on this point. Put the case to yourselves. You find the press publishing letters insinuating they are forgeries, that a murder has been committed, that you had perpetrated both the murder and the forgery. Further, the indignation of the citizens of your county arose to such a state of excitement that they assembled in masses at your house to the number of 300 or 400, and openly charged you with the murder. Could you breast such a stream of popular anger and indignation? I think not. And if you did, I venture no man, other than a Commonwealth prosecutor, would ever think of alluding to it as evidence of criminality. But you find that the prisoner did not even then leave, but it was only after the company had left, and the storm of public wrath continued to increase in strength and fury, plainly indicating that violence would be ultimately resorted to, that he was forced to leave his home and friends, and take refuge in a land of strangers, fondly hoping that the excitement might moderate or die away. But no sooner was it known that he had left his home, than rumor with her 1,000 tongues commenced the work of destruction, slander, and falsehood. Every newspaper in the largest city, the smallest village, was teeming with the charge of murdering Adolphus Muir. Each seemed to vie with the other in adding to the first charge the most atrocious crimes, from the murdering of the hog drover to that of his mother-in-law, and finally to that of his own son. These charges in the public press were daily seen by him, and I ask you, what more could be wanting to expel the most virtuous from our land. Mr. May told you that the timid might have fled under such circumstances, although innocent, and I tell you that public opinion, when highly excited, whether true or false, if brought to bear upon a single individual, is more terrible than a whip of scorpions, and the innocent as well as the guilty will wither before it, and be blown as chaff before the wind. We come now, gentlemen, to the confession said to be made to Mr. Benjamin J. Vaughn. You were informed by the witness that he left Virginia in search of the prisoner, and that he found him in Texas, in a small town called Nashville. That after he had arrested him and whilst on his way home, the prisoner commenced a conversation about the murder of Muir, by saying that he had read the statements in the newspapers, giving the different accounts of the murder of Muir, and that he had been charged in the publications alluded to with having killed Hog Driver, his mother-in-law, and his own son. That Muir's case was bad enough. The witness further informed you that he asked the prisoner some questions with a view of obtaining a confession from him. The first was whether he, Epes, was with the party who made the search on his plantation, and he stated that he was. The witness then asked how near they went to the grave. Vaughn then said to him the grave must have been well concealed, to which Epes replied that it was, that it had the appearance of an old hog bed, with trash and a few brush thrown over it. He further stated that he had not paid the bond. This is the substance of the statement made by Mr. Vaughn. You all recollect the great notoriety which had been given to this case, and the many circumstances which it was said connected the prisoner with the murder of Muir. Compare these with the confession which Mr. Vaughn has told you was made to him by the accused, a confession which, if interpreted in the light and under the circumstances under which the conversation is said to have taken place, does not carry sufficient weight with it to create suspicion, much less to justify a verdict of guilty. Can you believe that a gentleman of Mr. Vaughn's intelligence, if his object had been to have obtained from the prisoner a full and fair history of the death of Mr. Muir, would have come from Texas to Virginia with a mere paragraph statement, not long enough to make a respectable postscript to a lady's letter, as the true revelation of what had been so long the theme of public speculation and inquiry? You all know Mr. Vaughn to be a man of too much sense to have relied on such a vague statement, if he could have obtained a better. This conversation is construed by the Commonwealth into a confession, when I think I will convince you that it was nothing more than a repetition of the statements which Epes told Vaughn he had seen published in the different newspapers. Mark the manner in which the conversation commenced. Epes said he had seen the different statements in the paper, and named among them that he had been charged with having killed the hog drover, his mother-in-law, and even that he had been charged with having killed his own son, and closed by saying that Muir's case was bad enough. It is for you to decide upon the proper construction to be put upon this language, as the witness and the prisoner totally differ as to the ideas intended to be conveyed. Such a rule of construction should be applied as to reflect the meaning Mr. Epes intended his remarks should convey. Let us analyze the expressions used. Epes says, I see I am charged with murdering Muir. I also see I am charged with murdering a hog drover. I further see I am charged with murdering my mother-in-law. And lastly, I see I am charged with murdering my own son. Muir's case is bad enough. Now, gentlemen, what is the legitimate deduction to be drawn from these remarks? Evidently, that Mr. Epes, so far from having confessed the killing of Muir, only said it is bad enough to charge me with killing Muir, without adding thereby the crime of murdering 3 other persons, one of whom was my own son. These charges had been all made in the public press of the country. Suppose Epes had closed his remarks by saying he had seen all the charges that had been made, and that his mother-in-law's case was bad enough. Would anybody have inferred that he thereby acknowledged that he had killed his mother-in-law? Surely not. but would have inferred that he was only referring to the charges, and that it was bad enough to charge him with murdering his mother-in-law, without the additional charge of the inhuman crime of having killed his own son. If he had intended in the conversation to have confessed that he had murdered Muir, what more easy than to have said, "It is true, I killed Muir. That's bad enough," without charging me with the other 3 crimes. Instead of such a confession, he speaks of the charge of having killed Muir, and connects it with the other 3 charges without speaking of his own agency or action upon any one of them. There is nothing plainer than this being the proper light in which the conversation should be viewed. Is there an individual on that panel or within this house who, if the prisoner had told him that he murdered Muir, would not have asked him where he killed him, how he killed him, whether he was shot once or twice, or put some question as to the details of a murder that had engrossed so much public attention and aroused so much excitement throughout the land? A disposition not to misrepresent or misunderstand would have induced you to have done so, not to speak of the curiosity of man to be informed to the fullest extent into the secret history of this mysterious affair. Mr. Vaughan, however, knowing all the rumors that had been, and that there were at that time in circulation, without knowing whether they were true or false, coolly puts a question to the prisoner, which he knew himself, and which was known by every man and woman in the county of Dinwiddie, and that was whether he, Epes, was with the party that made the search on his, Epes, plantation on the 9th of July, 1846. I do not think that another man in Virginia, of Mr. Vaughan's intelligence, would have put such a question, after such a startling development as he thinks the prisoner intended to make. A question, the answers to which he not only knew himself, but which was known by everybody else. Again, gentlemen, notwithstanding Mr. Epes had told Mr. Vaughan that he had seen all the statements in the newspapers, and with the knowledge of the fact that all the particulars of the search, the finding of the body and the place and manner of its interment, had been published, it was another question to the accused, which he was enabled to answer from the fact that he had taken part in the search and the publications that he had seen. This is the question. How near did the party during the search go to the grave? Epes answers by saying they were at one time within 3 or 4 feet of it. Does this answer show that Mr. Epes knew where the grave was on the day on which the search was made? You will bear in mind that the facts in relation to finding the grave and finding the body had all been published, and that Mr. Epes had told Mr. Vaughan that he had seen all the statements. One of the statements was, and the true one, that a grave with a dead body in it had been found in an old field, a quarter or half a mile from the house, under a cherry tree on the prisoner's land. Now, Mr. Epes, though 4,000 or 5,000 miles from home, could, without knowing on the day of the search whether the grave was under the tree or not, tell how near they went to it, for it was only necessary for him to know on what part of the plantation the cherry tree stood. Knowing this fact, seeing from the publications that the grave was under that particular tree, and being with the party when they walked by the tree, he could tell how near they went to the tree, and consequently how near they went to the grave. Suppose, gentlemen, 10 days ago a search had been made on one of your plantations for something that had been stolen, and that you assisted in making the search, that you had failed finding the object sought for. Today, however, you are informed that it was found buried under a walnut tree near the head of your lane, and some friend should ask you how near the party went to the place at which it was found. Why, you would at once say, well, if it was buried under a walnut tree near the head of the lane, we must have gone within 2 or 3 feet of it, for we went right under the tree, and yet you might not have known that the article was there, any more than Epes knew the grave was under the cherry tree on the day of the search. The information in both cases of the approach to the object is derived from the knowledge of the particular location of the tree. But there is another view of this subject that will overthrow at once all belief that Epes could have known that the grave was under the tree on the day of the search. And this is the improbability that Epes or any other man would have gone with a party of gentlemen, highly excited, and who had openly charged him with the murder of a man for whose body they were then in search. Would he not have taken some method to decoy them off, or at least have placed himself in a situation where he might have escaped in the event of the body being discovered, when he must have known that death would have been his portion had the body been found? It is not in the nature of the guilty, nor has God given man the nerve, when conscious of his own guilt, to play such a part, and nobody but one devoid of sense, or an innocent man, would dare expose himself to such an unnecessary peril. And as he has been endorsed by the prosecutor of the Commonwealth as a man of intellect, we should infer that his conduct on that occasion was more compatible with innocence than with guilt. The description of the grave which the prisoner says was given by the prisoner, like the other portions of this novel confession, is nothing more than a mere repetition of the rumors which Mr. Vaughan had heard from others, and which Epes had seen published. It will not be expected, I presume, for me to enter into an argument to explain the remark by the prisoner in relation to his not having paid the bond, when it is recollected by you that on the day of the search, when Mr. Epes was informed that counsel had been consulted, and that an opinion had been given that he would have to pay the money again, he at once stated to John A. Muir and P. Boisseau that he would do so. If there had been criminality in that remark, would it not have detected the receipt on the bond as a forgery and led to his immediate arrest? I hope I have satisfied you that Mr. Vaughan was entirely mistaken in the construction which it seems he placed on the conversation with the prisoner, which he is pleased to call a confession. You will recollect that it is not a question of veracity, whether such a conversation took place or not, but whether the construction put upon it by Mr. Vaughan was the correct one or not. No man who knows Mr. Vaughan will question his veracity, but it is your peculiar province to scan well that conversation, that injustice may not be done the prisoner. The strongest proof that Mr. Vaughan did not put the proper construction on that conversation is derived from the fact that today is the 5th day since the commencement of this trial, and witnesses have been examined from the entire surrounding country, and not a single fact has been elicited going to show that the prisoner at the bar ever made a confession to any other human being on earth than to Mr. Vaughan. What then could have been his motive for making a confession to him? Does anyone believe that the prisoner would dare expect the witness to keep it a secret? The intelligence which all award to him forbids the idea that he was ignorant of the certainty of forfeiting his life, should it be introduced on his trial as evidence. Further, he knew Mr. Vaughan had pursued him for the purpose of having him brought to trial for the supposed murder of F.A. Muir. Then what motive could have induced him to make a confession to one who at that time occupied a situation of deadly hostility towards him? Was it a reckless disregard of consequences that caused him to make the confession? If so, then the same feelings would have caused him to make confessions to others. Not so, however. Mr. Vaughan, his hot pursuer, is the only living being who can be found that ever heard the least whisper of a confession. I am addressing men of experience, men who well know that the most angry controversies and deadly conflicts too often arise from wrong constructions put upon hotel and steamboat conversations. Does not the worthy prosecutor know that our most eminent statesmen are often drawn into difficulties by misrepresentations of remarks made when traveling in company with others? There is nothing more dangerous to the peace of society, nothing better calculated to lead to mortal combat, and to force into a man's mouth or out of it what he did not intend to utter. Conscious of this, why does he ask you to give a different meaning to the remarks of the prisoner? than was ever intended by him that they should have. Reflect upon the situation of the prisoner. He sees before him a witness repeating a conversation which took place as a confession. He denies that it was a confession, but he cannot be heard. He must be silent and hear himself misrepresented. The strictest vigilance should be given to the conduct of the individual obtaining the confession, whether there was any undue influence used in obtaining it. How well does Chief Justice Foster describe this type of evidence when he says, see Phillips on evidence, page 86. Hasty confessions, he says, made to persons having no authority to examine, are the weakest and most suspicious of all evidence. Proof may be too easily procured. Words are often misreported, whether through ignorance, inattention, or malice, it mattereth not to the defendant. He is equally affected in either case. They are extremely liable to misconstruction, and withal this evidence is not, in the ordinary course of things, to be disproved by that sort of negative evidence by which the proof of plain facts may be, and often is, confronted. This is the opinion of a judge who had, from experience, seen too much oppression and injustice from such hasty and unguarded conversations being construed into confessions. And his opinion have been, and will be respected so long as truth and light is sought, but particularly when one party, from his situation, is bound to be silent, and is unable from the testimony to prove a negative. And whilst the Commonwealth relies on it as the strongest testimony, I think you will concur with me that it is the weakest. I might here close my remarks, but I feel it my duty at the expense of trespassing on the patience of his honor and yourselves to again call your attention to the fact that the whole of the evidence is circumstantial, and to say to you that every link in the chain of circumstances must be clearly and fully connected before you can bring in a verdict of guilty, and that if there be any doubt upon your minds of any fact necessary to the conviction of the accused, he is entitled to the benefit of that doubt. How often have the innocent been punished upon circumstantial evidence infinitely stronger than that against the prisoner at the bar? The cases I have quoted to you too plainly show. It is not necessary for me to make a single remark upon those cases, other than to tell you that they speak in eloquent terms of the sad consequences which too often result from convictions upon circumstantial evidence. How awful must be the survivors of that jury have felt when they saw the death, the infamy and disgrace that their reliance on circumstances had produced. But the workings of Providence are mysterious, and it is the duty of man to profit by errors of his fellow man, and to take heed that he be not led off into the errors of those who have gone before him. I have now, gentlemen, closed my defense, and I hope and trust in God that I have performed my part with an honesty of purpose. At least I feel an abiding confidence that whatever may be the result of your deliberations, I shall have nothing to reproach myself with. My humble efforts can do the prisoner no good without your aid. You stand between him and the grave. In your hands is placed the thread of life. Ponder, I pray you, deeply upon the consequences that must follow a verdict of guilty. Recollect the awful responsibility that rests upon you all, and be sure that when you shall be called to judgment before high heaven, you can say with a clear conscience that what I have done was the honest conviction of a heart seeking alone to do right. Do this, and the Commonwealth will be satisfied. Do this, and thus a poor, miserable being will be content to abide by your decision. Then in your hands I leave him, and in turning him over to your justice and mercy, permit me to return you my thanks for the undivided attention which you have given me, and what I have had to say. Not mine alone, but the thanks and the blessing of an interesting family will be showered upon you for the cool, dispassionate, and impartial investigation which will give to the trial of one so near and so dear to them. Now look, I pray you, on the prisoner. See that pitiable, perishing wreck of nature. Are his thanks worthy to be received? A miserable outcast though he be, yet he lives, and though almost overwhelmed by the billows of popular indignation, that God who tempers the wind to the shorn lamb, now in the hour of his trouble and discontent, may be pouring balm into his broken heart, crying as to Peter of old, Be of good cheer, be not afraid, it is I. This and this alone is his hope in another world, and you will ever have his thanks for extending to him that justice, blended with mercy, which is the glory and beauty of the inestimable right of trial by jury. End of section 51. Section 52 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of William Dandridge Epes for the murder of Francis Adolphus Muir. Petersburg, Virginia, 1848, Part 7. Mr. Joines for the prisoner. Mr. Joines, my colleague, who opened the defense, has pointed out to you the intrinsic difficulties which belong in every case to some of the questions which you are now to decide. He has shown you how difficult it is in many cases to identify the dead even recently after death, how much that difficulty increases with the lapse of time and the progress of decay, and how often men are mistaken even as to the living. He has shown you how difficult it is to identify handwriting, especially when disguised, and how much this difficulty is augmented in this case by the great dissimilarity of the three letters attributed to the prisoner, and has illustrated with great force the doubts that must hang over our most confident opinions on all such subjects. I might enforce the same views still further, but it is not necessary, and only calling upon you to bear them in mind, I proceed at once to present such further views as have occurred to myself. And here at the outset, gentlemen, let me remark that you must not only be satisfied that F.A. Muir is dead, that the prisoner wrote the letters produced here in evidence, that he was found in possession of Muir's watch, that he knew of Muir's death, and trusted to falsehood and stratagem to conceal it, and that he finally fled to Texas. These are the great points upon which the attorney for the Commonwealth has insisted in his argument. But it is not enough that the supposition of the prisoner, having murdered Muir, will explain all the facts in the cause, and account for all his subsequent conduct. The Commonwealth must go further, and satisfy you beyond all doubt that the facts cannot be otherwise explained, that there is no other way in accounting for the prisoner's conduct. This is the great principle by which you are to be guided in this cause, and it is important that you should understand it clearly and fully in the onset. It is not for us to establish the truth of any other supposition that may be suggested, to account for the facts and conduct disclosed by the evidence. It is incumbent upon the Commonwealth, as you have already seen, to show that it is not, and cannot be true, and not only that that particular supposition cannot be true, but that no other possible one can be true, except the supposition of guilt insisted upon by the Commonwealth. It is not enough for counsel to urge that any supposition we suggest is not probable, that it is not as likely to be true as the supposition of guilt, that it would be strange or singular if it were true. It must be made out to a moral certainty that it is not and cannot be true. It is not enough that the appearances are against the prisoner. It is not enough that he seems to be guilty. It is not enough that he is probably guilty. It must be shown that he certainly is so. This is a great bulwark which the law has thrown around the liberty and life of a citizen. The law will take no man's life upon a probability. It is not governed by appearances, by what seems to be so. It proceeds upon facts, fully and clearly made out, and upon nothing less. The Commonwealth must not only satisfy you that the hypothesis of guilt will account fully for all the facts, and that no other hypothesis can account for them, but you must be satisfied of this beyond a doubt upon any one point essential to the prosecution must acquit the prisoner. A doubt is equal to 1,000 witnesses. If it be doubtful whether some other supposition may not be true, if any one man doubts upon this subject, the prisoner cannot be convicted. If any one man doubts upon any one fact, let him rather die in his place than find the prisoner guilty with a doubt upon his mind. Every one of you will remember, gentlemen, that this great rule of law which I have been endeavoring to explain and enforce, as your guide in deciding upon this evidence, more important than any other to be known and understood by you in this cause, was not mentioned or alluded to by the attorney for the Commonwealth. He was content to assume that the prisoner was guilty of murder, and to agree that all the evidence is consistent with that supposition. He did not undertake to show you that no other supposition can be true or consistent with the evidence. His effort in his discussion of the facts and circumstances of the case seemed to be to make a case of apparent guilt, at most, a case of probable guilt, and that, too, by merely showing that the facts are consistent with guilt, forgetting the great rule which forbids you to convict, though all this should be true. This was all that the attorney for the Commonwealth felt himself able to contend for, upon the facts and circumstances in the cause, and it was this consciousness of the intrinsic defects of his evidence that led him, notwithstanding the portentous array of facts of which we have all heard so much, so conclusive, it was supposed, as to shut every avenue of escape for the prisoner, to bring forward another piece of evidence, kept back until the close of his case, that he seemed to consider too powerful for reply, and sufficient of itself to seal the doom of the prisoner. I allude to the evidence of Mr. B.J. Vaughan, which is relied upon as proving a confession by the prisoner of the crime charged upon him. So far from this evidence being entitled to the conclusive weight ascribed to it by Mr. May, I regard it, if I know my own opinion, as the very weakest evidence in the whole cause. A number of well-known writers lay it down that evidence of confessions is the weakest and most suspicious kind of evidence. Thus you perceive how little weight the law, in its wisdom, ascribes to the most direct confession of guilt. Hence it is that a confession alone, however plain and clear it may be, is not sufficient to justify conviction in any case whatsoever. Thus, in the case of the People versus Hennessy, 15 Wind 147, the prisoner was convicted of embezzlement upon the strength of a detailed written statement furnished by himself, and yet the Supreme Court of New York set aside the conviction and awarded a new trial upon the ground that a confession alone, however clear and deliberate, will not authorize a conviction. In another case, a Negro boy was prosecuted for the murder of a child by throwing him into a well. He was seen playing with the child near the well in which the body was found not long before the child was missed. During the search for the child, the prisoner was found hid up a tree. He pretended the child had gone up the road, looked around and called for him, went to bed at night without his supper, and next morning admitted he had seen the child fall into the well, but gave no reason why he neglected to mention it. He afterwards confessed that he had drowned the child by throwing him into the well, and upon the strength of this confession the jury found him guilty. And yet, though here was a train of suspicious circumstances, apparently confirming and corroborating the confession, the Supreme Court of New Jersey awarded a new trial on the ground that the evidence was not sufficient, in law, to justify the conviction. The State versus Aaron 1 Southard, 232. If evidence of a confession is at all times suspicious and entitled to but little consideration, the evidence relied on to prove a confession in this case is entitled to no consideration at all. One had just arrested the prisoner the day before in his distant retreat, where he had remained so long undisturbed, and where he doubtless fancied himself forever out of danger, and was now bringing him back to be tried for his life. Is it probable that he would disclose the fatal secret to this, his worst enemy, in preference to all the world besides? They traveled together from Texas to Petersburg, spent days and nights in company, and yet there was no fuller confession, no subsequent conversation upon the subject. The prisoner has since been in Virginia more than 6 months, and yet there has been no other confession, or anything like a confession to anybody else, nor even to Vaughan himself. How can it be accounted for that the prisoner, while he had already confessed enough to Vaughan, if the Commonwealth be right, to forfeit his life after he had fully and freely admitted his guilt, should have withheld the particulars of his crime, and at all other times and to all other people, and even to Vaughan himself, should have kept his lips forever sealed upon the whole subject? Is it easy to believe? Is it consistent with probability? Is it natural that a sensible man would purposely run his head into the halter by confessing without assignable motive what would take away his life? Remember, too, the situation of the prisoner, just arrested when he had long thought himself secure, in chains and disgrace, with spirits sunk, fear predominant, hope fluttering around, purposes and views momentarily changing, 1,000 plans alternating, a soul tortured with anguish, and difficulties gathering into a multitude. Are the words of such a man at such a time, his words of anguish and despair, to be weighed against him in golden scales? I submit that the language of the prisoner, even if the witness has related his very words, ought to be interpreted with every allowance in his favor, and that if it be possible to put a different construction upon it, it ought not to be construed as a confession of guilt. Moreover, the weight of this evidence depends on the accuracy of Vaughan's recollection. Alter a word, and it may change the sense of the whole. A single mistake of the witness might be fatal to the prisoner. And here I call your attention to the fact that after the witness had finished his statement of the conversation with the prisoner, and said, in reply to a distinct question, that he recollected nothing more, reflection and further interrogation fished up from his memory another part of the same conversation, not previously remembered. How much more may still have been forgotten? How many words or forms of expression may not the witness have mistaken, after the lapse of 7 months, and with a memory thus palpably treacherous? Remember, too, that the guilt of the prisoner was, in the mind of this witness, a foregone conclusion, so that he would be naturally inclined, without meaning to do wrong, to construe anything that might fall from the prisoner as confirming that opinion, though not so intended by the prisoner. And the very process of reflecting upon the subject in such a state of mind would be apt to give to the language of the prisoner and the recollection of the witness the form most in accordance with this preconceived opinion, the form most agreeable to the meaning ascribed to it, or rather to fix in the memory of the witness the idea attributed to the prisoner, instead of the language in which it was expressed. What, then, is the evidence? The prisoner, speaking about the charges that had been made against him in the newspapers, and which he said were not true, added, "This case is bad enough." He had been charged with the murder of his mother-in-law and his own son, and his plain meaning was that this charge, upon which he had been arrested and was about to be tried, was bad enough. It was bad enough to be charged with the murder of Muir, who was not of his own blood. If case had been charged, or if the word had been left out altogether, the expression would have amounted to nothing. Or the prisoner may have intended to say that his conduct in this case had been bad enough, without meaning to charge himself with the guilt of murder. And if all or half of what we have been told be true, there was ample ground for the humiliating admission. He said that some persons on the day of the search in July 1846 were within 3 or 4 feet of the grave. But this remark is not even incompatible with entire innocence, for in the 2 years that had gone by, why might not the prisoner have learned from others the precise locality of the grave? But without insisting upon that view, I will show you hereafter, when it will fall in more properly with the line of my argument, how this remark, as well as that about his covering the grave, so as to conceal it, are plainly consistent with the prisoner's entire innocence of the crime charged upon him in this indictment. The prisoner further said, if the grave had then been discovered, he supposed he would have had to give up. Not to give up that he was guilty of the murder, but to give himself up into custody, or perhaps to give himself up to the angry multitude to be destroyed on the spot. Passing by for the present this alleged confession of the prisoner, I come to the other evidence in the cause. It is all circumstantial. No human eye has seen the prisoner raise his hand against the deceased. Everything depends on inferences to be drawn from a multitude of circumstances. And here I must remind you again, that is not even enough that the prisoner's guilt should be a fair, natural, and probable inference from the facts, but it must be the only one that the facts do not contradict. It must be the only one that can be consistent with or account for the facts. The impression on your minds must be, in the language already read to you, not that the prisoner is probably guilty, but that he really and absolutely is so. It must be borne in mind, too, that a train of circumstances often seems to lead directly and clearly to a particular conclusion, when it turns out that the fact is certainly otherwise. This is matter of common experience. We have all of us been thus deceived by appearances that left no doubt on our minds, and when the truth has been discovered, we have been amazed at the result, and unable to comprehend how the appearances and probabilities of the case could be so inconsistent with the truth. Men who seem to be guilty have been hung upon such mistakes, and the bloody record should admonish us not to be misled by the strongest appearances or the most plausible arguments, where the consequences of mistake are so terrible. Cases of this sort that have occurred in practice will best explain and illustrate the true meaning and proper application of the great rule of law to which I have so often referred, that the jury ought not to convict in a case of circumstantial evidence unless the hypothesis of guilt be the only possible hypothesis, in the language of Mr. Starkey, upon which the facts of the case can be accounted for. The cases cited in Starkey on evidence illustrate, in a striking manner, the extreme caution with which an opinion should be made up on mere circumstantial evidence, even when it seems to be plainest, and how the most confident conclusions upon such evidence should be distrusted. And they show, moreover, how often the multitude out of doors, who judge without law and decide without proof, condemn an innocent man to infamy and death. They trust to appearances, they rely on probabilities. They argue, as does the Commonwealth here, that the supposition of the prisoner's guilt is a key to all the facts, and therefore he must be guilty. But such, let me repeat the admonition, is not the rule of the law by which you are sworn to abide. Gentlemen of the jury, divest yourselves of all your impressions. Forget all that you have heard out of doors and ask yourselves the question, if these men were all innocent, may not Epes be innocent likewise? You were asked to condemn a fellow man to die. It is a fearful responsibility. Let every man of you, therefore, look well to the proof, and ask himself again and again, with trembling solicitude, is it not possible that I too may be deceived by appearances of guilt? Is there no other possible hypothesis in which these facts can be accounted for? It is a solemn question which no man can ask himself lightly. And remember at the same time that it is not only the dictate of mercy, but equally a rule of law and a maxim of civil liberty, based on the soundest wisdom and essential to the best rights of the citizen, that it is safer to err on the side of mercy than of justice. Better 99 guilty should escape than that one innocent man should suffer. If I am told that the effect of my argument would be that no man could ever be convicted with positive proof of his guilt, I reply that even if that should be the consequence, it would be far better than that the innocent should be convicted without sufficient evidence. But it does not follow. If I find a man hung upon a tree, it may be murder or suicide. If his hands are tied behind him, it is clearly a case of murder in the first degree. It can be nothing less. Or, as in McCune's case, where the house was surrounded by an armed party in the dead of night, and a man was shot in his bed as he lay sleeping by the side of his wife. That could not have been by accident or in self-defense. In all such cases, the single question is, by whose hands did the deceased come to his death? Not only must it be shown beyond a doubt that Muir came to his death by the hands of the prisoner, and that feloniously, but it must be shown that he came to his death by one or both of the gunshot wounds described in the indictment, and in no other way. It is for that specific offense that the prisoner is tried, and he cannot be hanged for another. If the prisoner inflicted the death blow with a bludgeon or an axe, or destroyed the deceased by poison, he must be acquitted on this indictment. On this main, leading fact, the evidence produced by the Commonwealth is the lamest, weakest, poorest ever heard in a court of justice. A doctor who never saw the body until it had been buried upward of 5 months is brought here to testify to his opinions about the cause of death, opinions which I will undertake to show you are worth nothing, absolutely nothing. If the body had been found with a fracture of the skull, or with the marks of a halter upon the neck, in addition to the gunshot wound, how could you determine the cause of death? It might have been one. It might as well have been the other. Nothing but the most thorough and skillful examination of the whole body could have determined it, even if it could have been determined at all. And the Commonwealth would have taken the precaution to charge a killing in each of these modes, so as to justify a conviction, if the death was produced in either. Now, in this case, there was a large echinosis, a bruise on the right side over the region of the liver. Here was, or might have been, an ample cause of death. It was not examined. Dr. Thompson, having jumped to his conclusion that the gunshot wounds were the only cause of death, did not think it worthy while to investigate the cause or the effect of this exterior injury. Did Dr. T make the necessary examination or possess the necessary information of the actual condition of the body to entitle his opinion to your confidence? The highest medical authorities direct that in every such case, the body shall be opened and every cavity inspected, even where the cause of death is quite obvious. If such a thorough examination of every region and cavity of the body is necessary in every case, how much more clearly so is it where there are several injuries apparent on the body? And the question to be decided is whether this or that was the cause of death. And yet, in just such a case, Dr. Thompson has neglected this indispensable means of solving the question, and has contented himself with a mere external inspection of the body, or rather a part of the body, for he did not even strip the clothing from the whole of it. Many cases might be stated to show the importance of such a thorough examination of the body, and how easy it is to mistake the apparent cause of death for the real one. Mr. Taylor, page 282, states a case in which a man was stabbed by his wife in a quarrel and died in 10 minutes. He received 2 stabs in the right arm and 1 in the region of the stomach. Everybody, even the prisoner herself, believed that the man had died from the wounds, but the medical evidence on the trial showed clearly that death had resulted from the rupture of a large aneurysm, and the woman was acquitted. On page 278, he states another case in which a man attempted suicide by cutting his throat. The wound was 4 inches deep and involved some of the branches of a large artery. 3 weeks afterwards, the man dies, and the medical evidence before the inquest proved that it was the result of an abscess in the brain. Mr. Taylor makes this case the subject of these pertinent remarks. If we suppose that the wound in this case had been inflicted by another on provocation, and that the examination of the body had fallen into the hands of a less careful practitioner, who might have neglected to examine the head, the accused party would have been charged with manslaughter and sent to trial. Here again, the same witness is being examined, and the prisoner's case remaining undefended, the evidence might have appeared sufficient to justify a conviction. A ball will often strike the body and run round under the skin, appearing to penetrate right across the cavity. Thus, in one case, a man appeared to have been shot fairly across the chest and through the lungs, when it was found upon inspection that the ball had run around the lungs without traversing any part of them. Hennon's Military Surgery, page 368. I might multiply such cases, but these are enough for my purpose. They show how apt we are to mistake an apparent cause of death for the real one, how important it is to resort to every possible means of finding out the truth, how dangerous it is to form an opinion without it. What proof have we here that either of the apparent causes of death was the real one? What proof that the gunshot wounds, rather than the other injury, were the cause of death? Had the witness opened and explored the body, he might have ascertained the truth. I have shown you that in no other way could it be done, and yet without this examination, which might so easily have been made, without this evidence so easily had, and so conclusive had it been consulted, you were called upon to adopt one of 2 apparent causes of death as the real one, and to hang the prisoner upon this opinion of the doctor. End of section 52.